Honourable members, the Speaker.
I acknowledge the Ngunnawal and Ngambri peoples who are the traditional custodians of the Canberra area and pay respect to the elders past and present of all Australia's Indigenous peoples. Almighty God, we humbly beseech Thee to vouchsafe Thy blessing upon this Parliament. Direct and prosper our deliberations to the advancement of Thy glory and the true welfare of the people of Australia. Our Father, who art in heaven, hallowed be Thy name. Thy kingdom come, Thy will be done on earth as is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive them that trespass against us. And lead us not into temptation, but deliver us from evil. For Thine is the kingdom, and the power, and the glory, forever and ever. Amen. I have received a message from the Senate informing the House that Senator Blythe has been discharged from the Joint Committee on the Broadcasting of Parliamentary Proceedings, and that Senator Nampa Price has been appointed a member of the committee. Senator Chandler has been discharged from the Joint Standing Committee on the National Disability Insurance Scheme, and that Senator Nampa Price has been appointed a member of the committee. Senator Blythe has also been discharged from the Joint Standing Committee on the Parliamentary Library, and that Senator Nampa Price has also been appointed a member of the committee. I have received advice from the Chief Opposition Whip nominating a change in the membership of the Joint Standing Committee on Foreign Affairs, Defence and Trade. I've also received advice from Mr Hastie resigning from the position on the Parliamentary Joint Committee on Intelligence and Security. I'll give the call to the Assistant Minister.
I ask leave of the House to move a motion to discharge members from certain committees.
Is leave granted? I call the member Flinders. Leave is granted, and I call the Assistant Minister.
I move that Mr Wallace be discharged from the Joint Standing Committee on Foreign Affairs, Defence and Trade, and Mr Hastie be discharged from the Parliamentary Joint Committee on Intelligence and Security.
I'll put the question. Those opinion say aye. Against no. I think the ayes have it. The call to the Chief Government Whip.
Thank you, Speaker. I declare that unless otherwise ordered, Criminal Code Amendment State Sponsors of Terrorism Bill 2025, Education Legislation Amendment Integrity and Other Measures Bill 2025, Home Affairs Legislation Amendment 2025 Measures No. 2 Bill 2025, Defence Amendment Parliamentary Joint Committee on Defence Bill 2025, and Corporations Review Fees Amendment Technical Amendments Bill 2025 stand referred to the Federation Chamber for further consideration at the adjournment of the debate on the motion for the second reading of each bill.
I thank the Chief Government Whip and call the clerk.
Government business. Order of the day number 1. Criminal Code Amendment, State Sponsors of Terrorism Bill 2025. Resumption of debate on second reading.
The question is that this bill be now read a second time, and I give the call to the honourable member for Fisher.
Thank you, Mr Speaker. The ability to list certain organisations as terrorist organisations, as provided for by Division 102 of the Criminal Code, provides the Australian Government with a valuable tool for publicly condemning those organisations, as well as putting the public on notice that certain dealings with those organisations are criminal offences. However, the application of this framework does not currently extend to foreign state entities who engage in terrorist acts targeting Australia. A new framework designed to list state sponsors of terrorism would enable the government to inform the public of the risks posed by foreign state entities that seek to harm Australians or Australian interests and harden the domestic operating environment. The bill would amend the Criminal Code to allow the Commonwealth to list foreign state entities that have engaged in a state terrorist act or otherwise supported or advocated terrorist acts targeted at Australia. The bill would create a new parallel legislative framework that in many respects mirrors the existing framework for the listing of terrorist organisations. The bill would enable the Governor-General to list foreign state entities as state sponsors of terrorism on the advice of the Australian Federal Police Minister, with agreement from the Foreign Affairs Minister. The bill would also create new offences which would criminalise conduct engaged in by these entities, as well as conduct engaged in by persons who would seek to assist or support these activities. It would also provide for appropriate defences, for example, for persons who are required by law to engage with a listed entity or engage with an entity for a legitimate purpose. The bill would also make amendments to various other Commonwealth Acts to apply the law enforcement powers and other policy tools that are available in response to or targeted at the prevention of terrorist acts to the new provisions concerning state-sponsored terrorism. Mr Speaker, the threat of terrorism to Australians both at home and abroad is constantly evolving. No longer the purview of religiously motivated extremist groups, terrorism today takes on many forms, from differing ideologies, political views and faith groups, from those on the political far left to those on the far right, from fundamentalist Islamists to fundamentalist Christians. From individual lone actors to now state-sponsored terrorism, the threat of terrorism in Australia and to Australians abroad is dynamic, it is real and it is significant. The current national terrorism threat level is set at probable, meaning there is greater than a 50% chance of a terrorist attack or attack planning occurring onshore within the next 12 months. This threat level was raised from possible to probable on the 5th of August 2024. The Coalition has called for the listing of the Islamic Revolutionary Guard Corps, the IRGC, as a terrorist organisation for more than 2 years. The Labor government has resisted these calls at every turn, arguing that the current terrorism listing enabling provisions in Division 102 of the Criminal Code do not permit the listing of foreign state entities. The Coalition has consistently offered to support measures to amend the Criminal Code to enable the listing of the IRGC as a listed terrorist organisation. Mr Speaker, on the 26th of August 2025, the Director-General of Security announced that the IRGC has been directly linked to terrorist activity on Australian soil in 2 confirmed incidents in 2024. The firebombing of a kosher restaurant, the Lewis Continental Kitchen in Sydney, on the 20th of October 2024, and the arson attack of the Adass Israel Synagogue in Melbourne on the 6th of December 2024, causing an estimated $45 million in damage and putting at risk the lives of people who were in the building at that time. Mr Speaker, the Director-General, Mr Burgess, advised that the attacks were directed by the IRGC using a covert network of facilitators. There may be further announcements that additional attacks will be attributed to the IRGC on Australian soil. In response, the Australian government expelled the Iranian ambassador, along with 3 Iranian diplomats, and the Australian embassy in Tehran was closed. It is noteworthy that this is the first time an Australian government has expelled an ambassador since the Second World War. This bill does not seek to list the IRGC as a state sponsor of terrorism, but it will provide the legislative machinery for the government to do so. Schedule 1 of the bill would create a new Part 5.3a of the Criminal Code to deal with state sponsors of terrorism and state-sponsored terrorist acts. Specifically, Schedule 1 would insert new Division 110 that would provide relevant definitions for Part 5.3a and its offences, and provides a framework through which a state entity could be prescribed by regulation as a state sponsor of terrorism. New Division 111 would provide for offences connected with state terrorist acts, covering the doing of such an act, as well as steps in support or preparation of such an act. Division 111 would also capture instances where state entities are supporting non-state entities in the commission of terrorist acts, including steps in preparation of these acts. New Division 112 would provide for offences in relation to dealings with a state sponsor of terrorism, including directing the activities of a state sponsor of terrorism, the provision of support and funding, membership, association and recruitment. New Division 113 would provide for offences connected with the financing of a state terrorist act targeted at Australia, including the financing of a person involved in such an act. New Division 114 would provide general provisions relating to the offences, including the application of extended geographical jurisdiction, availability of alternative verdicts, and the requirement for the Attorney-General's consent to be obtained for prosecution. Mr Speaker, Schedule 2 of the bill would amend Part 5.3 of the Criminal Code to provide that Part 5.3 orders available under Divisions 104, that is control orders, Division 105, that is preventative detention orders, and Division 105A, post-sentence orders of the Criminal Code, which are used to respond to terrorism threats, that they are available in respect of state sponsors of terrorism and state terrorist acts in Part 5.3A. Schedule 2 of the bill would also make amendments to the Crimes Act 1914, the Surveillance Devices Act 2004 and the Telecommunications Interception and Access Act to give effect to the extended application of Part 5.3 orders to Part 5.3A. Schedule 3 of the bill would make consequential amendments to a series of Commonwealth legislation to ensure consistency in the treatment of terrorist organisations and terrorist acts under Part 5.3 and state sponsors of terrorism and state terrorist acts in Part 5.3A. Schedule 3 would also make consequential amendments to the Crimes Act, Criminal Code, Surveillance Devices Act, and the Telecommunications Interception Act. Schedule 4 of the bill would make further amendments to Division 80 of the Criminal Code to ensure consistency in the way in which the prohibited terrorist organisation symbols offences operate. Additionally, Schedule 4 would make technical amendments to the operation of sentencing provisions in the Crimes Act. Mr Deputy Speaker, the new offences and the extended application of existing offences would not apply retrospectively, as they would not capture conduct that an individual engaged in before amendments commenced or before a state entity is listed as a state sponsor of terrorism. However, in listing a state entity such as the IRGC, the AFP Minister is able to consider and be satisfied of acts that occurred prior to the commencement of the legislation. That is, it is not only prospective acts that can lead to a listing. The membership offence in Section 112.2 would include a defence where a person proves they took all reasonable steps to cease to be a member of the entity as soon as practicable after they knew the entity was a state sponsor of terrorism. The association offence in Section 112.7 would include defences where the association was with a close family member and related to a matter of family or domestic concern, or takes place in the course of practising a religion in a place used for public religious worship, or the association is only for the purpose of providing humanitarian, legal advice or legal representation in connection with specified matters. These offence-specific defences align with those currently available for the comparable membership and association offences for terrorist organisations. Additionally, new general defences in Division 112 would be available, including where there is engagement with a state sponsor of terrorism which is not connected with terrorism and is otherwise legitimate or unavoidable. Importantly, the defence of mistake of fact remains available for an accused person for many of the offence provisions under Section 9.2 of the Criminal Code. Mr Speaker, requirement to obtain consent from the Foreign Affairs Minister and to brief the Leader of the Opposition prior to listing subsection 110.35 would require that before the Governor-General makes regulations listing a foreign state entity as a state sponsor of terrorism, the AFP Minister must obtain the Foreign Affairs Minister's agreement in writing to the entity being specified as a state sponsor of terrorism and arrange for the Leader of the Opposition in the House of Representatives to be briefed in relation to the proposed regulations. The Attorney-General must also consent to the prosecution. The bill also includes a safeguard that the Attorney-General must consent to commit a person to trial for all new offences and the existing violent extremist material offences. This provides an opportunity for the Attorney-General to consider the appropriateness of the proposed prosecution in all the circumstances of the case. Mr Speaker, at the outset, it should be said that the Coalition supports this bill. It has been a long time coming, too long. Whilst the Coalition supports the bill, the process that this government has undertaken to get to this point is as regrettable as it is noteworthy. The bill has been referred to the PJCIS, the Parliamentary Joint Committee on Intelligence and Security, which held a 2-hour public hearing on the 16th of October 2025. The Attorney-General, when referring the bill to the PJCIS, requested that the PJCIS report back by the 24th of October 2025. The net effect of this request is that in order to complete its report within this extremely truncated period, stakeholders were afforded just 7 clear days in which to consider the bill and provide submissions before the public hearing. As a result, the PJCIS only received submissions from the Attorney-General's Department, the Department of Home Affairs, the Department of Foreign Affairs and Trade, Save the Children and the Australian Council for International Development, and 2 individuals. These were received prior to the public hearing, and then just in the last few days, the committee received additional submissions from Chris Taylor, Dr John Coyne and Justin Bassey from the Australian Strategic Policy Institute. The committee received submissions from the Australian Federal Police, Oz-Iran, Australian Red Cross, Alliance for Journalists for Freedom and a 3rd individual. This government's approach to this bill is emblematic of how it conducts national security policy. Do nothing, delay and obfuscate for as long as possible, and only do the right thing once all other alternatives have been exhausted. The bill has not been, in my view, appropriately scrutinised by the PJCIS and was akin to a box-ticking exercise by the government. This is a concerning trend of this government. I have watched this government seek to ram important national security legislation through the PJCIS, and it must stop. My criticism of the government is not directly aimed at government members of the committee, although regrettably, in my view, government members are not doing enough, at least publicly, to resist the government's utterly unrealistic expectations of workload and timeframes that it sets for the committee. Take, for example, the referral of the current bill to the PJCIS. I spoke earlier about the process. The attorney wrote to the chair of the committee asking for an inquiry into the bill. That letter was dated the 8th of October. She asked for the committee to report back by the 24th of October, just 16 days later. In that time, the committee had to meet to accept the referral and set relevant timeframes for the conduct of the inquiry. Submissions had to be made, a public hearing needed to be conducted, a report needed to be drafted, considered by the chair, then by the committee, and then vetted by security agencies, and then tabled. All of this was supposed to have been done within 16 days. The net effect of this ridiculously truncated period was that submitters had only 7 days to prepare their submission before the public hearing was set down on the 16th of October. Mr Speaker, the PJCIS was once considered the most important committees in this parliament. Its members receive briefings on matters of national security by agencies within our national intelligence community. It has largely acted in a bipartisan manner since its inception, with its members coming from the parties of government, willing to leave their political guns at the door to ensure that the protection of the Australian public is its paramount consideration, as it should be. But the government continues to trash this legacy by virtue of its intent to nobble the ability of the PJCIS to appropriately and fulsomely conduct its vital work. In the last term of Parliament, the PJCIS had such an incredibly heavy workload. At one point, it was conducting, I believe, somewhere in the order of 14 inquiries at one time. That is not sustainable, and it is made all the worse by this government's insistence on setting totally unrealistic deadlines for reports to be tabled in the Parliament. Some submitters have indicated to me that they simply will not and physically cannot provide submissions in the times often set by the government. Well, why does this matter? Because national security matters. Our laws that govern national security and security agencies matter. The lives, rights and liberties of Australians matter. But if this government continues to trash these conventions, we will have ill-considered laws that will have unintended consequences, that cost the lives of Australians and or trash the very principles of our Western liberal democracy. The government's approach to rushing the PJCIS through its work is disrespectful of stakeholders who are often experts in this complicated maze of national security laws and architecture. Those stakeholders want to be heard but often can't. Members of the PJCIS rely heavily on the expertise of these stakeholders when considering the implications of national security legislation that comes before it. It is disrespectful of the committee's incredibly hard-working secretariat and puts them under totally unacceptable pressures and strains. So much for this government's often trumpeted principles of respect at work and the rights to disconnect. It is a simple case of do as I say, not as I do. If every other employer in this country has to abide by these laws, it's about time this government started acting in the same manner. Enough is enough. The government must allow the PJCIS the appropriate opportunity to do its work. The government sat on its hands and did absolutely nothing about progressing a bill which would enable the listing of the IRGC until the Director-General of Security announced publicly that the IRGC had been directing terrorist acts on the Australian mainland. That is despite the opposition calling for such a bill for more than 2 years. And I want to take this opportunity to acknowledge the good work of the former Shadow Attorney-General in calling this out, the member for Barara, Senator Chandler and Senator James Patterson, who they all three have consistently called on this government to do whatever it can to list the IRGC. Then all of a sudden, the government, having been totally and utterly embarrassed by its inaction, wants to put the pedal to the metal. This government has never taken national security seriously, whilst I have served as Deputy Chair of the PJCIS. Mr Speaker, I turn now to the issue of what foreign entities could be listed under this bill. As drafted, the bill may enable the Australian government to list a foreign entity, such as the Israeli Defence Force, or even the Israeli government, if an Australian citizen or permanent resident was killed or seriously injured in Gaza or the West Bank as a result of military actions the IDF may take, for example. Whilst there would be competing diplomatic considerations in so doing, and the Foreign Minister would have to consent to the listing, the theoretical possibility remains that the government or other entity or one or more democratically elected allies of Australia could be listed as a state sponsor of terrorism. Mr Speaker, pursuant to section 110.35 of the bill, in order for a foreign state actor to be listed by the AFP Minister as a state sponsor of terrorism, the Foreign Affairs Minister must agree. It is argued by the government that this two-step process establishes a check and balance on the scheme so that adverse decisions are not made contrary to the national interest. And the Coalition agrees with that. Unfortunately, however, the bill does not provide any legislative guidance to the Foreign Affairs Minister about what factors the Minister should take into consideration in deciding to agree to the listing. The Coalition thinks that this is a misstep on the part of the government, but it will not prevent the Coalition from supporting this important piece of legislation. Mr Speaker, in its public hearing examining the bill on the 16th of October 2025, the PJCIS identified an omission. I'll withdraw that. In its public hearing examining the bill on the 16th of October 2025, submissions were received by the PJCIS which identified an omission in paragraphs 29(1), BAA and BAB of the Intelligence Services Act, which would mean that as drafted, the PJCIS would not have the ability to monitor and review AFP counter-terrorism functions in relation to the new Part 5.3A to the same extent it currently monitors and reviews such functions in relation to Part 5.3. This is an important omission, Mr Speaker, both in terms of keeping the legislative schemes in Part 5.3 and Part 5.3A parallel and keeping them subject to consistent PJC oversight. And I can flag that I will intend to move an amendment in the consideration in detail when this matter comes before the Federation Chamber later on this afternoon. Mr Speaker, in summary, the Coalition supports this very important national security bill. It is long overdue. The federal government's primary responsibility is to keep Australians safe. This bill will assist in that aim. No foreign state entity should think that it can get away with perpetrating acts of terrorism on Australian soil or Australians. Not now, not ever. And I commend the bill to the House.
Before I call the Assistant Minister, just to remind the member and all members, if you're referring to correspondence that may be listed as confidential, that is not appropriate to be used during the debate.
Vision.
In the earlier remarks you made around a letter. Anyway, just remind all members. I call the Assistant Minister.
I move that the debate be adjourned and the resumption of the debate be made in order of the day for a later hour this day.
The question is the debate be adjourned and the resumption of the debate be made in order of the day for a later hour this day. I'll put the question. Those opinions say aye. Against no. I think the ayes have it. Call to the clerk.
Business. Order of the day number 2. Education Legislation Amendment, Integrity and Other Measures Bill, resumption of debate on second reading.
The question is the bill be read a second time. I'll give the call to the member for Barara.
Thank you, Mr Speaker. I rise to speak on the Education Legislation, Integrity and Other Measures Bill 2025. This bill does 4 things. First, it deals with integrity measures in the international education sector. Second, it lifts the caps on Commonwealth-supported places for Indigenous medical students. Third, it gives new powers to TEXA to regulate the delivery of higher education on offshore campuses. And fourth, it introduces powers to compulsorily obtain information and publish information in relation to pricing and service delivery in childcare, along with some other technical amendments. In a sense, this is a bill that bookends the education system. It deals with education in the very early stages of life, in the early childhood education and care sector, and as well in the higher education field. It's arguably quite targeted in that respect. But education is a journey that continues through life. When you make changes to one part of the system, there are always downstream consequences. So when we talk about changes to the early childhood education and care sector, we should also necessarily be talking about the downstream impacts on schools and eventually on vocational and higher education. And when you talk about changes that have downstream impacts across our education system, you're talking about millions of Australian students, from very young children through to adult learners and their families. This is the systemic viewpoint that's necessary for this sort of bill, and it would be remiss of me not to put these changes in a broader context. So I want to take this opportunity to say a few words about the education system more generally, so that there's a proper understanding of this bill in its context. Because one of the most profound shifts in our country in the last 30 years have been the way in which we educate children. There are major demographic changes that have altered the shape of our country. These are grand demographic, cultural and lifestyle shifts which have really only become apparent through multiple censuses and public policy data sets over 20 years or more, and are now reshaping our society. The trends are slow, but they're profound. My approach to these things is shaped by the great Sir Robert Menzies, who was a tremendous believer in the transformative power of education. In 1966, while speaking at the Melbourne University campus, Menzies was heckled by an angry student who wanted him to put more money into education. Menzies shot back, "No government has ever put more money into education than I have. After listening to you," he said, "I can understand what vast amounts we still have to spend." Menzies' own life has been transformed through scholarships and educational opportunities. In fact, so much of his education policy reflects that biography and background. He wanted to give other Australians the same opportunities he'd had. Menzies promoted a liberal education through the universities as a public good that benefited the whole of Australian society. 2 years ago, Michael Wesley told the Robert Menzies Institute about the catalytic role Menzies played in taking a marginalised and in many ways moribund university system in Australia and breathing into it a grand vision and ambition. He spoke about how Menzies' vision for the universities laid the foundation for the world-class education sector we have today. Menzies understood the transformative power of learning, and if we are to understand the Australian population today, we also need to appreciate how higher education has transformed our society. In 1996, the year John Howard was elected Prime Minister, 42% of the population aged 15 years and over had at least one post-school qualification. By 2024, the proportion of Australians aged between 15 and 74 with a post-school qualification had jumped to 63%. In 1996, 10.8% of men and 10.1% of women held a bachelor's degree or higher. In 2024, that number had more than tripled, with 33% of Australians holding a bachelor's degree or above. And beneath that massive change is another social story about women's education. In 1996, similar proportions of men and women had degrees, with slightly more men than women. By last year, 30% of women between the ages of 15 and 74 had a degree at bachelor's level or higher, compared to 30% of men in the same bracket. If you drill down to the 25 to 34 age bracket, 41% of men, but 54% of women have a bachelor's degree or higher. That's an extraordinary change, an extraordinary positive reflection in relation to women's education. Returning to the specifics of the bill lays the groundwork for major future changes to the early childhood education and care sector. The impacts of those changes may flow through to other parts of the education sector landscape as it stands today. So it's worthwhile spending a moment or two outlining what that landscape looks like. The June quarter report from this year showed that there were more than 1 million Australian families using a childcare service, and many of those families have more than one child in childcare. We're talking about a total of more than 1.4 million children attending around 15,000 different approved childcare centres. That's just under half of all Australian children aged 5 and under, or just over a third of children aged 12 and under. For those who use care, the majority attended centre-based care, but around 40% were in outside school hours care and just under 5% in family day care. In 2024, there were 341,000 4- and 5-year-olds enrolled in a preschool program. There are over 4 million school students in Australia today, and around 63% of them are in government schools, 20% in Catholic schools and 17% in independent schools. The non-government education sector is now the fastest growing, with independent schools growing by more than 18% in the 5 years to 2024, and Catholic schools by more than 6%. In higher education, there are now 1.6 million students enrolled in our tertiary education institutions. Of those, more than 1.1 million are domestic students, with 589,000 international students. Student numbers are recovering from the pandemic, but men are less likely to commence higher education than they were 10 years ago. In the 2023-24 financial year, international education was worth $51 billion to the Australian economy, with $30.2 billion paid in GST and $20.6 billion paid in tuition fees. It is a major export industry and a major asset to our country. What does this data tell us to date? Because there are stories in all of these figures. Take, for example, the extraordinary growth in independent and Catholic schools for the last 5 years. To me, that data shows broader trends. It shows that in our society, parents want choice and will make sacrifices to choose the option that is right for them. It's not my job to tell parents what is best for their children. Parents know what's best for their children. It's my job to make sure that parents have the greatest range of options so that they can choose what's best for their family. The education system needs to be set up to allow parents to make that choice. And my role is to do everything I can so whatever choice they make is a good choice. I only need to look at my own electorate, where we have outstanding government, Catholic and independent schools. As Shadow Education Minister, you will never hear me attack our teachers. Australians love their schools. They know that their schools bring communities together. They know their teachers work hard and that they care deeply about their students. They know their teachers are trying to give students the foundational knowledge that is so crucial to set them up for success. I'm a strong believer that students need to develop deep foundational knowledge to set them up and to help them understand the world around them. I want to say to Australian parents, the basis of a strong education, reading, writing, maths, science and a proper and deep understanding of our history are non-negotiable. These are the foundations of learning. It's only when these foundations are right that we can properly prepare our children for the future. Without those foundations, we are failing to equip our children with the tools they need to build successful and productive careers. We should expect that our education system will set high standards and drive excellence in these fields. We never want to fall into the trap of low expectations. We owe it to our children to deliver explicit teaching wherever it's needed, to empower our teachers and our principals to combat classroom disruption. The fitness for purpose of our education system is not only in what it teaches, it's in how well it prepares the next generation for the years to come. Foundations are meant to be built upon. What's clear to me is that Australians need to be lifelong learners. There's a phrase often attributed to the American thinker Alvin Toffler, who said, "The illiterate of the 21st century won't be those who cannot read and write, but those who cannot learn, unlearn and relearn." Ironically, it appears the quote may have been inaccurate or misattributed, but it's a good line and it makes a clear point. We're moving into a world where the ability to adapt will be definitive of success, and there's growing unease that our education system is just not there. Because while the data tells a story of the stunning success in women's education, it also tells about the decline in men's education. In 2015, 168,000 young men started their higher education journey. By 2024, that number had dropped to 158,000, all while our national population increased by almost 3.4 million over the same period. What's driving this trend? Is that a trend we will see continue into the future? Do the changes that we're making in bills like this one contribute to that trend in our higher education sector? These are the types of concerns and others that we should be thinking about. But in some areas, the concerns are immediate. Parts of this bill are designed, the government says, to inform future policy work in the childcare sector. That's good and it's necessary, but it's also time for immediate action. Last night I watched the revelations on Four Corners about the way that pedophiles have been operating in the Australian childcare centres. It was horrific. It's one of the most blood-curdling and disturbing things I've ever seen on Australian television. We've treated this with the utmost seriousness. Our approach as the opposition has always been to put children first. We've not taken a partisan view on this at any point. We supported the government's response to the horrific incidents we saw this year in Melbourne. We supported the actions of Attorneys General in relation to the Working with Children checks and even called for it to be sped up, which the Attorney did. And just this week we sought to introduce a bill to deal with the sentencing of child sex offenders and made it clear that this wasn't partisan, but it is urgent. We repeat our request for government support for these initiatives. When it comes to childcare, safety must be the number one priority. Safety must be the number one priority. This morning I wrote to the Education Minister making clear that in our view further action is needed to restore confidence in the sector. And I've been informed a moment before I spoke that the Education Minister has written back to me just now. And I look forward to reading his letter. We're not interested in taking a partisan line on these issues. Yes, I do urge the government to support coalition moves to strengthen our laws to remove child sex offenders from our streets and to protect our communities. That, as I said, that is not partisan, but it is urgent. But as I've said to the Minister, I'll countenance any serious proposal to further improve safety in our childcare centres. I want to turn to some of the specific mechanisms in this bill, because some of these measures have been before the Parliament previously in the Education Services for Overseas Students Amendment, Quality and Integrity Bill 2024, which was never put to a vote in the Senate. This is not just a reheat of previous policy, because the Parliament has not seen more than half of the measures that are in this bill, which is currently before the Parliament. And the debate in the last Parliament was dominated by Labor's bungled handling of the overseas student caps issue. Now, those caps are not part of this bill, but that doesn't mean that the other provisions of the bill are without flaw. In the last Parliament, coalition senators who looked at elements of this bill in the course of the Senate committee inquiry raised a number of concerns about missteps and overreach. For instance, parts 1 and 2 of the bill are about Education Agents Commission and information sharing. They're intended to address integrity concerns across the education sector following the release of the rapid review into the exploitation of Australia's visa system by Christine Nixon. The Nixon review cited the fact that approximately 75% of international students seek the assistance of an education agent. It also the current regulations for the it also deals with the current regulators for the education sector, being TEXA and ASQA, who play no role in the supervision of education agents. Instead, the onus is on the education provider to ensure the agents they deal with do not engage in false, misleading or unethical recruitment practices. When this bill was last before the Parliament, the bill included definitions of the term education agent and education agent commission and inserted a fit and proper person test for providers engaging with education agents. Some stakeholders raised concerns about the breadth of the new definition of education agent that may have had unintended consequences. For instance, the Australian Chamber of Commerce and Industry submission stated, and I quote, "The broad definition of associate may pose logistical challenges for providers, potentially deterring valuable investments and complicating compliance. To mitigate these issues, it's crucial to carefully consider the unintended consequences of those broad definitions before progressing this bill." In the last Parliament, the submission from the Independent Higher Education Australia stated, "While IHEA supports clarity through the definition of an education agent, the references to people who provide advice or assistance to overseas students or are otherwise dealing with overseas students seems quite broad, far-reaching, and may capture people who are not engaged in a financially beneficial arrangement with the provider. While we understand the intent is to capture all situations where there are monetary and non-monetary agreements and benefits to agents, it's not clear how a compliance regime will support the identification of non-monetary benefits." These are real challenges. Will Part 2 of Schedule 1 in effect drive up commissions in the education agents sector? This warrants careful consideration, and I'm concerned that consideration has not yet been given. All of these concerns remain in relation to the bill before the House. And I note the government's approach here is a very long way removed from what it said it would do, because Recommendation 13 in the Nixon Review proposed regulating onshore and offshore education agents and adopting a model similar to the United States. In response, the government said it would, and I quote, consider expanding the remit of the Office of Migration Agents Registration Authority, AMARA, to include education agents as providers of visa advice. An expanded AMARA role would be complemented by increased accountability of education providers without requiring separate regulatory infrastructure in the Department of Education. What about other parts of the bill? Other parts of the bill dealing with education integrity also raise concerns. For instance, the Minister's power in Schedule 7 to wake up and cancel any course in Australia is completely unchecked. He can do so on one day simply if he's satisfied that there are or have been systemic issues in relation to the 18 standard of delivery of the courses included in the class. The courses included in the class provide limit value to Australia's current, emerging and future skills and training needs and priorities, or it's in the public interest to do so. That power is essentially unchecked. It's a massive power. It's arguably duplicative of the functions of the regulators. And I'm worried that this might result in administrative law litigation. There are measures in this bill as well in relation to Indigenous medical students. This is a modest measure, which we understand will only affect a very small number of students, and which, given the size of the measure and the way that admissions are regulated currently, has no material impact on admission standards or supply, and may help address a small area of unmet demand. Under this bill, TEXA also is given additional powers. The powers it is given are to regulate offshore campuses. Why? Why put this ahead of the review that's going on right now into TEXA's powers and functions? Why is it that, as one stakeholder put it to me, institutions are self-accrediting when delivering courses on Australian soil, but not when delivering those same courses offshore? The only explanation we have here is that TEXA has asked for these powers, and we need more explanation than that. Finally, I come to the question of childcare. Now, as with school education, parents and families and children all come in different shapes and sizes. It's important that we as legislators don't tell parents how to run their families and don't mandate a one-size-fits-all system in relation to the way we undertake childcare. We need to provide choices for families to meet families where they're at, and that is the thing that will underscore my approach to the question of childcare more broadly. In this bill, the government's explanatory materials make it clear that the measures relating to childcare will be a measure that is sensitive for the sector. We understand that the information collection will start later this year through a secure platform being constructed by Deloitte. The purpose of the childcare provisions here are about compulsory acquiring information about pricing in order for the government to undertake a policy project. We understand this policy project will be initially done on a voluntary basis, but the Secretary will be able to use compulsory powers if necessary. There's an obvious concern about the publication of information that may be a pricing signal. We've asked questions about who will be targeted, who decides who will be targeted, and who obtains the information. As it stands, the answers are unclear. What is clear is that this pricing project comes after the Productivity Commission's June 2024 report on childcare and the ACCC's childcare price inquiry, which was released in January 2024. But the powers have been introduced essentially without consultation or visibility from the sector, and we don't know what the impact will be. This is why we are seeking these matters to be, or this bill to be sent to the Senate committee for a short Senate inquiry in order to unpack and scrutinise the measures in this bill. It's important that the Parliament does its job in scrutinising legislation, to hear from stakeholders, to understand the full effects before passing the bill. It behoves us as legislators to understand the impacts before we pass this bill into law. And I thank the House.
I give the call to the Minister.
Thank you, Deputy Speaker. I move that the debate be adjourned and the resumption of the debate be made an order of the day for a later hour this day.
The question is that the debate be adjourned and the resumption of the debate be made an order of the day for a later hour of this day. All those opinions say aye. All those against no. I think the ayes have it. Okay, Clerk.
Government Business, Order of the Day number 3, Home Affairs Legislation Amendment 2025, Measures number 2 Bill 2025, resumption of debate on the second reading.
The question is that the bill be now read a second time, and I give the call to the member for Flinders.
Thank you, Deputy Speaker. Let me begin by saying that the Coalition will support the passage of the Home Affairs Legislation Amendment 2025 Measures number 2 Bill of 2025. That is because, fundamentally, the content of the bill is aimed at doing two worthwhile things. The first is to modernise and clarify Australia's laws regarding the collection and use of biometric facial images under the Migration Act of 1958 and the Australian Citizenship Act of 2007. The second is to provide the Minister for Home Affairs with a new discretionary power to exempt certain individuals from meeting the physical residence requirement that ordinarily applies in the first 2 years after a citizenship application is made. These are relatively modest and pragmatic updates to existing laws, and on the surface, they are likely to give expression to valuable improvements. Of course, they also reflect the need for ongoing vigilance in return to Australia's migration and citizenship laws, not least in order to ensure that they keep pace with technology and align with global best practice, and that the administration of our borders and our citizenship systems remains effective, secure and just. Deputy Speaker, the biometric provisions in this bill are, in large part, a continuation of reforms that were first enacted by the former Coalition government. More specifically, it was the Coalition that, in 2015, legislated the Migration Amendment Strengthening Biometrics Integrity Act. That landmark legislation established the very foundations of the biometric systems that now underpin Australia's border operations, including smart gate automation and the broader facial recognition architecture in use at our airports. A decade has passed since those reforms were legislated, and unsurprisingly, biometric technology has advanced substantially during that time. Criminal networks involved in human trafficking, people smuggling and identity fraud are now more sophisticated than ever, and our verification systems must accordingly evolve just as quickly. The content of this bill essentially updates and refines parts of our laws to reflect those realities and imperatives. Foremost among the changes incorporated within the legislation are clarifications of what constitutes a lawful facial image under both the Migration Act and the Citizenship Act. By modernising these provisions, the bill brings Australian law into closer alignment with international biometric standards. In the process, it is designed to make it more difficult for identity fraudsters and human traffickers to exploit emerging gaps in our existing framework. More specifically, the bill makes it clear that facial images used for identity verification can lawfully include the full face alone or the face together with parts of the neck and shoulders, depending on how the image is captured. This clarification is important because modern automated systems such as airport smart gates, kiosk check-ins and digital visa processing platforms often record cropped or variably framed images. Under the current law, that has created uncertainty about whether such images technically meet statutory requirements. These amendments should resolve that doubt. They will confirm that existing records remain valid and that future image collection will be legally sound and operationally consistent across agencies. On each of these grounds, the effects of the bill should be to strengthen the integrity of biometric matching, reduce the risk of administrative error, and ensure that Australia's systems are compatible with the standards now widely used internationally. It should also complement other national initiatives, such as the National Driver Licence Facial Recognition Solution, a system that, once operational, is meant to better integrate Commonwealth and state facial databases to improve information sharing and establish additional protections against identity crime. Deputy Speaker, Schedule 2 of this bill deals with a different, though not entirely unrelated issue, the physical residence requirement for aspiring Australian citizens. Currently, Australian citizenship law requires that individuals granted citizenship must be physically present in Australia for at least 180 days within the 2 years immediately following their conferral. That requirement makes sense in the overwhelming majority of cases, as it encourages genuine connection and integration into the Australian community. However, there are some circumstances in which the rule can be unreasonably restrictive and problematic, most notably of all for elite sports people who regularly train and compete on foreign soil. Passage of this bill would provide the Minister for Home Affairs with a new discretionary power to exempt such individuals where it is assessed that it is justifiable to do so, especially where they would otherwise be required to travel to and from Australia on a frequent basis simply in order to try to meet the existing obligations. The Coalition recognises the practicality of this measure. In essence, it introduces improved flexibility for relatively exceptional circumstances. That said, we naturally expect that this new ministerial power will be exercised with appropriate care and caution, and that necessary oversight measures will be put in place in order to prevent the potential for misappropriation or abuse. It must ultimately be the case that these exemptions are not used to create backdoor arrangements or any other form of preferential treatment in relation to Australian citizenship for particular individuals or groups. But we are prepared to support, at least in principle, what appears overall to be a sensible fix. At the same time, it must be said that many of the legal ambiguities this bill seeks to correct, particularly those addressed through deeming provisions that retroactively validate past actions, are almost certainly the result of problems that have been around for a while due to yet more administrative mismanagement and delays under Labor's watch. Over the past 3.5 years, we have seen repeated wanton examples of retrospective clean-ups and ad hoc fixes across the Home Affairs and immigration portfolios, evidence of a government playing catch-up rather than leading with competence. Indeed, over the past 3.5 years, the Albanese government's record in Home Affairs has been one of disarray, delays and some dysfunction. From the High Court's ruling in NZYQ decision that exposed shocking gaps in the management of immigration detainees, to stripping the Home Affairs portfolio of its many functions and then restoring them again much later, and to repeated failures in visa processing, border protection and cybersecurity coordination, the government has demonstrated a lack of control. Some ministerial infighting and reshuffles, endless reviews and reactive management of one crisis after another have become hallmarks of this administration. Australians have seen detainees released without adequate safeguards, critical infrastructure vulnerabilities left unaddressed, extremely dangerous criminals released only in some cases to commit even more alarming crimes, and the integrity of migration programs eroded by paralysis. In essence, this government's approach has too often been reactive, opaque, and in some cases incompetent and piecemeal. When Labor encounters administrative or legal difficulties, its instinct is to ignore the seriousness of the problems and then sometime later to rush in here to legislate after the fact, to paper over cracks rather than address the foundations. And given that extreme secrecy and a wholesale lack of accountability have been such staples of this government's administration as a whole, it's probably right to imagine that the same has happened again in the lead up to the introduction of this legislation. For anyone outside the bureaucracy knows at this point, the creation of this bill could in fact be the byproduct of yet more mistakes rather than any kind of forward-leaning development. What we see here again, at the very least, are multiple provisions targeting at retrospectively correcting past actions. Overall, this government's approach to Home Affairs has been a story of confusion, complacency and indeed some chaos. And it has represented a very stark contrast from the years before that, when the Coalition delivered strength, order and decisiveness. But to return to where I began, the Coalition will support the passage of this bill, and whilst its origins may well lie in more quick fixes from Labor, its content, especially around the biometric updates, is generally sound. It is also broadly consistent in this particular case with the basic policy direction established under the previous Coalition government. We therefore welcome the improvements it should make to the management of Australia's migration, border and citizenship systems. And we hope that the changes that the bill delivers will represent at least one small step in the right direction in the Home Affairs portfolio for the Labor Party. And in the meantime, I thank the House.
Minister.
I move that the debate be adjourned and the resumption of the debate be made in order of the day for a later hour this day.
The question is that the debate be adjourned and the resumption of the debate be made in order of the day for a later hour of this day. I will now put that question. All the opinions say aye. All those against. Motion is carried. And I give the call to the member for Fisher.
Thanks, Madam Deputy Speaker. Madam Deputy Speaker, I seek leave to move the following motion.
First of all, can I just see if leave is granted?
Leave is not granted.
Yet.
Okay, read the motion.
Doesn't know what he's opposing.
That was my fault, member for Fisher.
That's all right.
Trying to keep things moving.
Madam Deputy Speaker, I seek leave to move the following motion. That so much of the standing and sessional orders be suspended as would prevent the following. 1. The Crimes Amendment Mandatory Minimum Sentences for Child Sexual Abuse Bill of 2025, standing referred to the Federation Chamber. 2. The bill be called on for debate immediately, following constituency statements today, with the time for each second reading speech limited to 10 minutes. And 3. Proceedings on the bill having priority over all other government legislation, with debate concluding no later than 6 p.m. today, and any questions required to complete the bill's consideration in the Federation Chamber being put immediately.
And that's the motion? Okay. Is leave granted?
Leave is not granted.
Leave is not granted.
Mr. Speaker, I move that so much of the standing and sessional orders be suspended as would prevent the following. 1. The Crimes Amendment Mandatory Minimum Sentences for Child Sexual Abuse Bill 2025, standing referred to the Federation Chamber. 2. The bill being called on for debate immediately following constituency statements today, with the time for each second reading speech limited to 10 minutes. And 3. Proceedings on the bill having priority over all other government legislation, with debate concluding no later than 6 p.m. today, and any questions required to complete the bill's consideration in the Federation Chamber being put immediately.
Is there a member who wishes to second this? All right. Sorry, just a moment. You're going to speak first, and then we call for a second.
Yes.
And then I'll
Thank you.
call for a seconder.
Yep. Madam Speaker, Madam Deputy Speaker, I rise today to speak on a matter of the utmost seriousness and urgency. This Parliament must act now to protect the most vulnerable members of our society, our children. This is not an issue that can wait for another sitting week or another round of debates. The safety of our children demands immediate action, which is why I move that the standing orders be suspended so that this bill can be brought on and dealt with immediately. This bill is about the protection of Australian children. It is about sending an unmistakable message to those who exploit, abuse or prey upon children that they will face justice and that they will face serious prison time. Child sexual offences are among the most serious offences in the Commonwealth Statute Book. Any person who commits one of these crimes should expect to spend a long time in prison. I do not believe there is a single right-minded, decent parent in this country who would disagree. This bill is also about restoring public confidence in the justice system. Families across Australia have been clear. They want their children to be safe. They are horrified by what they see in the media. They are deeply concerned about the proliferation of child sexual abuse, particularly online, and they are dismayed when they see offenders walking free after only a few months behind bars. Madam Deputy Speaker, Four Corners showed what parents already fear. Gaps in staffing, ratios and checks are letting offenders near our kids. Parents deserve more than promises. After last night's revelations, we need stronger sentencing for Commonwealth offences and a national lift in safeguards information sharing and enforcement to make clear that if you exploit a child online or through a carriage service, you will face real prison time, not a slap on the wrist. The statistics are devastating. The Australian Centre to Counter Child Exploitation recorded 82,764 reports of online child exploitation in 2024-25. That is an average of more than 226 reports every single day. Over the last year alone, reports of online child sexual abuse increased by 41%. This is not an isolated problem. It is a national epidemic. Given those numbers, there is no justification for delay. We cannot allow a system that hands down sentences measured in months for crimes of extraordinary depravity. Madam Deputy Speaker, the case that has shocked the Australian community in recent times is the case of the DPP and Maloney in Victoria. It involved a father who sexually abused his 5-year-old daughter on 19 separate occasions and who produced and transmitted 77 separate files of child sexual abuse material. Those files included 13 videos and 64 images. The judgment makes for unbearable reading. The little girl knew what was happening to her was wrong. On at least 2 occasions, she told her father she didn't like it. She was just 5 years old. Yet despite this, the offender will be eligible for release after just 2.5 years. For the Commonwealth offences of producing and transmitting child abuse material, he received a sentence of only 6 months imprisonment before release on a recognizance order. 6 months for producing and sharing videos of a child being sexually assaulted, his own daughter, no less. Madam Deputy Speaker, that is not justice. That is an abject failure, and that failure demands immediate action by this government. The Commonwealth does not have a general power to make criminal laws. That is a matter for the states. However, the Commonwealth does have jurisdiction when a carriage service, such as the internet or postal service, is used to commit these crimes. This bill deals with those specific offences. It does not create new offences. It strengthens sentences for existing ones. Specifically, the bill amends the Crimes Act to establish mandatory minimum sentences of 5 years imprisonment for 5 existing offences relating to child abuse material transmitted or possessed through a carriage or postal service. For second or subsequent offences, the mandatory minimum will increase to 6 years. Importantly, this bill closes the loophole that allows the court in Maloney to release the offender after just 6 months in prison. Under this bill, a recognizance release order cannot be granted for these crimes unless exceptional circumstances exist. This reform is not radical. It is necessary, it is reasonable, and it reflects the expectations of the Australian community. When the Coalition introduced mandatory minimum sentences in 2019, it was because 39% of Commonwealth child sex offenders were not serving a single day in prison. That was unacceptable then, and it remains unacceptable now. Since the introduction of those reforms, we've seen real improvements. More offenders are pleading guilty. Sentences are longer. Rehabilitation rates have improved. The community is safer. But cases like Maloney show that more must be done. That is why we must act now. Deputy Speaker, the Coalition seeks bipartisanship on this bill. The Attorney has said publicly that she is open to considering this proposal. I welcome that. But words are not enough. The time for consideration is over. It is time to act. This bill should not be delayed by procedural obstacles. Standing orders should be suspended so that it can be debated and passed without delay. The community expects no less. The impacts of child sexual abuse are lifelong. 95% of survivors experience long-term mental health consequences. 67% struggle in their relationships. 56% suffer setbacks in their education and finances. The trauma endures for decades. It destroys lives. It breaks families. And too often, victims of abuse become offenders themselves. That is the devastating cycle that we are duty-bound to break. Some will argue that longer sentences don't reduce reoffending, but while an offender is behind bars, they cannot harm another child. Longer sentences incapacitate offenders. They protect communities. They send a clear and powerful message that this nation will not tolerate sexual abuse of children. They also deter potential offenders who know that the consequences are real and severe. Most importantly, they restore faith that our justice system stands with victims, not with perpetrators. Madam Deputy Speaker, every day that we delay, another 226 reports of online child exploitation are received. Every day that we delay, more children are abused. Every day that we delay, we fail those who depend upon us for protection. That is why this bill must be passed urgently. That is why the standing orders must be suspended today. I call on every member of this House, regardless of their political affiliation, to support this motion. Let's act together. Let's act decisively. Let's act now. Every child deserves protection. Every offender deserves real punishment. This Parliament has the power to make that happen. Let us not waste another day. I commend the motion to the House.
Is the motion seconded?
I second the motion.
And do you wish to speak?
Yes. In rising to support the Shadow Attorney-General, I do so reflecting the number one priority of any government, to keep Australians safe. Protecting children is an imperative of that special compact. This proposal has been put together in a considered, thorough and careful way because we have a problem here, Deputy Speaker, and we, as a collective of this federal parliament, need to fix it. This is above politics. This is beyond partisanship. This is solely and entirely centred on wanting to protect children, to deter predators and to keep Australians safe. I am deeply disturbed by the horrific allegations of abuse occurring in childcare around Australia. We cannot look the other way. We cannot hope that it goes away. The ABC's Four Corners program last night identified almost 150 childcare workers convicted, charged or accused of sexual abuse and inappropriate conduct against children. I saw some of journalist Adele Ferguson's story. It was shocking, and more of what she uncovered chilled me to the bone, I have to say. I'm familiar with Adele Ferguson's work across several topics. She is forensic and she has a strong sense of justice. As a proud Victorian who currently watches in despair at the lawlessness running rampant across my state, let me remind the House about why we are here on this issue. We are here because of the Maloney case. Let's remind ourselves of the main points of that case. And I'm not going to go into the details of offending in this case. But this is about a parent who abused their child, their daughter, who was 5. The offender abused their child on no less than 19 occasions. They then produced and communicated child abuse material from those occasions. There could not be a more profound breach of trust. I think of that little girl, that 5-year-old, and I think about how she is doing now, a few years on, and I think about the rest of her life and what that holds because of that abuse. That child, who hopefully will become an adult one day, has a life sentence, Deputy Speaker. Her abuser does not. He doesn't have a fraction of the life sentence that he imposed on that child. Maloney was given an effective non-parole period of 6 months for the Commonwealth offences of producing and distributing child abuse material, which followed a 2-year non-parole period for the other offences. That is manifestly inadequate. That is wrong. We are offering the government an opportunity to show the Australian people that their parliament can come together and work in the common good, beyond the political fray, when there are circumstances such as this. The sentence was in part due to mitigating circumstances. Deputy Speaker, in the instances of child abuse, there should be none, because there is never any reason, any excuse for abusing a child. There should be no mitigating circumstances. And today, we seek to fix that. This bill ensures that those who abuse, exploit or prey upon children face real consequences. Deputy Speaker, this bill, and the motion, which I am proud to second, introduces mandatory minimum sentences of 5 years imprisonment for serious Commonwealth child sexual abuse offences. This increases to 6 years for second or subsequent offences, as it should be, Deputy Speaker. The bill also closes a loophole that has allowed some offenders to walk free on recognisance of release orders after serving only a fraction of their sentence. This is not good enough. Deputy Speaker, Australians deserve better. We have to do better on this. Our children deserve to grow up safely. I implore my colleagues on the other side of this chamber to support this motion, and I strongly commend it to the House. Thank you.
The question is that the motion be agreed to, and I give the call to the Assistant Minister.
Thank you, Deputy Speaker. Everyone in this chamber has contempt for those who harm or seek to harm children. There should be no suggestion or intimation to the contrary, and I move that this debate be adjourned.
Well, I can't proceed on that. I just want to check something with the clerk, because I believe I've got to proceed straight to what the Minister has put, which is that the debate be adjourned. Yes, Member for Fisher.
Madam Deputy Speaker, I refer you to page 530 of the practice, and whilst I appreciate the Minister's commentary before he moved the motion, the reality is under Standing Order 79A, and as detailed in page 530 of the practice, a member who speaks to the motion, he made brief remarks and then moved the motion. That can't happen. Both can't happen under the rules, under Standing Order 79A, and as detailed on page 530 of the practice. The person who speaks to the motion can't move an adjournment of the motion.
So just so I can clarify, Member for Fisher, you're suggesting that because the Assistant Minister said a short phrase before moving the motion?
That is exactly what I'm saying.
That's a speech and a contribution?
Correct.
Okay.
And the practice supports me on that point of order, and I now move that once you've made a ruling on that, I'll await your ruling.
Yep. Okay. We take it as a speech.
Move that the question be now put.
The question that is before us, that the question now be put. All of that opinion say aye. Aye. All those against, no. 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 One voice. The ayes have it. Ayes have it. It's only one voice. Noes have it. Noes have it. I call it for the noes having it. Are you calling for a division? I've just got a lot of noise going on in your peanut gallery. I'm just confirming with you. You're calling a division? Okay, ring the bell for 4 minutes.
We're voting for the motion.
Lock the doors. The question is the question be put. The ayes will pass to the right of the chair and the noes to the left. Appoint the honourable members for Capricornia and Bowman as tellers for the ayes, and the honourable members for Werriwa and Bean as tellers for the noes. Order. The result of the division is ayes 48, noes 88. The matter is resolved in the negative. Time has expired, so the question now is that the motion be agreed to. I'll put the question. Those opinions say aye. Against no. I think the noes have it. Ayes have it. Division required. Ring the bells. Ring the bells for 1 minute. Lock the doors. The question is the motion be agreed to. The ayes will pass to the right of the chair and the noes to the left. Appoint the honourable members for Werriwa and Bean as tellers for the noes, and the honourable members for Capricornia and Bowman as tellers for the ayes. Order. The result of the division is ayes 48, noes 88. The matter was resolved in the negative. Order. If members can leave the chamber as quickly and as quietly as possible. Are there any statements by honourable members? I give the call to the member for New England.
Thank you very much, Mr Deputy Speaker. Mr. Speaker, I rise today to talk about the fiasco, which is the Bureau of Meteorology website, that we had a perfectly good website, one that worked absolutely marvellously. In fact, it got 2.6 billion hits a year, and for the price of $4.1 million, we've turned it into a complete fiasco. It is amazing when you put out a poll of 4,000 people, the results are 88% think it's a complete debacle, but it has got some supporters out there. 3% of people believe it's all right. 3% of people believe it's all right. This is one of those issues that just resonates everywhere, where we're getting people calling us saying, what on earth have they done to a website that worked perfectly well? Now, it's a very strange time to change the Bureau of Meteorology website because we've arrived at the time of the storms. And yesterday we had a massive storm that went through southeast Queensland, and of course the website was found wanting. So I call on this government as a catalyst, as a clear understanding of competency, to move from this politically correct rubbish and go back to the one that worked, the one that farmers could use, the one that shop owners could use, the one that could actually tell you this marvellous thing that you want to get from a website. You want to find out about it, and I know this is surprising, the weather.
I give a call to the honourable member for Menzies.
Thank you, Speaker. It is with great pride that I rise to speak today to congratulate Professor Richard Robson, a resident of Menzies, on recently being jointly awarded the Nobel Prize for Chemistry. Professor Robson has worked for over 4 decades on world-leading research into metal organic frameworks. Notably, his inspiration for this innovation came through his teaching at the University of Melbourne. He devised a strategy using molecular rods by which a wide variety of molecular building blocks could be linked together to form network structures. These are crystal structures that are typically the size of only 1/1000th of a millimetre in length. This pioneering work has led to the development of an entire new field of research worldwide. This honour is a fitting testament to the work Professor Robson has undertaken throughout his career, and one that it recognises his diligence, creativity and leadership. I know that his work is already serving as an example to students across our community and country of the power of scientific research to expand possibilities and change lives. I was pleased to be able to personally congratulate Professor Robson last week and extend the warm congratulations of the Prime Minister, the government and our local community in Menzies. His humility, imagination and commitment to learning and teaching exemplifies the very best of Australia's scientific community, and I thank him again for his extraordinary contribution.
Member for Mayo.
Thank you, Deputy Speaker. The electorate of Mayo is home to some outstanding sporting clubs, and one of them is the Onkaparinga Swimming Club, whose home base, Paul, is in the Woodside Army Barracks in the Adelaide Hills, and it is a base with uncertain future. And I would like to talk to you about this club. 80 members, swimmers aged from 5 to 75, programs for all abilities, members from across the Adelaide Hills and the city, and this is a very special club. The Onkaparinga Swimming Club proudly welcomes swimmers with a disability. They are valued and respected. Head coach Pat, who's been with the club for more than 30 years, is dedicated to swimmers with a disability, which is important. That's what inclusion's all about. The Onkaparinga Swimming Club is one of the state's best. Earlier this year, it won the country swimming championships. In fact, they've won 20 out of the last 25 titles. For more than 3 decades, the Onkaparinga Swimming Club has trained at our Woodside Barracks. And they've done this year round. And the reason why they've done this is it's the only indoor pool that I can think of in the whole of the Adelaide Hills Council. And Adelaide Hills gets very, very cold, basically from middle March through till, well, it's still even cold now. Access to the pool is critical for the club's future, and this base and the facilities must remain open, not only for defence but for our whole community. They have no guarantee on the future, nothing about a lease past December, and they need certainty. They deserve certainty.
Member for Adelaide.
Hear, hear.
Thank you, Deputy Speaker. Deputy Speaker, I rise today to commemorate Ochi Day, a day which represents the Greek determination through the strong refusal of fascism and fight for freedom. We remember the sacrifices and struggles of those who fought for us. On this day, the 28th of October, Greeks all over Australia will be commemorating and celebrating the 28th of October as Orchi Day. In 1940, Greece refused to surrender to the Axis forces and said no to allowing their troops into Greece. Despite the odds being stacked against them, their brave act greatly influenced the tide of the war. The strength and determination of the Greek army resulted in the first setback and victory for the Allied forces and the first setback for the Axis forces. And the delay of Axis plans through Greece's defiance greatly shaped the Allied victory. Orchi Day holds a significant day, especially in my electorate, with a big community of Greek Australians who will be commemorating this weekend. Will be laying wreaths at different points across Adelaide to remember those that fought bravely, but also to remember the determination of the Greek people throughout World War II and other wars that they've fought in.
Member for Flinders.
Thank you, Madam Deputy Speaker. The Rosebud Hospital is a much-loved institution on the southern Mornington Peninsula. Everyone who lives there has a story of how the hospital and its excellent staff has come to their rescue. But in recent years, the stories about Rosebud are less about proud births or broken arms or learning to ride a bike, and more about long waits in triage, an overwhelmed ED in summer, and an eventual transport to Frankston Hospital for anything more than a flesh wound. Back in 2019, the Federal Coalition provided $5 million to the state government, which owns and operates the hospital, to do a business case to rebuild it. And a month ago, with great fanfare, the State Health Minister, Mary-Ann Thomas, came to Rosebud for a grand announcement, and there was much excitement and enthusiasm, particularly from the community group that has argued for years for the much-needed investment to redevelop it, only to be told that the hospital would get, wait for the drum roll, $4 million. Now, let me help you with the maths here. In 2019, the Federal Coalition provided $5 million for a business case. In 2022, the State Coalition promised $340 million to rebuild the hospital. And 6 years later, the Labor Party in Victoria comes to the party with $4 million, roughly 0.01% of what the hospital needs to be rebuilt. And even that was $1 million less than what the Federal Coalition provided 6 years ago. We all know that Victoria is broke, and each day another $20 million of Victorian taxpayers' money goes to paying interest on Labor's debt. Every month, Labor spends on interest what it could have spent to a full rebuild of the Rosebud Hospital.
Member for Bullwinkle.
Speaker, I rise today to share a story from my electorate of Bullwinkle. It's a story about community, resilience and the remarkable spirit of the people who live in the Perth Hills. This past weekend, the suburb of Darlington held its annual community bonfire. While I was unfortunately unable to attend this year, it's an event that holds a very special place in my heart. For many years, my sister, Dr. Diane Parker, a teacher at Helena College, and I were part of the volunteers who organised the bonfire, and I have seen firsthand how it brings out the best in our community. To an outsider, it might look like a simple bonfire, fun night out and a sausage sizzle and soup from the local CWA, but it's so much more than that. Its primary purpose is bushfire hazard reduction of the eastern states wattles, which is unable to be composted due to the resilient seed pods, so it needs to be burnt. The tradition began over a decade ago when a resident concerned about the fuel load in the local reserve suggested the community come together to clear it for themselves, and they did. It's a collaboration between the Darlington Volunteer Bushfire Brigade, Bushfire Ready Group, CWA, and most importantly, the students from Helena College High School who help gather the wood and make the bonfire the day before. It's a community proactively taking responsibility for its own safety. Speaker, I'm proud to say that I've also committed $300,000 to provide female change facilities to the Darlington Volunteer Bushfire.
Member for Warringah has the
Thank you. Last month I hosted a roundtable with constituents from the Australian screen industry. All were deeply concerned at the lack of local content rules for streaming services, which is resulting in a lack of investment in Australian stories. The screen industry has seen an estimated 60% reduction in work, and this puts around 55,000 jobs at risk. Listening to their stories and hearing the impact impact on their livelihoods. A petition was started to call on the government to deliver on their election promises in 2022 and 2025 and earlier in 2019 to legislate local content requirements for streaming services. The campaign has struck a chord. Australians love Australian stories, which is why nearly 12,000 people have now signed to show their support. And that includes actors, producers, directors, writers, voice actors, all who tell our homegrown stories. Many of them are in fact here today in the gallery, and I want to thank them for their strong advocacy. Countries such as Canada, France, Denmark, Italy and Spain have all introduced local content rules or are in the process of negotiating them to protect their screen industry. It's time for Australia to do the same. Streamers are using the publicly funded NBN to deliver their product. We should ensure that there is Australian-made stories. So I call on the Prime Minister and Minister Burke to deliver on their commitment and legislate for streaming platforms quotas for Australian content.
Member for Petrie.
Thank you, Deputy Speaker. Today, I have the pleasure of reading the visions of the future from 21-year-old Mia as part of our Raise Our Voice campaign. As a child, I saw the government making true progress. It was progressive policy, people-focused policy that allowed a kid born into an abusive and uncertain living situation to dream of bigger and better things. I was proud of my country because I knew as a whole we were progressing towards a greater, brighter future for everyone. However, as I got older, I suppose my rose-tinted glasses were cracked slightly. When I was in high school, particularly in the pandemic period, progressive policy appeared to falter. Decisions to increase the fees of certain degrees had me questioning my future. Perhaps attending a tertiary education isn't a key step in breaking generational burdens for everyone, but for me and many more, it is. That is only one example of backwards policy changing my perspective as a young person of what my future will look like. Parties making shameful statements about my rights as a woman, division over rights of Indigenous people, and over the correct way to handle children who have turned to crime. It isn't the progressive Australia that lifted me up as a child. So, to the government, I put this to you. Please do not shy away from progressive policy. Do not go backwards in the ways we have seen our foreign neighbours regress. Australia is built on progress, innovation and lifting up those who need it most. You never know, there might be a little kid watching Question Time the same way I used to, dreaming of her future. And trust me, her perception of her government's progress is everything. It is our future.
Member for Capricornia.
Thank you, Deputy Speaker. Today I rise to express my deep disappointment and frankly outrage at the Albanese Labor government's decision to rip $23 million in funding from the Rocky Sports Club project. This funding was secured and approved in 2010 by the former coalition government to support the expansion of a club that services 129 local sporting and community groups. It was shovel-ready, community-backed and would have delivered local jobs and world-class sporting facilities here in Rockhampton. But instead of backing regional Queensland, Labor's Infrastructure Minister Catherine King has strung along this community for years, only to pull the plug entirely, later on Friday afternoon, thinking no one would notice. Let's be clear, this was a simple variation request for an extension of time, not a new project, not a handout, just the green light needed to get on with the job. The decision to cut this funding shows utter contempt for Rockhampton and the wider Capricornia region. It's a betrayal of local athletes, volunteers and families who have poured their hearts into this vision. I call on Minister King and the Albanese government to reverse this decision and show some respect for the people of Rockhampton. Our community deserves better.
Member for Robertson.
Thank you, Deputy Speaker. And yet again we mark another chapter in our nation's history books, the chapter where the health of the nation is strengthened and a chapter focused on healthcare for all Australians and not just some. The Albanese government is making the single largest investment in Medicare since its creation over 40 years ago. Over $8.5 billion invested into Medicare to make sure that patients can get the care that they need when they need it. Also to supporting our Australian doctors, our Australian general practitioners, the backbone of our health workforce. And this isn't just a commitment for those practices, for those GPs, it is making sure that GPs can focus on what they do, and that is preventative primary health care, making sure that preventative health measures are put in place so that these chronic diseases don't spiral out of control, don't exacerbate and require an emergency department admission, making sure the hypertension remains low and making sure that cholesterol remains low so it doesn't become a heart attack or doesn't become a stroke. This is this government's focus. This government's focus is to make sure that we are funding bulk billing and making sure that we are sustaining the beating heart that is our healthcare system, bulk billing. Thank you.
Member for Barawa.
Thank you, Deputy Speaker. Today I met with Philippa Ryan, who told me the story of her husband, John. John was an award-winning builder working across residential and commercial construction and a local in our community. Only recently retired, John loved golf, and more than anything he loved his family. John was a husband, a father of 3 and a grandfather to 7. Last year, John passed away from glioblastoma after being diagnosed only 4 months earlier. John's story was devastating to hear, and I thank Philippa for taking the time to share and acknowledge him today. Brain tumours don't discriminate. They can impact anyone at any age. In my own family, my grandmother Ruth died of a brain tumour at 49. The survival rates are confronting, just 22%, and for glioblastoma only 5%. Each year, 1,528 Australians die from brain cancer and another 1,896 are diagnosed. This should concern each and every one of us. If we're serious about changing outcomes, we need to do more to support patients, families and research. In Barawa, we have dozens of families who've lived through or who are currently going through the devastation of brain tumour diagnosis, and that's why the Brain Tumour Alliance and its wonderful event, Head to Hill, is so important today. I want to acknowledge others in my community, particularly Ben Murray, Christine Whittle and Danielle Ballantyne, who along with Philippa shared stories with me and helped me bring awareness to this important issue in the Parliament today. Your message is being heard, and I'll continue to advocate on your behalf and on behalf of other families across the Barawa community.
Member for Moore.
Deputy Speaker, I rise as a proud ETU member and qualified electrician. I know what it means to work long hours away from family in tough conditions, building the infrastructure that powers our economy. I know the pride in that work and the frustration when the cost of living keeps rising but the wages don't. Across Western Australia, workers are doing it tough. Rent, groceries and fuel are all up, while too many employers still treat fair pay and safe conditions as optional. That's why Labor's same job, same pay reforms matter. They've restored balance, ensuring employers can no longer ignore their workforce. But sometimes, even with fair laws, workers must stand together and use every lawful tool available, including protected industrial action, to make their voices heard. That's what ETU members are doing at Bechtel's Pluto Train 2 near Karratha. They're building a project worth billions, yet too often people who build our prosperity are the last to share in it. They're only asking for fairness, safety and respect, to be paid for every hour worked, for super to reflect real hours and for rosters that let them get home safely to their families. Those are modest, reasonable claims grounded in dignity, not excess. Industrial action is never taken lightly, but sometimes standing still costs more. ETU members are united, they are strong, and they have my full support in their fight for fair and safe modern agreement, because a strong economy depends on workers who are safe, respected and fairly paid.
And Member for Riverina has the call.
Deputy Speaker, you would be very impressed if you wandered not far from here, Parliament House, and you went to the Yass Valley. You would find a lot of budding Tom Cruises. And when you go out and about in the Yass Valley area, you hear them say, "Show me the money. Show me the money. Show me the money." And what they're referring to is, of course, the Barton Highway, because it's been neglected. And what those budding Tom Cruises, aka Jerry Maguires, are shouting out, "Show me the money," for is because they want money for one of Australia's busiest highway. A highway between 2014 and 2023 has unfortunately seen 141 crashes, 9 deaths and 5 serious injuries. And in 2020, during the by-election, the now Regional Development Minister promised $250 million. Well, Minister, show me the money. And then, of course, in November 2023, it became $150 million, and we haven't seen that either. Minister, show me the money. And then, of course, we got $25 million in the last budget, apparently. But I say again, Show me the money, because we haven't seen the money. Labor has neglected the Barton Highway, just like they've neglected regional Australia. Show me the money, Labor.
Member for Leichhardt.
Thank you, Speaker. I rise today to take part in the Raise Your Voice speech. For Youth Voice in Parliament Week, I took part in the Raise Our Voice campaign. This speech is written by an FNQ leader. My name is Claudia. I'm 16 years old from Cairns. Right now, young people in regional Queensland are living through a youth mental health crisis. In my community, the nearest psychologist can be a 4-hour drive away. 200 kilometres that a struggling teenager simply cannot travel. Even when you get there, wait lists can stretch for 6 months. For a young person in crisis, 6 months isn't just too long, it's deadly. 1 in 4 young Australians experience mental ill health, but in regional areas, support is almost impossible to reach. We are told to speak up and be resilient, yet when we do, there is no one to answer. If the government truly wants to build a better tomorrow, it must start today by funding free, local, culturally safe mental health services that are accessible in every community. No young Australian should be told to wait. No one should be left behind because of their postcode. We don't need promises, we need action, and we need it now. As someone who has a well-documented struggle with depression in my past, I want to say to Claudia, we hear you. We're listening. The Medicare Mental Health Clinic in Cairns, the tender is complete and will be opening soon. Headspace Plus will be adding another clinician to help with youth mental health. We know that young people in the far north have undergone a lot of stress lately with Cyclone Jasper and COVID. We have listened and we have acted. Claudia, we are on your side.
Member for Cook.
Layla, a very smart 10-year-old girl from my electorate, wrote this speech. Imagine waking up every morning, not with excitement for the day ahead, but with a heavy burden. Not because of tests or tiredness, but because of bullies. Now ask yourself this, how would you feel? This is the harsh reality faced by me and many other children around Australia. There should certainly be more effective approaches to bullying, as it can improve children's education, well-being, and give them the tools to overcome adversity and grow as a person. Around Australia, bullying undoubtedly affects children's well-being. It causes immense stress and lowers self-esteem, impacting their grades and impacting their future. Studies show that children who were victims of bullying are at a higher risk of anxiety, stress and depression, sometimes lasting well into adulthood. 1 in 4 Year 4 to Year 9 students report being bullied every few weeks. Some schools think the situation is that victims must simply be more resilient. But what does resilience really mean? Layla's ideas include encouraging martial arts to build perseverance and a positive mindset, and creating a task force in every school to help children thrive. Layla, I thank you for your courage and your compassion in bringing this message to Parliament, and I urge action for the protection of young Australians.
Member for Bankside.
Thank you, Deputy Speaker. When Australia Post announced that the post office in Revesby Town Centre would be closing, I knew that the wrong decision had been made. And it came extremely disappointingly for the community in Revesby and the surrounding areas it services. When I spoke about the situation during the last parliamentary sitting week, I said I look forward to further discussions with Australia Post, particularly around alternatives to closure. While I'm pleased that these conversations were had, unfortunately, I am terribly disappointed that Australia Post did not recognise the importance of the closure and are pushing forward with closing the post office. The petition I launched in September received the support of more than 2,600 local residents from our community. And I'd like to thank that community for supporting our efforts to save the post office, with special recognition to Amanda Sweeney, who took it upon herself to collect signatures. While the post office will close on the 29th of this month, there is still work to do. Revesby is a growing community. It needs more services, not less. I will continue to work with local residents, businesses and Australia Post to find alternative solutions to preserve access to services in our community.
Member for Gippsland.
Well, thank you, Deputy Speaker, and I am sad to report that there has been an outbreak of arrogance and hubris and it's infected the entire Labor caucus. Because how else, Deputy Speaker, can we explain the mean-spirited plan, the complete lack of respect, which is the Labor proposal to put a use-by date on "We will remember them"? Now, without any consultation, no consultation whatsoever with ex-service organisation, without any proof there's a problem actually there to be solved, the Labor Party is removing rights from Australian Defence Force personnel and veterans to appeal decisions which would impact some of the most heroic Australians in our history. Under the legislation the Labor Party rammed through the House of Reps, which everyone over there voted for, Deputy Speaker, everyone voted for it. Under that legislation, Teddy Sheehan doesn't get a VC. Richard Norton doesn't get a VC. Harry Smith's troops at Long Tan do not get the medallic recognition they so rightly deserve. And the Labor Party voted for it. Now, Deputy Speaker, I say to the Minister, why? Why, Minister? You can't hide forever. This missing in action minister has given no reason whatsoever as to why he has gone down this pathway. Why is your government showing no respect to veterans, no respect to Australian Defence Force personnel? Why won't you just bin this bad bill before you do more?
Spence has a call.
Thank you, Deputy Speaker. Last Friday I had the great honour to open our newest defence capability in my electorate of Spence. Life Support International Australia has commenced its service and maintenance function on the Unipack 3 search and rescue kit, a kit that's deployed from our P8 Poseidons based out of RAF Base Edinburgh. This kit is relied on when we have search and rescue events out across our neighbouring seas, and as someone who spent 10 years in the offshore gas and oil sector, being able to be part of the grand opening and have an inherent link to a life-saving device such as the Unipack 3 was a really, really special occasion for me. When things go wrong, when you're hundreds of nautical miles offshore, you don't have the luxury of being able to step back onto land to safety. You really do rely on these life-saving appliances to get deployed in a time of need. So to the men and women that are going to be part of this maintenance facility, all power to you and the work that you do. You will save lives. To Greg Yerkes, the CEO of LSI, and Biorg's Doug Phillips, thank you so much for the opportunity to be there at your grand opening. It's just another feather in the cap for defence industry in South Australia, building on the great work that's been going on for many, many years. Thank you.
Leader of the Opposition.
Australians expect their Prime Minister to show judgment, respect and leadership. Instead, we have got the opposite. Arriving back in Australia from his overseas trip, the Prime Minister stepped off the plane proudly wearing a T-shirt with the name of a band, Joy Division, whose origins are steeped in anti-Semitism. The name was taken from the wing of a Nazi concentration camp where Jewish women were forced into sexual slavery. At a time when Jewish Australians are facing a rise in anti-Semitism, when families are asking for reassurance and unity, the Prime Minister chose to parade an image derived from hatred and suffering. This is not a slip of judgment, and he cannot claim ignorance. He was told about the dark origins of this band on a podcast in 2022. He even admitted that is very dark. He knew, he understood, and still he wore the T-shirt. So to wear that name across your chest is not just a statement of musical taste, and it is more than bad taste. It raises questions about values, the wrong values, and it is a profound failure of judgment. For the Prime Minister of this country, in full knowledge of the meaning behind the name of this band, to choose to wear this T-shirt is an insult to all, and it fails the basic tests of leadership. He should apologise immediately and explain why he thought this was acceptable.
Member for Swan.
Mindsets that have powered the nation's economy. I have also helped rehabilitate these mindsets and bring them back to life. Our EPBC reforms are important. Our environmental laws are old, outdated and overloaded and too slow for business and too weak for nature. Our reforms deliver this. To the Liberal Party, the supposed party of business, go back to basics and back business. You need to support these reforms. To the Greens, you are the party of protest. Let's be the party of progress. We can create these reforms that will be amazing for generations to come. Australia is one of the most beautiful countries across the world, and we have a moment in our times where we can create laws that are good for business but also good for the environment. Put the politics aside. Are you prepared to do this once-in-a-generation reform? I'm a proud miner. I'm also proud of our beautiful Australian environment. Come on, bring it on.
Order. In accordance with Standing Order 43, the time for members' statements has concluded. If members can take their seats as quickly and as quietly as possible, we shall move to questions without notice. Are there any questions without notice? And I give the call to the Honourable Leader of the Opposition.
Thank you, Mr Speaker. My question is to the Minister for Climate Change and Energy, and I refer to the front page of today's Australian. Under pressure from Senator Dean Smith and the other place, Labor has finally released a secret government document which warns of a, quote, further significant increase in retail electricity prices. It was also revealed that the Clerk of the Senate called Labor's obfuscation, quote, not acceptable. Why did this minister do everything he could to hide this document from the Australian public, instead of doing everything he could to reduce power prices by $275?
Call to the Minister for Climate Change and Energy.
Well, thank you very much, Mr Speaker. I'm deeply grateful to the Leader of the Opposition for the question, although I think it might have been better, Mr Speaker, if she had been more transparent with the House, because the Leader of the Opposition has asserted that the incoming government brief said one thing, didn't read the full quote for the incoming government brief. I will, Mr Speaker. It says,
Order.
It says,
on my left.
Mr Speaker, and I quote, the draft default market offer points to a further significant increase in retail electricity prices next financial year. Now, the important thing about the incoming government briefs referring to the default market offer is that that market offer was already public, not only when I received the incoming government brief, so it was hardly a revelation, but before the election, Mr Speaker, because the default market offer increase was released
Members on my left.
by the Australian Energy Regulator before the 2025 election. Now, that is not uncommon for a minister to receive a default market offer just before an election. And the minister has an opportunity, has a decision point before them at that point. The minister can say, well, it should be released in a transparent fashion. The minister can do that. That's what I did. Here's the press release from me referring to the release of the default market offer, this secret briefing that the Leader of the Opposition is so concerned to read about on the front page of the Australian today. I tabled my press release, Mr Speaker, from the 11th of March 2025, which was before the federal election. The alternative option available to a minister when receiving a default market offer that is high before an election is to change the law to keep it secret. That is the alternative option before a minister, an option I declined to take, an option one of my predecessors did take. The Minister for Industry, Energy and Emissions Reduction on the 31st of March 2022, almost 3 years before, changed the law by regulation to keep it secret until after the election. I table that as well. Now, the Leader of the Opposition quotes the incoming government brief. If the Leader of the Opposition had read on, she might have further quoted that brief. Decarbonising the electricity and energy system is foundational to achieving a whole-of-economy transformation, maintaining energy affordability and reliability. There's a whole lot more. There's a whole lot more where that came from, Mr Deputy Speaker. I hope I get more questions to the Opposition on the incoming government brief.
Member for Moncrieff can cease interjecting for the remainder of question time. The call to the honourable member for Hasluck.
Minister for Resources and Northern Australia, how is the Albanese Labor government delivering on its commitment to create secure and safe jobs by boosting Australia's critical minerals and rare earths industry? What other approaches have been proposed?
Call to the Minister for Northern Australia and the Minister for Resources.
Thank you very much, Mr Speaker, and I thank the member for Hasluck for her question. I want to take this brief moment to express my deepest sympathies to the families and workmates of the 2 workers who have died in a mining accident in Cobar earlier today. And it's a reminder to each of us here and around the country that mining is dangerous work and that every person who works in this industry deserves to come home safely at the end of a swing or at the end of a shift. Mr Speaker, Australia's resources sector is the engine room of our economy. We have a once-in-a-generation opportunity to capture new investment and create good, safe, well-paid jobs across the country by supporting the development of our critical minerals and rare earths industry. This government and our critical minerals strategy sets out a clear vision to make Australia a globally significant producer of both raw and processed critical minerals. The historic Critical Minerals Framework Agreement signed between the Prime Minister and the President of the United States last week is a major step in developing and growing this vital sector. This means good, safe, secure jobs for thousands of Australians in processing and mining in regions and industrial areas right across the country. Last week's historic signing is just the start of many more partnerships with the United States and Australia in our resources sector. And I want to take this moment to thank Ambassador Rudd for his tireless advocacy of our critical minerals and rare earths industry in Washington. And I will continue to work with other friends around the world as well, and later this week I look forward to representing Australia at a meeting of G7+ ministers in Toronto to further our work to diversify global critical minerals supply chains for the benefit of Australian workers, jobs and industries, and for our national security. Now, Mr Speaker, those opposite might not want to hear it, but it is a fact that no government has invested more in the future of Australia's resources than the Albanese Labor government. No government has done more to develop the critical minerals and rare earths industry and therefore the resources sector as a whole than this Albanese Labor government. Now, the truth is sometimes hard to take for those opposite, Mr Speaker, but let's look at their track record. They opposed the production tax credits for critical minerals. They kicked off about the Critical Minerals Strategic Reserve, which puts Australia in the perfect place to work with the United States. And let's not remember that churlish moment when they wanted to rewrite the periodic table and make gas a critical mineral. You would have thought that topped it, but now they're all over the shop in relation to environmental reform, claiming credit 1 minute and then bagging it the next. The truth is, Mr Speaker, those opposite don't know where they are in respect of the resources industry. They certainly don't know where they are with environmental law reform. They are no help whatsoever to the critical minerals industry. Meanwhile, Australia can trust in the Albanese Labor government to support the resources sector.
Member for Page, trying to give the call to the Honourable the Leader of the Opposition, who now will ask her question.
Thank you, Mr Speaker. My question is to the Minister for Climate Change and Energy. In January, the Prime Minister said of Tomago, quote, 5,000 jobs depend on this facility. But Tomago is now in crisis, with its CEO saying future energy prices are not commercially viable. Under Labor, there have been closures of the Kwinana and Kalgoorlie smelters in WA, emergency bailouts in Hobart, Whyalla, Port Pirie and Mount Isa, and mayday calls from Bell Bay and Boyne smelters. How can Labor promise a future made in Australia when all it actually delivers is future shutdowns, future job losses and higher energy prices?
Give the call to the Minister for Climate Change and Energy.
Thank you very much, Mr Speaker, and I thank the Honourable the Leader of the Opposition for the question. The first thing to say is that today is confronting news for the employees of Tomago. And on behalf of the government, I'm sure, I express our solidarity with the workers of Tomago and the people of the Hunter, Mr Speaker, and that regardless of what comes, there is a month of consultation, but we will stand with the workers of Tomago regardless of what comes. That is the first and most important thing to say, Mr Speaker. Tomago, Rio and Tomago have today announced the beginning of a consultation about the future of the Tomago smelter. And it is true that they referred to energy prices in that announcement. And they made clear in the announcement today, I quote, it is true that they said that finding competitively priced energy remains a central challenge. They went on to say, based on market proposals received to date, the cost of both coal-fired power and renewable energy options from January 2029 would increase significantly, fundamentally changing the operating economics and leaving the smelter unviable. That is what they said. And then they go on to say, Mr. Speaker, that it is difficult to find enough renewable energy for the project. Now, what they're saying is what we say, that we need more of the cheapest and most reliable energy for our grid. Now, this is an important and difficult period for the Tomago smelter. The government has been in discussions with Rio through the Industry Minister, the Treasurer, myself and others for some time, and we will continue that over the coming months and for as long as it takes to make sure that nothing is left on the field when it comes to the future of the workers of Tomago. That's the view of our Hunter MPs. That's the view of every member of the Cabinet. What we won't do, what you will not hear any one member of this government do, is stand at this dispatch box and celebrate the death of manufacturing jobs in this country. I'm old enough to remember that happening. I'm old enough to have been sitting there when a Treasurer of Australia goaded manufacturing to leave this country. I remember what that was like, and it won't happen on our watch. And nor will we say, as a Liberal government said the last time an aluminium smelter closed in Australia, the then Treasurer said, if you get entirely despondent about one business closing, you'll ignore the fact that at any other one time other businesses are opening, and that's the jobs of tomorrow. Well, I'm sure that made the workers of Point Henry feel a lot better when the Treasurer of Australia, Joe Hockey, said that at this dispatch box when the last time an aluminium smelter announced their closure in this country. Now, we will work with the workers, the owners, the unions and the business community of the Tomago community, of the Hunter community, to ensure not only that nothing is left on the field for the jobs of the day, but we are creating the jobs of tomorrow for them as well.
Before I call the member for Patterson, she can resume her seat. There was just far too much noise during that answer. Everyone's had a pretty good go. The member for Forest, Lyne, Gippsland, the Leader of the Opposition. I appreciate your interjections, but it's not going to continue. The member for Fairfax as well, I forgot him. Order. No. We're just not going to have that level of interjection. It's not a wall of noise. The manager of opposition business is warned, and if he interjects again, he will leave the chamber. No questions about that one. Okay. We'll now hear from the member for Patterson.
Thank you, Speaker. My question is to the Minister representing the Minister for Industry and Innovation. In light of reports regarding the future of the Tomago aluminium smelter, what is the Albanese Labor government doing to secure the Hunter's industrial future and ensure the Australian aluminium sector thrives?
The call to the Minister for Defence Industry and the Minister for Pacific Island Affairs.
Thank you, Speaker, and I thank the member for Patterson for her question.
Order. No, pause. The member for Fadden will leave the chamber. Interjecting like that before the minister has even said something is completely disrespectful and disorderly. For goodness sake. After I just told the chamber to lift standards, to have that carry on, everyone do better today. The minister has the call.
Thank you, Speaker, and I thank the member for Patterson for her question and her powerful advocacy for her community. Speaker, this morning Rio Tinto announced that it has decided to enter consultation on potential closure of Tomago aluminium in 2028. This is very tough news for my community, the Hunter, especially for the thousands of workers and their families. Let me be crystal clear. This consultation is a commercial decision taken by the business, and the government stands firmly with workers and the Hunter community. We're absolutely determined to explore every opportunity to secure new power purchasing agreements for the facility, because it's the right thing to do for these workers, it's the right thing to do for the Hunter, and it's the right thing to do for Australia. Speaker, the Hunter has been very good to Rio for decades, and it's time for Rio to do the right thing by the Hunter. We've made it very clear to Rio Tinto and the New South Wales government that we're here to support the facility if we have constructive partners. We continue to be in discussions with Rio and the state government on options for Tomago. Nothing is off the table. Let me repeat that, Speaker. Nothing is off the table. Australia is one of the few countries with a complete aluminium supply chain, and we're strengthening and growing every stage, fixing mining approvals while protecting the environment, securing affordable gas for alumina refineries through the gas market review, and backing our smelters with the green aluminium production credit.
Order.
This record $2 billion investment in the Australian-made aluminium industry is about supporting our industry to navigate the worldwide shift to new forms of electricity. We're working with state governments, industry unions and affected communities nationwide to secure the sector's long-term future. And we're doing this because it's in the national interest. And before we see people trying to reheat the tired old climate wars, Rio has been very clear. Energy supply offers based on coal power are too expensive. Speaker, we're standing with the Hunter to support our industrial future. We've already committed $850 million for a missile factory, an Australian first, $432 million for a major renewable hydrogen project, $100 million to make the Port of Newcastle hydrogen ready, and $60 million for a manufacturing centre of excellence. But the truth is, Speaker, a decade of energy policy failure by those opposite left the facility in energy policy limbo, and we're facing the consequences now.
Order.
Speaker, the Australian government will always stand up for Australian workers and businesses, and we can call on Rio to continue to work with us on every option to support the community that supported them for decades.
The Minister's time has concluded. Before I call the member for Curtin, I'd like to do some acknowledgement. I'm pleased to inform the House that present in the gallery today are representatives from the House of Commons of the United Kingdom Defence Select Committee led by Mr Tandeshi, the Committee Chair and Member of Parliament for Slough. I'm also pleased to report to the House that in the gallery today is a delegation from the France-Australia Friendship Group of the French National Assembly, led by the group's President, Mr Eric Worth. Accompanied by the delegation is His Excellency Ambassador Pierre-André Imbert, and also a delegation from the European Parliament, led by the Chair, Mr Sean Kelly. And in the Northern Gallery, an esteemed delegation from the screen industry, including some of Australia's most famous actors and producers. Welcome to you all. I'm going to give the call to the honourable member for Curtin.
My question is to the Minister for Communications. The rise of AI is making it hard to tell what's real and what's not, and Australians need to be able to distinguish fact from fiction online. The government has committed to developing a national media literacy strategy. What's the progress on this strategy, and will it deal with AI deepfakes and misinformation?
The call to the Minister for Communications and the Minister for Sport.
Thanks very much, Mr Speaker, and thank you to the member for Curtin for her question. We on this side of the House agree this is a really important topic, and we've been putting a lot of effort into the space of the future of news media, what online safety looks like, where this is going, how this dovetails into the work that we want to do with AI. It's a really interesting space, and I appreciate your interest in it. We really care about this issue, and I think we are very clear-eyed about the fact that AI is changing the landscape, and it is changing it very quickly. And whilst we on this side of the House want to make the most of every opportunity that AI presents us, we want to be a country that is seen across the world as being forward-leaning on AI and making the most of the opportunities, there are things that we need to do to make sure that our kids in particular and everybody who engages with it online has the kind of literacy and resilience needed to be able to make the most of those opportunities whilst being safe at the same time. That is why what that looks like is the $132 million that we have put into Newsmap to make sure that we have a strong and vibrant news media space in this country, particularly in regional areas. We have put money into the Alana and Madeline Foundation, which works with children in schools to improve digital literacy and trying to recognise what you said in your question around what is and isn't real online. And we've put money into Newshound, which helps students and schools work on news media and come up through the ranks, perhaps to one day meet the high calibre of the press gallery that watch us on now. It is an interesting space. I talk to the media students at places like East Doncaster that I was at with the member for Menzies recently. I think we can all agree that kids are swamped with what is happening. A platform like YouTube uploads 600 hours of content every 60 seconds. That is a reality that has been the case for some time now. That is not something new that we have time to prepare for, and that's why the News Media Literacy Plan that you referred to was announced by my predecessor as commencing this year, a program of work that we're looking to do over the coming 3 years, and I look forward to continuing that work.
Give the call to the member for Dixon.
Thank you, Speaker. My question is to the Acting Prime Minister. How is the Albanese Labor government delivering cost of living relief for all Australians? And has there been any opposition to this approach?
Call to the Acting Prime Minister.
Well, can I thank the member for her question and congratulate her on her wonderful speech last night. At the election, we promised to increase paid parental leave, and as of the 1st of July this year, we've increased paid parental leave by 2 weeks, and we'll increase it by another 2 weeks next year. In the 2022 election, we promised a real increase in the minimum wage, and just a few weeks later, one of the very first actions of our government was to do just that, and we did it again the next year and the next, and again this year. Indeed, the 3.5% wage increase for award workers this year has benefited 2.9 million Australian workers, and those on the minimum wage itself will receive an annual wage increase of $1,669, and that is at the heart of why we've got wages going again in this country after the lost decade of wage stagnation from those opposite. And at this election campaign, we promised the biggest boost in Medicare since its creation, leading to 9 out of 10 GP consults being bulk billed, and all of that begins next week on the 1st of November. Because with the Albanese government, we do what we say. When we promise, we deliver. And we are producing strong, unified adult government, and that stands in stark contrast from what we are seeing from those opposite. We have a former leader of the National Party, a Deputy Prime Minister of this country, now openly wondering whether he's going to leave the coalition and become a foot soldier in Pauline Hanson's One Nation. We've got the member for Canning sulking there on the backbench and sharpening his claws because of his shocked discovery that industry policy isn't a part of Home Affairs. We are watching an existential battle as those opposite wonder whether or not the coalition are going to join the world in producing a low-carbon economy or whether they are going to follow the National Party in simply declaring that climate change is one big hoax. They no longer speak with one voice. They are not a coherent political movement. They are just a bin fire. And that fire is burning so out of control that if they are not careful, it is liable to melt the bin. Well, on this side of the House, we are all about the Australian people. Our only care is for their safety, for their prosperity and for their interest.
Order. The member for Goldstein. The member for Wannon has the call.
My question is to the Minister for Climate Change. On 20 January this year, the Prime Minister visited the Tomago aluminium smelter where 5,000 local jobs depend on its future and told journalists, quote, "This is what a future made in Australia looks like." Yet today, Tomago aluminium said, and I quote, "Finding competitively priced energy remains a central challenge." How can Labor promise a future made in Australia when all it can actually deliver is higher energy prices?
Call to the Minister for Climate Change and the Minister for Energy.
Well, thank you, Mr Speaker. I thank the honourable gentleman for the question. We can more than promise a future made in Australia. We can deliver a future made in Australia because we believe in the opportunities for our great country. We believe in the opportunities for our great country in a decarbonising world, and we believe that the regions that have powered Australia for so long will power us into the future in a different way. And we believe that industries like aluminium need a need a supply of energy which is reliable, and we believe they need a supply of energy which is cheap, and that's why we are determined to continue the transition that's underway in this country, which those opposite would stop. They would stop if they had the opportunity. And again, the honourable member quotes the Tomago statement today, which I had already quoted, and I had already quoted because it says that the submissions they'd had from coal-fired power were uncompetitive, and that is true. And they also went on to say there is significant uncertainty about when renewable projects will be available at the scale we need. Now, that's unfortunate, but we agree we should have more renewables quicker. Those opposite would see less renewables across our country. Now, the Boyne Island smelter in Queensland has managed to get enough renewables. They've secured more than 2 gigawatts worth of renewables. That's a good thing. That is the future of aluminium smelting. The Tomago facility is in a different situation. As I said previously, this government, through the Prime Minister, the Treasurer, the Industry Minister, the member for Shortland and the Hunter members, will leave nothing on the table. We will continue the conversations with Tomago and with Rio, with the New South Wales government, to see if anything is possible to support this facility and to support the workers. And regardless of the outcome, we will be there for the people of the Hunter, because when the industrial change happens, it's important that government steps up. And this government will step up for the people of the Hunter. We will step up not only about Tomago, but about the other opportunities in the Hunter, because the people of the Hunter, having powered Australia for so long and having shaped so much of Australia's future, deserve nothing less. They don't need a minister at this dispatch box celebrating the departure of manufacturing jobs, goading manufacturing to leave, or saying, don't worry, another business will come along, which is what Joe Hockey said when the Point Henry smelter, the last smelter to close in Australia, announced their closure in 2014. That's what would happen if those opposite held the levers. It will not happen on our watch.
The call to the honourable member for Hughes.
Thank you, Mr Speaker. My question is to the Treasurer. What is the Albanese Labor government doing to ease cost of living and responsibly manage Australia's economy? How does this compare with other approaches the government is being asked to consider?
Call to the Treasurer.
Thank you, Mr Speaker. When the good people of Hughes elected their first Labor member in almost 3 decades, they elected an absolute champion for their local community, and I thank him for his question. As the member for Hughes knows, at the last election we were promised responsible cost of living help, and we promised to strengthen Medicare, and we are delivering. Whether it's slashing student debt, cheaper medicines, more bulk billed GP visits, cheaper early childhood education, tax cuts, protecting penalty rates, getting wages moving again, all of this is about easing the cost of living in the most responsible way that we can. And we're doing that at the same time as we're getting the budget in much better nick than we inherited from those opposite. And today the global ratings agency Fitch has reaffirmed Australia's AAA credit rating. And in doing so, Mr Speaker, Fitch acknowledged our efforts in paying down the debt that we inherited. They praised our focus on productivity, and they outlined the private sector recovery underway in Australia's economy. This is another powerful endorsement of Labor's responsible economic management. It shows and it reminds us that under Labor, Australia has one of the strongest budgets in the G20, Mr Speaker, and that's helping us in the fight against inflation. Now, we've made good progress in the fight against inflation. It's around half of what we inherited from those opposite, and that's given the Reserve Bank the confidence to cut interest rates 3 times this year. But we know that people are still under pressure, and tomorrow we'll get the latest inflation figures. The market predicts inflation, headline inflation, to tick up a bit tomorrow in the numbers because of the state energy rebates coming off. That's already been factored into the forecast of the Treasury and the Reserve Bank for some time. Inflation's ticked up for every major advanced economy in the world except the UK, where it is much higher than it is here. Now, we know that people are still under pressure. That's why our cost of living help, delivered in the most responsible way, is so important, Mr Speaker. We went to the election and we promised cost of living help, and we are delivering. We went to the election, we promised to manage the economy and the budget in the most responsible way that we can, and we are delivering on that front as well, Mr Speaker. Now, those opposite went to the election promising higher income taxes, bigger deficits and more debt, Mr Speaker. And since that election, they have learned nothing from the result. They haven't changed a bit. They are divided, they are divisive and they are in disarray. Well, this government is not distracted by the madness of the extreme right and the internal politics of those opposite. We will continue to focus on responsible economic management and cost of living relief. They are divided, we are delivering, and that's the difference.
Before I call the member for Flynn, I'm also pleased to advise that in the Speaker's gallery is the Honourable Wendy Machin, a former State Minister in the Fayette government and the first woman to chair the New South Wales Parliament. And I was a little early in recognising the members of the French Assembly who have now joined us. A very welcome to our French friends. We give the call to the Honourable Member for Flynn.
Thank you, Mr Speaker. My question is to the Minister for Climate Change and Energy. Yesterday, the Minister informed the House that 200 jobs could be lost with the possible closure of Gladstone Power Station in 2029. Can the Minister guarantee that thousands of jobs in the alumina sector in Gladstone will be safe under the government's renewable-only energy approach?
Call to the Minister for Climate Change and Energy.
Well, thank you very much, Mr Speaker. I thank the honourable member for his question, but I disagree with the premise, just like I disagree with him that climate change isn't primarily caused by human activity, Mr Speaker. I disagree on a number of fronts with the member for Flynn. And he has mischaracterised the government's approach to energy policy, because our energy policy does support renewable energy, backed by gas peaking, backed by storage and backed by transmission, Mr Speaker. But there is a certain irony to the opposition asking about the future of industry under this government's energy policy, because it wasn't that long ago those opposite went to the election, went to the Australian people with an alternative energy plan that involved a heavy reliance on nuclear energy. Now, the opposition, under the stewardship of the now Shadow Treasurer, told the Australian people that their plan was 44% cheaper. And when you looked at their plan, it only was 44% cheaper because it assumed 40% less energy use across Australia. Now, how would you possibly get to 40% less energy use in Australia? Well, there's only one way. There's only one way, and that is to assume no heavy industry in Australia, because that is a big part of our industrial use. They're modelling that the member for Fairfax masterminded.
Members on my right, I'd like to hear from the member for one on a point of order.
It was an incredibly important question about jobs, and I would ask the Minister to be relevant to the question.
Yeah, the Minister wasn't asked about anything the opposition had done. He can do some compare and contrast. He's done that, so the remainder of his answer won't be about what the opposition or the former Shadow Minister's done, because he wasn't asked about that. So he'll need to be directly relevant. If he's talking about opposition policies, he'll need to make it directly relevant to the question he was asked about the jobs in the member's electorate.
Sir, thank you. And it is clear and it is true that there is an alternative before the Australian people. And under this government, I can guarantee that we will ensure that energy policy is designed to ensure the supply of cheap and reliable energy, not only for Australia's households, which I'll get to later in question time perhaps, but Australia's heavy industry. Australia's heavy industry. And when we went to the election, we did not promise or assume that our energy use in Australia would halve from 45.9 terawatt-hours to 23.3 terawatt-hours. We did not assume that halving of energy use in heavy industry would occur. Now, the Tomago smelter uses 8.3 terawatt-hours of electricity. The only way you could achieve the outcomes promised by those opposite is to assume the closure of the Tomago smelter and the aluminium industry in the electorate of Flynn. That's the only way they could make their sums add up. That is not our approach. We will ensure a future for Australian industry while those opposite assume it disappears to justify their policy fantasies.
Call to the member for McEwen.
My question is the Assistant Treasurer and Minister for Financial Services. How is the Albanese Labor government strengthening Australia's superannuation system to ensure it's fairer, more sustainable and delivers better outcomes for low-income workers?
Call to the Assistant Treasurer and the Minister for Financial Services.
Speaker, I thank the member for McEwen for that question, and I'd like to acknowledge that he's been a champion for superannuation for many years. He's worked in the transport sector and he understands that it's so important to extend superannuation to sectors where there's varied work practices and hours. Speaker, Labor is the party of superannuation. Our priority is ensuring that superannuation delivers on its purpose of providing income for a dignified retirement. We have already implemented a number of reforms to strengthen the superannuation system over the term of government, including paying superannuation on government-funded paid parental leave, increasing the superannuation guarantee rate to 12%. Reaching 12% was the cherry on the top of decades of reforms by Labor governments. We are currently pushing forward with more important reforms to make our system fairer, including implementing payday super and a major boost to the low-income superannuation tax offset. First, on payday super, we know that for too long many workers have waited months to receive their super. Under Labor's reforms, from the 1st of July 2026, employers will be required to pay super at the same frequency as wages. This is a simple, practical change, but one that will make a huge difference to millions of workers. It means more frequent contributions, earlier compounding returns and stronger retirement balances for millions of Australians. The ATO estimates that more than $5 billion in super goes unpaid each year at the moment. That's money that should be sitting in workers' accounts, not lost from their future. For a 35-year-old who has unpaid super recovered, it can mean more than $30,000 more in their balances at retirement. This matters most for people who need it the most, women and low-paid workers who are more likely to be in casual or insecure work and who are more likely to miss out on super when it isn't paid promptly. The second reform is our boost to the low-income superannuation tax offset. We're increasing the listo by $310 so that it's up to $810. We're also increasing the threshold from $37,000 to $45,000 from 1 July 27. This means that if you earn $45,000 or less, you are not paying any tax on your super contributions. This means that you could benefit by around $15,000 in your balance by retirement, a huge difference. At the same time, we're ensuring that our super system remains sustainable and fair by better targeting concessions for very large balances. We are the party of superannuation. We'll keep working to strengthen it, to make it fairer and more sustainable, because all Australians deserve a dignified retirement.
Call to the Manager of Opposition Business.
Thank you, Speaker. My question is to the Minister representing the Minister for Industry and Innovation. The government has repeatedly refused to release the details of a secret departmental report obtained by the opposition under the existing Freedom of Information laws, which was given to the Minister for Industry and Innovation, titled Industry Facilities at Risk, Key Dates and Proposed High-Level Handling, given on 19 June 2025. Minister, how many Australian businesses are on this list of Australian industrial facilities at risk, and how many Australian jobs would be impacted should any of these at-risk facilities close?
We call to the Minister for Defence Industry, the Minister for Pacific Island Affairs and the Minister representing the Minister for Industry and Innovation.
I thank the member for his question. Given the very detailed nature of his question, referred to a document. I'm going to take it on notice and come back to you. That's the appropriate course of action for a minister representing another minister in this chamber.
The manager is seeking to table a document.
Given the nature of that answer, I seek to table the document, which is redacted. All the facilities are removed. You could get the original and give us the brief on which facilities are on this document.
You've asked the question. You're seeking to table a document. Is leave granted?
Appreciate the help, but we've already got it. We've already got it. That's the nature of a government document. Leave's not granted.
Leave is not granted. I thank the Manager of Opposition Business. And we'll hear from the member for Bass.
Thank you, Speaker. My question is to the Minister representing the Minister for Women. How will the Albanese Labor government's changes to the low-income superannuation tax offset support working women?
We call to the Minister for Infrastructure, Transport, Regional Development, Local Government and the Minister representing the Minister for Women.
Thank you very much, Mr Speaker, and can I thank the member for Bass for her question
but also just say to her what a delight it is to have her here in this chamber. It is such lovely to watch her developing into the job and the incredible compassion and care she is playing for young people and for women right the way through this country, but particularly for the people of Bass. It's always a privilege to stand in this House as a Minister of a Labor government and to talk about superannuation, because Labor is the party of super. We created it, we will always defend it, and we will always strengthen and make it fairer. The changes announced by the Treasurer will boost the low-income superannuation tax offset, the LISTO, by $310 to $810 and raise the eligibility threshold from $37,000 to $45,000 from the 1st of July 27. Because of these changes, in the 27-28 year, over 770,000 additional Australians will be eligible for LISTO, and over 490,000 Australians will receive a higher LISTO payment. And these changes will bring the total number of Australians eligible for LISTO to 3.1 million, of which around 60% are women. Women's economic equality is core business for this government, and now the government is delivering more to help low-income workers, predominantly women, by ensuring the superannuation system is stronger and it is fairer. And now, as I said, the CEO of Women in Super has called this a monumental victory for fairness in our super system. She rightly pointed out that this reform is particularly significant for women who form the backbone of our essential services: carers, education aides, hospitality workers, sales assistants and health workers. Our reforms have been welcomed by HESTA, with HESTA CEO Debbie Blakely saying this will help ensure more than 1 million low-income earners can build a more secure retirement and help create a fairer superannuation system. It, of course, builds on the foundations we've already laid in paying superannuation on paid parental leave, which started on the 1st of July. Paying super on the Commonwealth Parental Leave Scheme is benefiting around 180,000 Australian mothers each year, and around 95% of Commonwealth parental leave payment flows to women. This is what a good Labor government does. Make sure that we are looking after working and low-income Australians, making sure that particularly women can have the opportunity to have a safe and secure retirement, and that is exactly what the Treasurer has done with the expansion of the LISTO scheme to so many people, particularly women.
The call to the honourable member for Calare.
To the Treasurer. The government recently released its draft regulation on cash transactions, which only provides that cash has to be accepted for transactions of $500 or less and only at big supermarkets and major fuel retailers. With respect, it's a dud. It's the green light for the phasing out of cash in Australia. Why won't you support my private member's bill, which would apply to all businesses and all face-to-face transactions of $10,000 or less, and which would truly keep cash king in Australia?
Call to the Treasurer.
Well, thank you, Mr Speaker, and thank you to the honourable member for his question. The Albanese government is taking steps to ensure that Australians can use cash to pay for more of the essential items that they need, Mr Speaker. And in saying that, I acknowledge from the outset that the honourable member would like us to go further than we are proposing to go. There are good reasons why we've settled on the model that we have settled on, and I'll run through those reasons in a moment. But I remind the honourable member that there is currently nothing preventing any business in Australia from refusing to accept cash, and we consider that situation to be unacceptable. That is the status quo that we've inherited. That's the status quo that we are changing, because we know that cash still plays an important role in the lives of many Australians. Right now there's no obligation, and we're changing that. We take seriously the issues the honourable member and others have raised with us. Now, in 2022, we know that the Reserve Bank found that around 7% of Australians still use cash for the majority of their in-person purchases. But we also know that many of those cash users are older Australians, and also Australians living in rural and regional communities like those represented by the honourable member. So last year we said we would introduce a cash acceptance mandate for the first time. and we're delivering on that promise. From the 1st of January, we're ensuring that Australians can buy their fuel and groceries by mandating cash acceptance for essential purchases through a mandatory industry code under the Competition and Consumer Act. Now, this follows extensive consultation. Earlier this year, we received 61 submissions from organisations, 4,000 from individuals. We met with a range of organisations about it. Now, we know that there's a balance to be struck here between ensuring that Australians can use cash to pay for essentials, but also we don't want to place unnecessary burdens on small businesses, particularly small businesses in the regions. And after that extensive consultation, we think that we've got the balance right. Now, we've also committed to reviewing the mandate after 3 years to ensure it's functioning as it's supposed to. We'll consider then whether it should be expanded. We'll look at its impact on businesses of all sizes and any developments in cash distribution and access at that time as well. We do know that for many Australians, cash is more than a payment method. It can be a lifeline. That's why we are taking the steps that we are taking to make sure that more businesses in this country have to accept cash for essential items. And that is a very substantial change, a very substantial improvement on the status quo that we inherited.
Yeah. Give the call to the member for Adelaide.
Thank you, Mr Speaker. Mr Speaker, my question is to the Treasurer. What is the Albanese Labor government and the regulators doing to protect Australian consumers against misleading and deceptive conduct in the technology sector?
Give the call to the Treasurer.
Thanks, Mr Speaker. Thanks to the member for Adelaide, not just for his question, but for standing up for consumers in his beautiful part of the world and indeed right around Australia. Yesterday, the ACCC launched legal proceedings in the federal court against Microsoft for allegedly misleading about 2.7 million Australians when communicating subscription options and price increases after it integrated its AI assistant Copilot into Microsoft 365 plans. Now, since the 31st of October last year, Microsoft told subscribers it would renew subscriptions and customers would need to either accept it or cancel their subscription. And the ACCC alleges this was false and misleading because a third option wasn't disclosed. Now, Mr Speaker, whether it's the regulators or this government, we take these sorts of developments very seriously. This case is currently before the courts, and for that reason I won't comment on the specifics, but I will say this. There is no place for dodgy and deceptive behaviour like that being alleged in this case. If it's proven that this has happened, it amounts to deception on an industrial scale. So this week, the regulator has sent a powerful message to tech companies. We won't let Australians be treated like mugs. Now, Mr Speaker, I spoke to the ACCC Chair about these matters today. My office was briefed on Sunday. We're very grateful for the efforts of the good work of the people at the ACCC to safeguard Australian consumers. We're also helping them hold tech companies to account by increasing the maximum penalty for this kind of behaviour by 5 times to $50 million. But we also know, Mr Speaker, that the job is not done, and that's why we're doing more work to ban unfair trading practices under the Australian consumer law. Now, our changes will address a wide range of dodgy practices, including traps that make it difficult or confusing to cancel a subscription, hidden fees and charges at different stages of a purchase, deceptive or manipulative practices online, actions that make it difficult for people to report problems with their products or services. Now, this is about easing the cost of living and getting a fair go for consumers and suppliers. And here I want to pay tribute to my colleague, the Assistant Minister for Competition, for his work in this area. He's doing a mountain of work when it comes to the consumer law. I appreciate it. I pay tribute to him for that, and I thank him for that as well. He's just written to his state and territory colleagues to seek their agreement to these reforms. Mr Speaker, accelerating technological change is a big opportunity for Australian businesses and workers and consumers, but it can't come at any cost. We need to make sure it works for people, not against people. That's why so much of our economic policy is focused on maximising the benefits while we minimise the risks of emerging technology, including the work by the Minister for Industry, the member for Parramatta, and also this week on copyright by the Attorney-General.
Give the call to the member for Lyne.
My question is to the Minister representing the Minister for Industry and Innovation. James Strong, Tari's second largest private sector employer, produces aluminium cans from ingots produced by Tomago aluminium smelter. James Strong has seen its own energy prices surge by 65% over the last 4 years. The potential closure of Tomago has not only put at risk the future of thousands of Hunter jobs, but also the investment by James Strong in Taree. Will the minister admit that Labor's energy policy is killing local jobs and local manufacturing in the Hunter and in communities like Taree?
I'll hear from the Leader of the House.
Mr Speaker, we dealt with this yesterday, where the actual question at the end is on a different area or a different portfolio to where the question was directed.
Yeah, I'll hear from the manager.
Yesterday there was some confusion about some of the ministers answering questions. This is directly industry policy. Every industry in Australia is talking about their energy prices, every single industrial operation. So we're asking, yes, we're asking the industry representative about energy costs for industry shutting down in Australia. Yes, we are. Yes, we are asking that.
This is
it's valid. It can be. If you're the government, you can direct the question where you want.
The manager's made his point. Appreciate that. He is correct. This is a slightly different scenario where the Minister for representing the Minister for Industry is asking about the Minister for Energy's policy in relating to his portfolio. So that's totally okay. Order. I know you're trying to help. You're doing your best. But look, I'm just trying to help you as well. So help me help you. So what we're going to do is call the Minister. He can answer the question because the member for Lyne quite rightly has asked him a question about her electorate and the impact, and he can deal with that. And then if he wishes to, under the standing order, or under the practice, he can then defer to the other minister to add to assist the member's question. So the Minister representing the Minister for Industry and Science now has the call, and he may choose to allocate the remainder of the question to another minister responsible. Minister has the floor.
I thank you, Mr Speaker, and I thank you for the question about the future of the aluminium industry. As I said in an earlier answer, we're fighting every day to keep Tomago open. Yeah. We're working very hard with the state government in Rio, and we've said that every option is to be considered. Nothing is off the table, and we're working very hard because, as we said, the Hunter has been very good to Rio, and it's time that Rio is good to the Hunter. In terms of the broader issues around the aluminium sector, one issue your question went to is energy prices. So it's incumbent on me to point out where the wholesale price is at the moment. The current wholesale price in New South Wales is $70.58. When we came to power in May 22, it was $320 under your party. $320 compared to $70. So energy prices is one issue that we're all dealing with at the moment, but they've come down considerably at a wholesale level since we came into government. In terms of other industry policies, we won't be lectured on support for the aluminium sector by the Liberal Party. Let's remind people what's happened over the last few years. In 2014, when the last aluminium smelter was being considered for closure, which was Point Henry, what did those opposite do? They did nothing. They didn't engage with Alcoa. They didn't engage with the Victorian government. In fact, they cheered the closure of that smelter. Joe Hockey, then Treasurer, said we shouldn't be despondent about the closure of the Alcoa facility. And I table a news article quoting Joe Hockey saying we shouldn't be despondent about those jobs going. Almost 1,000 jobs went. Those opposite did nothing about it. In fact, they actively cheered it on. By contrast, we've got a range of industry policies to support the aluminium sector, from fixing mining approvals while protecting the environment.
Look, just resume your seat for a second. This will assist the House. The member for Wannon, I don't want to take your point of order because the minister was straying, but just as you probably agree with me, he's now talking about the policy he was asked about. If he strays off again, I'll be watching closely. How about that? The minister, in continuation, making sure he's directly relevant to the question he was asked about the member for Lyne to assist the House.
Thank you, Speaker. And as I was saying, we've got a range of policies to strengthen and grow the aluminium supply chain, from fixing mining approvals while protecting the environment, securing affordable gas for alumina refineries through the gas market review, and backing our smelters with the green aluminium production credit. We're going to keep working on this, and we're going to keep working with Rio and the state government to explore every option. Unlike those opposite, we don't cheer when manufacturing jobs go overseas. We don't dare them to leave. We fight for manufacturing jobs because every day we back Aussie workers, unlike those opposite, whose election policy was based on Tomago being closed down. That's what they think about manufacturing in this country. We get up, we fight for aluminium jobs every day like we fight for every manufacturing job, unlike those opposite.
Call to the member for Hunter.
Thank you, Mr Speaker. My question is to the Minister for Health. How is the Albanese Labor government making medicines cheaper for all Australians? How is this helping to improve the health of Australians with kidney disease?
Give a call to the Minister for Health and Ageing, the Minister for Disability and the National Disability Insurance Scheme.
Thank you, Speaker, and thanks to the Government Special Envoy for Men's Health for that question and for joining me and Kidney Health Australia at their terrific dialysis bus that visited the Parliament earlier today. More than 2.5 million Australians have kidney disease, Mr Speaker, but only 2.25 million of them don't even know it because, frankly, the signs and the symptoms of kidney disease usually only emerge after you've already lost about 90% of your kidney function. And that's why regular testing for Australians who are at high risk of kidney disease is just so important. People with diabetes, people with high blood pressure, First Nations Australians who are over the age of 18, Mr Speaker, because early detection allows patients to get the treatment that they need before they get to the point of kidney failure, which is going to require dialysis or even a kidney transplant. And there are terrific new treatments coming onto the market, Mr Speaker. Last year we listed Jardiance for a small limited group of Australians with a particular type of kidney disease, listed it on the PBS. But this week we are expanding that PBS listing dramatically, Mr Speaker. From Saturday, 70,000 more Australians will get access to this drug. Right now they're paying $60 a month. Pensioners like Peter, who joined the member for Hunter and me out the front of Parliament House, he'll just pay $7.70, not $60 a month, but $7.70 a month. And that's the magic of the PBS, Mr Speaker. The best medicines available around the world at affordable prices. And we're making those prices even cheaper, Mr Speaker. Already Australians have saved more than $1.5 billion at the pharmacy counter through our measures. And on the 1st of January, the price for general patients will drop even further to $25 a script, the same price it was way back in 2004. And for pensioners like Peter, they won't see an increase in their medicines prices for the rest of the decade, Mr Speaker. But returning to what I said earlier, you need to get the test to know if you need the treatment, Mr Speaker, and no one in this House does more than the member for Hunter, the Special Envoy for Men's Health, to encourage people to look after their own health, particularly Australian men who we know are particularly bad at it. Last month, he helped kick off the We for CKD campaign, CKD being chronic kidney disease, Mr Speaker, at a very big event up in the Mural Hall. And, Mr Speaker, you'll be pleased to hear he didn't just give a speech, he gave a sample as well, Mr Speaker, in the Mural Hall. And in a real high point, my time as Health Minister, he got me to hold the sample up for a photo. He's a hard man to say no to, Mr Speaker, just showing how determined we are to do everything we can to strengthen Medicare.
Give the call to the member for Indi.
Speaker, my question is to the Minister for Infrastructure. The Major and Local Community Infrastructure Program opened on 1 September as an invitation-only program, providing up to $560 million to identified projects. With the merit-based Growing Regions program now out of money, organisations and councils in my electorate are asking how they can be invited to apply to this program. Minister, how does a community organisation or local government secure an invitation to the Major and Local Community Infrastructure Program?
The call to the Minister for Infrastructure, Transport, Regional Development and Local Government.
Thank you very much, and can I thank the member for Indi for her question. As the member would know, and I have had numerous discussions with her about this, is that at elections, political parties make election commitments. And then under the grant rules, we are required to establish a program to then fund, assess and contract those election commitments. And that is what that fund does. That is the same way in which the Community Development Grants program of those opposite was supposed to be used, but if I'm asked about that, I might talk a little bit more about that as well. But of course, in terms of what we are delivering in community infrastructure currently, we are already delivering over billions of dollars of community infrastructure projects across our regions and our suburbs. Those programs have included $317.65 million through Thriving Suburbs for 30 projects, $587 million through the Growing Regions program for 110 projects that are currently being delivered, $67.6 million under the Urban Precincts and Partnerships program, and the $230.3.
Minister will pause. The member for Indi on a point of order.
Yes, thank you, Speaker. On relevance, I appreciate the list the minister's giving us, but the question was, how do our local councils and community organisations secure an invitation to this special program?
I think the minister did address that part of the question at the beginning of her answer. I was listening carefully where she specifically addressed the explanation, but I may allow her to continue and making sure she's directly relevant, but I think she did address that part of the question.
Answered your question in relation to that program and what the requirements of me under that particular program. But as I was saying, we are delivering billions of dollars of community infrastructure projects right the way through the regions and our suburbs. And I note in particular there are a number of projects being delivered in the member's own seat at the moment. She's done very well out of the Regional Precincts and Partnerships program and the Urban Precincts and the Growing Regions program as well. And those projects I know are incredibly important to her community because she's advocated very strongly for them. So from the Benalla Art Gallery, from the Lords Around the Ground package, the Eildon Maritime and Community Hub, Paul Cump Baseball Club, they are all projects that are being delivered in the member for Indi's electorate. And I could list projects right the way across the country in seats of those opposite, in the crossbench and over here as well. And that also comes on the back of this government's doubling of the Roads to Recovery funding, which is seeing an increase on the funding that those opposite provided, an increase for local road funding right the way across the country in our regional areas.
Yes, they'll hear from the Leader of the House before I call any other member.
Just to raise a point of order, under Standing Order 90, reflections on members. During that answer, there was a serious reflection of an improper motive made by the member for Goldstein, and it should be withdrawn.
I think to assist the House, if the member for Goldstein made a comment, may assist the House just to quickly withdraw and so we can move on.
I'll have to withdraw. Whatever.
Thank you, member for Goldstein. Order. Member for Goldstein's done the right thing and we'll move on. The member for Menzies has the call.
Thank you, Speaker. My question is to the Minister for Communications. How is the Albanese Labor government protecting the next generation of Australians from the harms of social media and giving parents across the country peace of mind?
Call to the Minister for Communications, the Minister for Sport.
I thank the member for Menzies for his question and for his generous invitation to East Doncaster State High School and his electorate to talk to media students there about Australia's social media minimum age laws. We had a thoughtful discussion about the importance of balancing online safety and keeping young Australians connected. And I hope that the students follow their passion for communications and media and become cadet journalists and maybe even one day join the illustrious heights of the Federal Parliamentary Press Gallery. Today marks 43 days. Look, again, Mr Speaker, the opposition gave interjections last answer as well about the calibre of the Federal Parliamentary Press Gallery, and yet again have done it here.
Order. The Minister will just order. Yeah, I want to hear from the manager.
No, the member just reflected on the opposition. We did no such thing. We've made no reflections either way. She's strayed from her answer and asked you to draw her back to it.
Yeah, maybe we just get back to the answer now, and I'm not sure what the issue is, but we'll just continue on with the answer without reflections on anyone.
Alrighty. Today marks 43 days until Australia's world-leading social media minimum age laws, which will see the minimum age to access platforms like Instagram, Facebook, YouTube, Snapchat and TikTok increase to the age of 16. This reform will not just change a law on 10 December, it will change a generation. It will deliver lasting cultural change, and it will protect young Australians going through a critical development of progress in their lives, and from predatory algorithms, from harmful content and from toxic popularity meters. It will give them 3 more years to actually have a childhood and to build community and identity and resilience in the real world. And it will offer Australian parents some peace of mind knowing they don't have to worry what their teenager is being exposed to on their social media account, because the Albanese government has their back. As one Australian mum told me, I have friends who are about to move to Australia. They have 2 daughters. Their eldest, who is 13, said she would need to get on Snapchat and Instagram when they move. The parents told their 13-year-old it would be illegal in Australia until she was 16, and her response was, well, that's fine. I only wanted to do it because I thought everybody else would be on there. That is the kind of cultural change that Australia can look forward to, and that is the kind of cultural change that Australia can be proud of. Mr. Speaker, we are not expecting perfection, but we are expecting social media platforms to understand and comply with their legal and social responsibilities and to make a meaningful difference. And to help Australian families prepare, we have launched a national education campaign airing on television, radio and digital channels across the country. The campaign points parents, carers and young people to helpful resources on the eSafety website. And in response to feedback I've heard from young Australians who are worried about how these laws will change their lives, last week I hosted a roundtable with the Assistant Minister for Mental Health and 20 frontline mental health organisations. They stand ready to help anyone who needs assistance with navigating this change, because we understand that cultural change can be difficult, but with 7 out of 10 young people experiencing harm online, this is too important not to act.
Call to the honourable member for Longman.
Thank you, Mr. Speaker. My question is to the Minister for Climate Change and Energy. Under Labor, significant industrial facilities have closed down, been bailed out by the taxpayer or expressing significant concerns about their future. Minister, will you apologise to the workers, their families and communities impacted by the government's failed energy policies?
Give the call to the Minister for Climate Change and Energy. The Minister has the call. The Minister for the Social Services is now warned. The Minister has the call.
Thank you, Mr. Speaker. What I will do is what every member of this cabinet will do, which is work every day in the best interest of working Australians, Mr. Speaker, to ensure that they have access to a brighter future, to ensure that they have access to the jobs opportunity created in a decarbonising world, to ensure that we don't repeat the 10 years of denial and delay which saw 24 coal-fired power stations announce their closure and the government of the day do absolutely nothing about it. That saw the government of the day put their head in their sands and pretend they could ignore the problem. And they left Australia's workers exposed, Mr. Speaker, and they gloated when an industrial facility closed. They goaded them into closing. At this dispatch box, the then Treasurer of Australia dared Holden to close their operations in Australia, which had existed for generations. The then Treasurer of Australia said when an aluminium smelter announced its closure, we shouldn't get too despondent about one facility closing. What an outrageous offence to the workers of Australia. Not something that will happen, Mr. Speaker, on our watch. What we will do is work every day with every ounce of energy we have to ensure that Australians have access to good, well-paying jobs, to ensure that Australia's natural advantages Our national advantages are seized as we embark on the path to net zero because we are unified in our belief in the benefits of net zero. We are unified in the belief that Australia's best days are ahead of us, and we are unified in our belief that we cannot return to 10 years of denial and dysfunction.
Give the call to the honourable member for Melbourne.
Thank you, Speaker. My question is to the Minister for Climate Change and Energy. How are homes, businesses and community groups embracing the opportunity of clean energy and acting on climate change? What policy proposals would undo that progress?
Call to the Minister for Climate Change and Energy.
Well, thank you, Mr Speaker, and I thank the member for Melbourne for her question. The member for Melbourne said to the people of Melbourne in May, let's put progress over protest, and the people of Melbourne responded with enthusiasm, and it's no easy task to defeat a leader of another party, and there are two people in this parliament who can tell us how it's done, Mr Speaker. The member for Melbourne is one of them, and the member for Melbourne asked me about Australians embracing opportunities, and Australians are making progress, with 101,942 households installing a cheaper home battery since the 1st of July. And you know what that means, Mr Speaker? Of interest to the member for Melbourne, that's more than the capacity of the MCG, which the member for Melbourne represents. When you consider that most of those households would have more than one person in them, that's even more. It's even more, but just on the number of households, that's more than the MCG can hold. And the other thing, Mr Speaker, is I told the House yesterday that we had added 2 gigawatt-hours of storage. Now, an interesting fact is that it took Australia 4 years, from the time we installed our first big battery, it took us 4 years to get to 1 gigawatt-hour. Australians working with their government have installed 2 gigawatt-hours in the last 4 months. Not 4 years, 4 months. That is real progress, that is real delivery, and that is real achievement. Now, I'm asked by the honourable member what could endanger this progress, and what could endanger the progress is an alternative government that doesn't know what the objective is, let alone what the pathway is. This is a party which went to the last election with a policy very different to ours and didn't get the memo from the Australian people, and has used every day since to argue about what the possible objective is. And we know that there were meetings today and meetings this week, and the Canavan review is due on net zero. We are all waiting with bated breath to hear what Senator Canavan could possibly think about net zero. He admitted on Insiders on the weekend that there's been no economic modelling. And the former leader, the member for Riverina, was asked how it's taking so long.
Order.
And he said, well, it's a process. It's not a McDonald's drive-through. You can't just turn up and ask the report to get it within 5 seconds of ordering. Well, you can work out in 4 months since the election or more whether you believe in climate change or not, I would posit, Mr Speaker. And the opposition spokesman was out this morning. He was asked when the opposition would finally declare their net zero, and he said, well, I hope before Christmas. I hope before Christmas. That's what I'm working towards. Well, I hope before Christmas, Mr Speaker, the opposition comes up with some policies. And I hope the number one policy is whether they believe in human-induced climate change. We know that plenty of them over there do not. And we know that they don't want to seize the economic opportunities of action on climate change. And we know that they want to go back to 10 years of denial and delay. Well, it's just as well there's an alternative, and that's the delivery that this government is delivering for Australian households and businesses.
Call to the Acting Prime Minister.
I ask that further questions be placed on the notice.
Order. If members can leave the chamber as quickly and as quietly as possible, we'll go to the Leader of the House with papers.
Speaker, these documents are tabled in accordance with the list circulated to the honourable members earlier today. Full details of the documents will be recorded in the votes and proceedings.
I have received a letter from the honourable member for Wannon proposing that a definite matter of public importance be submitted to the House for discussion, namely the failure of the government to cut power bills by $275, driving up costs for households and businesses. I call upon those honourable members who approve of the proposed discussion to rise in their places, and I give the call to the honourable member for Wannon.
Thanks, Speaker. In January this year, the Prime Minister went to the Tomago aluminium smelter. Now, there are 5,000 jobs that are dependent on this smelter. and he looked people in the eye. This is the Prime Minister. Looked people in the eye and he said, this is what a future made in Australia looks like. This is what a future made in Australia looks like. Now, for those 5,000 workers today, they want the Prime Minister back. They want the Prime Minister there, looking them in the eye again and saying, I am going to secure your future, and I am going to secure your future by reducing the price of electricity. And what they want also is that they want the Prime Minister to say that the Minister for Climate Change and Energy has failed in his job and will be moved, because they want some certainty, because everything that has happened under this minister has been all about energy prices going up. 39% for households and businesses. Now, what have Tomago Aluminium said? This is them quoted today. Finding competitively priced energy remains a central challenge, with electricity accounting for more than 40% of current operating costs. So what hope do they have if you have a minister who is recklessly pursuing a renewables agenda which he knows is going to continue to drive energy costs up? There is no hope. And how do we know that that's what's going to occur? Because we found it out today. He tried to hide the proof, tried to hide the evidence of what his department presented to him in the incoming minister's brief. Now, if you want a sense of how he went about trying to hide it, here's a couple of pages. Here is a couple of pages. Right.
I'll remind the member for Wannon. Member for Wannon.
This
you know
is
the rule
a
about
couple
propping.
of pages.
Put them down.
That is so. Now, on our side, we know that the minister is referred to as Blackout Bowen, as the Shadow Treasurer said. Now,
Excuse me, member for Wannon. I'm not going to let you go down this path.
So what we have, Deputy Speaker, now
you need to withdraw
evidence.
those comments.
I withdraw
Thank you.
that there are people on our side that refer to him as Blackout Bowen. I withdraw.
I'm going to remind the member for Wannon this is the Australian Parliament. This is a chamber with certain standards. What you say in your private business, I cannot control, but in this chamber, you are not going to do that.
So, Speaker,
I
withdraw. So what we see here now is a minister who is absolutely delighted to hide the truth from the Australian people. Now, it would be something which we could all laugh about if it wasn't so serious, because not only today are people worried at Tomago, but what do you think they're thinking now at Boyne Island, at Bell Bay? And I know that in my own electorate, where I have Portland aluminium, they'll also be looking seriously at this and wondering, well, is this truly what a future made in Australia looks like? And to get you a sense, to give you a sense of how out of touch this minister is, it's not only when it comes to smelters in Australia that we're seeing this, but even businesses tied to the very thing that he's been boasting about, and that is the renewable energy sector. Last week in the Daily Telegraph, we had a story about the owner of Janaspi Energy. Now, they were awarded, and we can't get any transparency around this, remember, $2.6 billion from the capacity scheme, right? You would think that this must be hugely beneficial to Australia. But he was asked, where is he going to source all his components from? And this was his response. He'd done nothing wrong. What's the big deal? We are an Australian company. The whole renewable sector is coming from China. Solar panels, batteries, we are just going to the source instead of through a third party. So this is a future made in Australia, according to the Minister for Energy and Climate Change. It is a future which is sadly collapsing before our eyes. Now, what should the minister do? It's pretty easy. What should the minister do? Well, the first thing he needs to do is drive energy prices down. He needs to drive energy prices down. Now, he could do that quite quickly. First, by simply stepping on the gas. Get more gas into the system and get it into the system immediately. And then the other thing he could do is he could work with the states and say, we're going to have to sweat our coal assets. We are going to have to sweat our coal assets, because that is the other way we are going to drive energy prices down. Now, there's two positive suggestions that the minister could take up right here and now to drive prices down. The third thing he could do is say that his 82% renewable energy target by 2030 is unrealistic, and everywhere else it's been tried in the world, it has driven prices through the roof. So you could say we have to stop and we have to reset and we have to change that. That would be three simple things that the minister could step in here and do, and that would give people a sense. That there is a future made in Australia, because at the moment there is deep concern that there isn't. I can tell you already through question time today, I have had text messages from manufacturers in this country saying that they are terribly worried, because this is the first nail, sadly, that they see in the coffin, and more are going to follow. Now, we don't want that sort of future for our nation. We want a future which is bright. We want a future where people have job security. We want a future where people know that energy prices are going to be affordable, where energy prices are going to secure jobs, where energy prices are going to drive manufacturing in this country. That is what we want on this side, and that is what we are going to keep fighting for. And why are we going to keep fighting for it? Because the jobs at those smelters, the jobs at those manufacturers, the jobs at the small businesses right across this nation are dependent on it. And we're already seeing that the job market here in this country is softening. And our worry, our huge worry, is that if that minister keeps up his reckless pursuit of driving energy prices through the roof, those jobs are going to continue to go. And everyone in this parliament should agree that that is the last thing that we want to see. Now, we have the minister who's going to reply and respond to this. Now, as I understand it on Sky today, that he said that they're going to reduce electricity prices by $150. Now, you're kidding. Now, yeah. So now it was going to be $275. It was going to be $275. So it's come back $125. But I look forward to him explaining exactly how he's going to do it. And while you're explaining it, can you explain what happened to the commitment where all of you looked the Australian people in the eye and said that you were going to reduce power prices by $275? Because if you had done that, and it was done 97 times, if you had done that, then we wouldn't be in this situation now, and people would not be worried about a future made in Australia disappearing before their very eyes. Yeah.
Just waiting for members to leave the chamber quietly, those that are leaving, and I give the call to the Assistant Treasurer and Minister for Financial Services.
Thank you, Speaker. Speaker, the last election offered a stark choice in a range of areas: health, economic management, infrastructure, but nowhere was that choice more clear and more stark than when it came to energy and climate change. And the two offerings at the last election saw one side offering a commitment to net zero, a commitment to a medium-term target, a commitment to a range of policies to help our economy move towards lower emissions with a range of price signals and investments, and with compensation, with rebates for households and small businesses doing it tough. The other side offering an ill-defined and poorly researched nuclear policy, all on the government's book, $600 billion, all publicly funded, very unclear as to technology, speculative as to technology, very unclear as to sites, and no compensation. So the choice was clear. What's remarkable, Speaker, is that since the election, the choice has become even more stark. Since the election, those opposite now even question a commitment to net zero, it seems, or they're unsure about it. Since the election, we've seen people go from the front bench to the back bench over this issue. Since the election, we've seen a former Deputy Prime Minister indeed threatening to leave one of the coalition parties over this issue. So since the election, I would say the choice is even more stark. Well, let's get to the nub of this motion. Let's get to the nub of the issue when it comes to households and small businesses. Who is better placed to manage electricity prices and the pressure they place on households and the pressure they place on business? And who is better placed to manage the transition of those prices? Well, let's look at the modelling. Let's look at the modelling by Treasury, by the AEMC, by business, right across the board. Let's look at the fact that the modelling all says what is better for prices is pricing that provides, is policies that provide certainty for business to make the investment we need for the transition. What is crystal clear is that the modelling shows that it is better to have an orderly transition than a disorderly transition. What is crystal clear is that it is better to have policies that enable a transition right across the economy rather than a rushed transition in an ad hoc way. Now, let me be very specific about some modelling which was released very recently, which makes this contrast particularly stark. It was Treasury modelling which looked at two orderly transitions and one disorderly transition. Now, I want to be clear about that term disorderly. It doesn't mean a transition by a disorderly opposition. It's a disorderly transition, but in effect, it's the same thing, Speaker. It's a transition which doesn't have an end point, which doesn't have a clear path along the way. Firstly, let's look at the modelling and what it says about an orderly transition. The modelling says that an orderly transition where you're sending price signals, where you have investment, wages go up, jobs go up, living standards go up. Australia is a beneficiary of the transition we need to have to net zero by 2050. Along the way, we see Australia benefit from cheaper and cleaner energy. There is a clear, credible path. Critically, when you have that clear, credible path, where you have investment signals being sent by policies that have a long-run horizon, you get business investing. And business has said right throughout the last decade, as this issue has been debated across this chamber, that one thing they need for investment decisions is certainty. They need long-term certainty in order to be able to make those investment decisions with confidence. So that's what the modelling says in relation to an orderly transition. What about a disorderly transition? And what does a disorderly transition mean? Well, a disorderly transition means that you don't set a medium-term target, that you don't take action in a timely way, that you don't adopt the kinds of policies that this government has adopted, like a capacity investment scheme, such as the safeguard mechanism, sending messages to business, such as investing in home batteries and electric vehicles. Tick on all of those for the opposition. So we are very much in disorderly transition territory when it comes to what the opposition is offering the Australian community. What we see with a disorderly transition is that energy prices spike. in the 2040s, not surprisingly, as the Australian nation and economy and society suffer from inaction. And this is exactly what we saw, by the way, the last decade they were in power. Almost a decade of inaction, almost a decade of no coherent framework when it comes to dealing with this very difficult and complex issue. So let's look at the modelling and what it says about a disorderly transition, which is what those opposite are offering, versus the renewables export upside scenario, which was one of the two orderly transitions. An economy which by 2050 is $2 trillion smaller. An economy where wholesale electricity prices are 50% higher in the 2040s because we are taking action late, because we are taking action in an uncoordinated way. GDP per capita, $4,500 less. That is the choice being offered between the government and the opposition. And so if those opposite want to have a debate about prices, they need to make clear to the Australian people why it is that a disorderly transition is in their interests. They need to make clear why it is that waiting till the last minute makes sense for the Australian public when clearly it doesn't. And all of the modelling says that. But in fact, we might be in a situation where those opposite are offering something even worse than a disorderly transition. The other scenario, which the Treasury modelling pointed to but didn't explicitly model, was abandoning net zero. And that seems to be something which a number of those opposite want to have on the agenda. That seems to be something which is all too often featuring in leaks that we read about in the papers or comments from those disgruntled from what they saw from the election. Abandoning net zero, not surprisingly, led to even worse outcomes than the disorderly transition. It led to less jobs, less growth, less and higher electricity prices. But of course, what it also means is abandoning net zero also means even worse outcomes for the environment. It means even worse outcomes for our planet and for our society. This is the choice that is being offered. Those opposite want to talk about prices, but all of the modelling is very clear that the best way to manage prices along the transition to net zero is to be as clear as possible about the endpoint, and we legislated that, and those opposite fought all along the way, but we legislated that. It's to have clear medium-term targets along the way, and it's to have a raft of policies that get you there. And as I've alluded to, we have clear endpoints. We have a range of policies that help the economy transition, including the Capacity Investment Scheme, which will lead to significant uptake in generation across a range of renewable technologies. We have the Safeguard Mechanism, which sends clear market signals across the economy so that abatement is achieved in a way that is spread widely across industries, so that it sends price signals so that abatement occurs in least cost ways. We also have a range of areas where the government is leaning in to particular sectors. For example, home batteries, which have been taken up by so many thousands of households. From 1 July, the Commonwealth's Cheaper Home Batteries program came into effect, providing an upfront discount of 30% on the cost of batteries. We've already seen tens of thousands of houses take advantage of this, which clearly complements a range of other renewables measures, such as solar energy. And then there's compensation, another clear area of difference between our parties. We went to the last election with a policy of a $150 rebate, an important measure for households. Over 10 million households and around 1 million small businesses will receive an additional $150 rebate on their bills from July 2025. And this adds to rebate measures which our government put into place last term, which those opposite fought tooth and nail every step of the way, and then raised questions about the inadequacy of our dealing with cost of living pressures. So, Speaker, in this motion today, what we find is an opposition that is raising an important, complex issue, frankly, in a disingenuous way. Because those opposite are offering the Australian people something they claim is simple, but something maybe that is simple but clearly won't work. And all of the modelling says that, the modelling by Treasury, by the independent regulators, by business. We need to have clear targets, clear signals and a transition that works for abatement and for our economy.
Member for Goldstone.
Thank you, Deputy Speaker. Deputy Speaker, Australia needs to afford energy. It's quite simple. Australian industry needs to be able to afford energy so that it can go on to be able to build out the future industrial capacity, to attract investments, so of course we can go on and build the jobs and economic opportunity so that Australians can get good-paying jobs, afford to buy their own home and, of course, be able to afford a secure retirement, because energy is the foundation of the economy. So it shouldn't really surprise anybody that when you have continuous price increases, it gets harder to attract the investment to continue to go on and build the industrial capacity of our country. And what we've had under this government as it's continued to constrain the volume of energy supply, along with the decisions of so many state governments, is price rises. Now, of course, Deputy Speaker, we don't oppose renewables at all as part of an industrial energy mix. It's a very important part of the industrial energy mix, but it's one part of our industrial energy mix. One of the strengths, whether it's the major hydroelectric investments that this side of Parliament has advocated for and built in the past, whether it is the baseload energy that we have advocated for and built in the past, whether it's, of course, building out the gas capacity for peaking that we have advocated for and built in the past. I remember the 2022 election where the delusions of the current Minister for Climate Change and Energy, he said that at Kurri Kurri we couldn't possibly have gas being built there. It must be hydrogen. Well, he's backed down from that because, unfortunately for him, energy responds to physics, not simply back down to what he wants to do or he wants to drive ideologically. Because energy does operate on physics and economics, and that's the basis in which we make our decisions about how to build out the energy capacity. Baseload has a role, gas and peaking has a role, renewables have a role, but we understand it must be part of a mix. My great-grandfather was a chief engineer on the First Lawn power station, and if you want to be able to have renewables, you need to be able to have baseload to back it in with other things like storage as part of a complex grid to be able to attract the investment to go on and build out the jobs you need. But when you only have a renewable energy only approach, you won't get that investment approach. And that's the path of dishonesty that this government is taking us down. And it's not just one that is going to have a short-term impact, it is going to be one that is going to sell out Australia's future. By only driving a solely renewable energy-driven focus into the future, Australia's future is being sold out with it because of the Albanese government. But let's not pretend that somehow what they say is what they do. Just like with the Victorian government or the New South Wales government, Deputy Speaker. They talk renewables, but what do? The Victorian government and the New South Wales government have secret contracts where they continue to subsidise coal. Let's look at the Albanese government, where they did exactly the same thing. They promised households $275 reductions in household bills, but then they gave coal generators and gas generators direct subsidies to pass on to households because they couldn't deliver on their promise. They did it so successfully, they even got the Teal members of Parliament who committed, ran on a platform of trust and integrity in public office and that they would abolish fossil fuel subsidies to vote with the government for new fossil fuel subsidies because they couldn't honour their promises around renewable energy. So the lectures that we are going to take from the government side, government benches, is net zero on energy, Deputy Speaker. Because we need a policy process that is going to deliver the industrial capacity and the energy capacity we need for industrial capacity for this country. Labor's plan was that they would reduce emissions, they would reduce prices and that they would reduce unreliability. The reality has been very different. They have increased emissions, they have increased prices and, of course, they've increased unreliability. What we need is a clear plan that mobilises capital, that brings prices down, that makes sure it addresses the issues of unreliability. And in the process, Deputy Speaker, if we achieve that, we will build out the social licence to reduce emissions as well. That's the basis in which we achieve long-term sustainable policy for energy, for emissions, and to build Australia's clean industrial future. Do that, and, of course, will drive the reindustrialisation of this country and create the economic opportunity that Australians so desperately want. Do what Labor's policy achieves, and we will continue to drive the madness of deindustrialisation.
Member for Bennelong.
Mr. Speaker, I mean, it's quite something to keep on coming into this place and seeing motions like this from the Liberals and the Nationals. I mean, only yesterday in another place up in the Federation Chamber, the Chief Opposition Whip was up there trying to push that great myth that the Liberals are the better economic managers, and that was in the face of the fact that they delivered 0 budget surpluses in their 9 long years in government. They were none from 9 when they promised to deliver 1 every year. And here today, in the House, they're doing the same with energy. The audacity they have, Deputy Speaker, to attack this government about credible energy policy when they couldn't land 1 in their 9 long years is quite something. I mean, I wish I had the confidence of a Liberal MP in opposition, Deputy Speaker, because they just keep on doing it. In this motion here again, once again today, it shows their incredible ability to totally ignore their record from their 9 long years in government. These are the same people who spent their time in government with no credible energy policy, who spent all that time ignoring expert advice, ignoring advice that 90% of all coal-fired power would close by 2035, and they did nothing to respond to that advice. Let's be clear. Their plans failed to invest in new energy, they failed to plan for the long term, and they failed to listen to the experts. And they come in here. So there's their audacity, but then there's the hypocrisy of it too, Deputy Speaker, because when this Labor government acted to provide energy relief to Australians and Australian small businesses, those opposite voted against it. 3 rounds of energy bill relief for homes and small businesses, they voted against that in 2022. Our action to cap coal and gas prices, to enforce an industry code of conduct for the first time, they voted against it in 2022. When it comes to energy policy, Deputy Speaker, the contrast between the Liberals, the Nationals and Labor couldn't be more stark. We listen to the experts on energy. We have a plan to overcome the challenges that this sector is facing, and importantly, we are delivering on it. When Labor came to government, wholesale power prices, and we heard it today from the Minister, over $300 per megawatt hour. Today, they're under $100 per megawatt hour. Over 10 million households and 1 million small businesses received energy relief that directly reduced the price of their power bills. And when it comes to adding new energy to the grid, something we desperately need to do, we're delivering the cheapest form of new energy as fast as we can. Deputy Speaker, since coming to government, we've approved over 100 renewable energy projects. That's enough to generate energy to power every home in Australia with the cheapest form of new energy, and it will reduce emissions to boot. These 100 projects will reduce over 53 million tonnes of CO2 each year, which is the equivalent of taking 16.7 million passenger cars off the road. Unlike those opposite who ignored all that advice, our plan is clear. We'll deliver new power to the grid and we'll choose the cheapest and cleanest form of new power for every Australian. We have a 2030 target of 82% renewable energy, and to get there, our capacity investment scheme is unlocking 32 gigawatts of renewable energy. Let's not forget, when they were in government, 4 gigawatts of energy left the system and only 1 gigawatt came in. We're underwriting 32 gigawatts of new renewable energy to go into the system because we know our industry needs it. We're rewiring the nation to deliver that energy where it's needed, and we're rolling out household assistance too, with Cheaper Home Battery Scheme, wildly successful, over 100,000 batteries since July, and for those households who couple that battery with a new solar system, saving up to $2,300 a year. Deputy Speaker, the opposition's energy plan is just pure fantasy. They don't have a plan for renewables. They fantasise about a plan for coal but don't deliver, and they're now hanging their hat on nuclear once again, which Australians rejected.
Member for Dawson.
Thank you, Deputy Speaker, and I rise today to support the member for Wannan's critical motion. And let's face it, it's another day and it's another Labor failure. The Australian people in 2022 were promised that if they were elected, if an Albanese Labor government were to be elected, they would have $275 per year cheaper power for their households. Now, what's happened? What has happened? Excess of $1,300. That's how much power has gone up under the Albanese Labor government watch. Now, the Australian people, they took the Labor Party for their word. They said, yep, we'll give you a go, on a premise of $275 cheaper power. But they just never followed through. Now, this wasn't a slip of the tongue. This was promised 97 times and not delivered. Now, I do a lot of mobile offices, listening posts when I'm going around my electorate, and the Australian people are doing it tough. They're living from pay to pay. And then, when they get their electricity bill, whether it be the end of the month or in 3 months, they're wondering how they can afford to pay for it. And they come to me, some of them actually come to me crying, how are they going to manage this Labor-created cost of living crisis? How do they pay their power bill? And this is after they were promised that power for their household would be $275 cheaper. Now, the flow-on effects with power prices, when you have your cup of coffee in the morning, you go down, try to buy a cup of coffee, small business, because this side of the house always supports small business, and they've had to put their their coffee prices up, because they've had to pay increase in power. So again, that drives inflation, and that is harder on your household budgets. Groceries, whether it be Woolworths, Coles, IGA, Aldi, they're big shops, but they pay enormous electricity bills. So what do they have to do? They have to increase their costs of their groceries, pass on to their consumers. So again, it's cost of living, it makes it harder. I've got pensioners in my electorate that are sweltering because they won't turn the air conditioner on or can't afford to turn the air conditioner on. Because for them, it's the choice between, if they turn their air conditioner on, they can't afford the electricity, and then they might not be able to eat. It's just not good. And Deputy Speaker, it's not just households, it's businesses. A business in my electorate, Blue River Ice, their power bill has just gone from $10,000 per month to $25,000 per month. And the owner of that business, Francis Vigilante, has told me it's not sustainable. He's done everything possible to try to make his business sustainable. He's put a robot in to pack some ice. He's got advanced refrigeration. He's even got solar on his roof. Now, trigger warning for those opposite, solar doesn't work at night. And he's got a 24/7 business. That is why I knew it would be a trigger warning, because those opposite clearly don't get it. That's why you need baseload power, power that's available 24/7, not just when the sun shines and not just when the wind blows. So, Francis, we're doing everything we can on this side of the House to show the government what they need to do, but it's very, very tough. And as Shadow Minister for Manufacturing, Assistant Manufacturing and Sovereign Capability, every business I go to, they're talking about their energy costs. Their energy costs are going through the roof. And that's purely because of Labor's reckless race to renewables and renewable-only approach that's driving power through the roof. So I ask those opposite, if renewables are so cheap, why is the power prices going through the roof? Why are they skyrocketing? It's just absolutely ridiculous. That's why on this side of the House, we are committed to nuclear power, no emission technologies, baseload power that will provide power 24/7. We're committed to manufacturing jobs, families, communities, not those opposite that are driving the manufacturing offshore. Those opposite are driving the manufacturing industry offshore. It's not good enough. Please do better.
Member for Dixon.
Thank you, Speaker. I'm really concerned about the member for Wannon. I'm really concerned that he might be suffering from some sort of amnesia, memory loss, lack of sleep, or maybe he's just terrible with the numbers. And I'm also now concerned that the member for Dawson might be suffering from the same kind of condition, because everyone in this place knows that the Albanese Labor government has consistently rolled out energy bill relief in the past 4 years. 2023, 2024, 2025. Deputy Speaker, we've delivered not one, not two, but 3 rounds of energy bill relief to homes and small businesses. In 2023, we provided rebates of up to $250 for pensioners and those receiving government benefits, and $324 to small businesses. Then in 2024, we rolled out $3.5 billion in energy bill relief, $300 for every household and $325 for small businesses. And this year, we are delivering an extra $1.8 billion in energy bill relief, giving every household and around 1 million small businesses a $150 rebate. This is targeted, meaningful help that will make a real difference for families and businesses in Dixon and across the nation. Not only are we taking the sting out of bills, but our energy relief rebate is expected to directly reduce national headline inflation by about 0.5%. The Albanese government has also acted to cap coal and gas prices, shielding Australians from the global energy crisis. Those opposite voted against that too. Households can now get 30% off the cost of installing a home battery, helping families take control of their energy use, lower their bills and contribute to a cleaner future. Already, 760 households in my electorate of Dixon have installed home batteries through the Cheaper Home Batteries program to store their sunshine and power their homes, saving them money off their electricity bills. And we're not just helping with electricity bills, we're helping families by strengthening Medicare, investing in housing, education and clean energy. We are providing real, tangible cost of living relief for Australians, while also investing in the cheapest form of energy, renewables and batteries. We're rolling out critical investments in renewable energy because the sun and the wind don't send a bill. This is in stark contrast to the Coalition's miserable approach. Not only did the Coalition change the law to hide a 20% hike in electricity prices before the 2022 election, those opposite disgracefully then went on to vote against energy bill relief for millions of Aussies. I'll say that again in case you missed it, in case you're lacking sleep or you've had some sort of memory loss. Those opposite voted against reducing electricity bills for millions of Australians. And the member for Dawson says that you will always support, that those opposite always support small businesses, but you did not support energy bill relief for small businesses in 2023. You voted against it. In the first half of 2025, renewables supplied more electricity globally than coal, and it's why 1,000 Aussie households a day are installing one of Labor's cheaper home batteries. The member for Wannon and the Coalition voted against Aussies struggling with the cost of living when they voted against energy bill relief. The people of Australia, we know, overwhelmingly voted at the last election for cheaper renewable energy, for a cheaper renewable energy focus future. They did not buy the hocus-pocus nuclear policy of those opposite, But of course, those opposite are hell-bent on ignoring that. And at the election and to this day, you know, they say the solution to Australian energy bills is the most expensive and slowest energy possible, nuclear. It's 2 to 6 times more costly than renewables. So while those opposite are arguing amongst themselves...
Giving the call to the member for Casey.
Thank you, Deputy Speaker. Well, I think it's important we look at a couple of facts when we come to energy prices. Fact one, the now government, then opposition, promised $275 price reduction 97 times before the 2022 election. So before that election, when they were in opposition, they promised it 97 times. As soon as they were elected, they did not make that commitment again. And when we raised this in the last term of Parliament, some of those on the backbench interjected and said we promised it by 2025, we would get it by 2025. Well, as we stand here at the end of October in 2025, I challenge those opposite to name one member of their community that has seen their power prices be reduced by $275 since 2022 when you were elected. There is not one. Solar batteries, we'll get to solar batteries. To get the benefit of solar batteries, you've got to spend $9,000 to get the benefit. Not everyone has $9,000 in the back pocket to pay for solar batteries. And we talk about the rebates, temporary one-off rebates because you're completely failing the Australian people and the energy system does not provide sustainable relief for those opposite. The member for Dixon was very quick to talk about the rebates. Well, what's the member for Dixon going to tell her community in January of 2026 when there are no more rebates and energy prices are up? As confirmed by Treasury, the RBA Governor, everyone opposite. Temporary relief helps when you've got no chance to get sustainable prices down, but when they run out, the Australian people are paying the price. So I look forward to being back here in February to see what line the government have, because they've run out of the temporary relief. The other promise they made at that time in 2022 was that same modelling, Reputex. They don't talk about the Reputex modelling anymore. There was 2 parts to that modelling: reducing prices by $275 by 2025. Failed. They also said in that modelling they would get emissions down by 2030, 42% emissions reduction. As we stand here today, they're going to fail on that target as well. I know the member for Dawson warned a trigger warning. I'm going to give them another trigger warning that I know they don't like. The member for Bennelong I know gets upset about this as well. Under this government, under the Albanese Labor government, who have been in power since 2002, 3.5 years, emissions flat, 2022, flatline since 2022, have not reduced emissions at all, this government. So they talk about energy. On the 2 key pillars, they have failed. They have failed to reduce prices and they have failed to reduce emissions. And that is why we have a situation where there is $300 million of energy debt in this country. The community members in Casey and every community in this House are dealing with $300 million in energy debt. And that has happened under this government. 3.5 years in power, $300 million in energy debt. We can talk about a number like that, but what does that mean when we talk about individuals? It talks about the pain that they are having. And I'll just use one example. I could talk for hours about the examples I get from my community, but Robert from Millgrove wrote recently, and I quote, "I just received an email from Red Energy saying that my electricity charges will be increased. When will the price rises on everything stop? My wages are not being increased, so every year my standard of living decreases." Robert is an example of so many people in my community and so many others that are paying the price for the failures of this government. And the reality is The Minister for Energy and Climate Change can stand up in question time, refuse to answer the questions about the challenges business faces, the challenges community faces, but that's the political spin and the theatre of this place. It doesn't provide solutions for our community members that are paying the price for their failures. Eventually, you can spin and spin and spin and talk about the opposition from 3.5 years ago. The community want real solutions.
Has expired. Member for Sturt has the call.
Thank you, Deputy Speaker. We've heard the claim today about the government's approach to energy, but let's be clear. The Albanese Labor government is delivering real, targeted relief to households and small businesses in parallel with laying the foundations for a cleaner, cheaper and more reliable energy future, one of the greatest industrial transformations in generations. From 1 July 2025, every household and around 1 million small businesses have received $150 in automatic energy bill rebates, on top of the $300 already delivered last financial year. And these rebates have helped drive down electricity prices by an estimated 7.1% nationally. But this just isn't about rebates. This is about transformation. Right. And South Australia is leading the way. In my great state, we're on track to reach 100% net renewable energy by 2027, with billions invested in large-scale renewables and more in the pipeline. Recently, the 412-megawatt Goyder South wind farm outside of Burra in the regional Clare Valley was inaugurated. It's the largest in the state, with 75 turbines boosting wind generation in South Australia by more than 20%, powering homes and businesses, including BHP, which will draw energy from the wind farm. It's forecast to produce roughly 1.5 terawatt-hours of renewable energy each year. And as of 1:30 p.m. today, the Australian Energy Market Operator Fuel Mix Dashboard showed that in South Australia, 48% of our energy was being generated by wind. The generation cost, Deputy Speaker, of wind energy, of course, and solar energy are next to zero. We know that more renewables there are in the system, the less we need to depend on unreliable, dirty, coal-fired power and gas over time, which will provide additional cost relief on energy bills. The energy transition away from fossil fuels to renewable energy is one of the greatest industrial transformations in over a century. It requires investment from all parts of this country, from the federal government to state government to local governments, to businesses, industry, communities and individual Australians. Our net zero targets are ambitious, but our planet demands that we work together to achieve them and go beyond them to the extent possible. In my electorate of Sturt, this is what my community is asking. Asian Australians for Climate Solutions, Electrify Adelaide, Mums and Grandmas for Climate Action, STEM for early learners, countless individual constituents. Transitioning to renewable energy as quickly as possible is what my community is calling for, loudly, because my electorate understands that the transition to renewable energy is both an environmental and economic imperative, and in Sturt, people are acting. Under the Albanese Labor government's Cheaper Home Batteries scheme, 1,606 households in Sturt have taken up the offer, making us the silver medal winner across the entire country. We have a community battery at the Tukawira Reserve, which provides energy to multiple Housing SA tenants in McGill and surrounding suburbs, giving them access to electricity stored in that community battery through South Australia's virtual power plant. The battery stores excess renewable energy from the grid when it is abundant for use at later times when demand and cost is high. By doing this as part of South Australia's virtual power plant, it delivers renewable energy and the cheapest residential electricity rate in South Australia to eligible low-income households. Since it came online, it has driven down annual power prices for these households by an average of $562. And we're seeing this transformation in our community spaces too. At the Hectorville Sports Club, a vital hub for children's sport and community participation, we've supported the installation of a 60-kilowatt solar system with battery storage through community grant funding. This project is cutting emissions, lowering energy costs and strengthening the club's long-term sustainability, showing how local action with federal support can deliver national impact. So let's not fall for the politics of pessimism. Let's recognise the progress we've made, reflect on the fact that there is more work to do and that this will be a complex transition, but it's also a necessary transition. Let's work together to deliver energy security for all Australians.
Member for McPherson.
Thank you, Deputy Speaker. I rise in support of this MPI as it's an issue hitting home for families and businesses right across our nation. When Anthony Albanese and Chris Bowen promised every Australian household a $275 cut to their annual electricity bill by 2025, Australians took them at their word. They believed, as any fair-minded person would, that relief was coming. Instead, power prices have surged by almost 40%. No family budgeting for groceries, rent or a mortgage can absorb that kind of a blow. Energy is a driving force in Australia's cost of living crisis, and this government's pushing families, industries and working Australians to breaking point. In my home state of Queensland, regional Australians are paying around $2,810 a year, while households in the southeast face bills of $2,766. These aren't luxury expenses. They're basic costs of keeping the lights on, running the fridge, doing a load of washing, or as we head into summer, deciding whether to stay cool or save on the air conditioning. For Labor members to stand in this chamber and congratulate themselves on their failed energy policy shows just how profoundly out of touch they are with the lived reality of everyday Australians, particularly those running businesses. We've seen the chaos unfolding for Tomago, who's predicting its energy prices will be unsustainable by 2028. BHP CEO Mike Henry has spoken about energy prices here in Australia being 2 to 3 times that of comparable nations. And what does that mean? It means that businesses and jobs will go elsewhere. Investment will flow out. Deputy Speaker, the government knows its plan isn't working, and yes, yet they press on, blind to the pain being felt in households across this nation. That's not governance. It's negligence dressed up as ideology. We all share the goal of reducing emissions. That's not in dispute. But when something isn't working, you cannot charge ahead at the detriment of Australian families, industries and jobs. Labor's reckless approach has delivered no meaningful reduction in costs or emissions, with national emissions today sitting at the same level as when the Coalition last left office. And we're yet to see this government's plan to provide a real solution to the transmission, distribution and storage questions that need answering. And on storage, battery storage, the supposed fix, can only supply a few hours of charge. You cannot run a modern industrial economy on Labor's plan. The government's own department has told them gas is critical to reliability because it can be dispatched when renewables underperform. But Labor's policies have made that harder, not easier. The ACCC has repeatedly warned of supply constraints and regulatory delays that drive up prices. Gas exploration acreage released in 2022 wasn't awarded until 2024, an extraordinary 2-year delay. And when it comes to coal, uncertainty reigns. Investors don't know when they can invest, and operators don't know when they must close. That's why state governments are now stepping in to clean up Canberra's mess. Queensland will use its coal assets until end of life to stabilise prices. And in New South Wales, the Eraring Power Station, our largest, supplying 18% of the state's electricity, was meant to close this year. Instead, the state government has had to strike a $450 million loss-sharing deal to keep it open until at least 2027. So much for the energy transition being under control. These aren't abstract numbers, they're jobs. Glencore's Mount Isa copper smelter needed a massive subsidy just to survive. And Rio Tinto's Gladstone Power Station, which powers the Boyne Island aluminium smelter, could close by 2029. When manufacturing collapses, it's not just GDP that suffers. It's pride, purpose, and the livelihoods of whole communities. Subsidised renewables get priority dispatch, forcing traditional plans to operate below capacity, eroding both profitability and grid stability. Deputy Speaker, this is what happens when ideology trumps engineering.
Member for Gorton.
Thank you, Deputy Speaker. I rise to speak on today's MPI, and there's been some really interesting rhetoric in this chamber this afternoon indeed. I'm really proud to represent one of the fastest growing electorates in the country. My community is young, diverse and growing every day. I've met thousands of families in my community who are experiencing cost of living pressures at the moment. If the Coalition think we don't understand cost of living relief for real Australian families, they are out of their minds. Real cost of living relief for families has been at the forefront of our policy agenda this term of government and the entirety of our last term of government. We are taking significant steps to reduce the household budget. We are taking strong action to provide energy bill relief to Australian households and businesses. When it comes to power bill relief, we've provided 3 rounds of energy bill relief for homes and small businesses to take the sting out of bills. We're providing up to $1.8 billion to extend the energy bill relief for another 6 months until the end of 2025, bringing the total energy bill relief fund commitment to $6.8 billion. And over 10 million households and around 1 million small businesses will receive an additional $150 rebate on their bills from July 2025. My team and I have visited the Taylors Hill Retirement Village a number of times to sit down with our seniors and to help them complete their energy bill relief application forms. Many of them told me how much of a difference this cost of living measure has made on their household budget. And it is real cost of living relief. It's more money in the pockets of more Australians. We've provided this energy bill relief while at the same time doing the overdue reform work to bring down bills for good. We've also acted to cap coal and gas prices, shielding Australians from the worst of the global energy crisis. And in the longer term, we're rolling out critical investments in renewable energy because the sun and wind don't send a bill. And we've acted to make the energy market fairer. Our new rules coming into effect in 2026 will make sure retailers aren't ripping off customers. Changes include banning unfair fees and card surcharges, stopping sneaky price hikes and making sure customers who are facing financial hardship are receiving the best price the retailer has to offer. And then there's the upfront discounts of around 30% off the cost of home batteries. In Gorton, we've seen an uptake of cheaper home batteries in 571 homes. 571 homes with more money in the pockets of Aussie families. On this side of the House, cost of living relief matters, and we have the track record to prove that. We have taken strong action to provide energy bill relief to Australian households and businesses, and those opposite have opposed this relief at every step. A decade of inaction has compromised our energy grid, and when those were last in government, they had more than 20 different policies across a decade. No one knew the direction, no one could plan, and no one could invest. And that confusion around net zero shows that those opposite haven't learned or done the work necessary to go in and create the right policies to solve this issue. The former coalition government left Australians without a power system, overexposed to offshore price shocks and overly reliant on ageing and increasingly unreliable coal plants. They ignored the experts and refused to take advantage of our abundant sun and wind. They left households paying the price for a grid that's too reliant on expensive, unreliable, ageing coal. And at the election, and to this day, they say that the solution to Australian energy bills is the most expensive and slowest energy possible, nuclear. And the member for Dawson restated the Coalition's support for nuclear just moments ago. The Coalition has opposed energy relief at every step. But it's not just that. They voted against energy bill relief. They voted against cheaper childcare and against cheaper medicines. They voted against cheaper healthcare. And we're getting on and delivering for all Australians. Only Labor has invested in reliable, affordable and clean energy, backed by experts and the Australian community, because we know that our communities and our communities know that when it comes to cost of living relief, they can trust Labor.
Thank you, and the time for discussion has now concluded. I have received messages from the Senate returning the following bills without amendment or requests: Appropriation Bill number 1, 2025 to 2026 without requests, Appropriation Bill number 2, 2025 to 2026, and Appropriation Parliamentary Departments Bill number 1, 2025 to 2026. The following message from the Senate has been received. The Senate returns to the House of Representatives a bill for an act to amend the law relating to telecommunications and for related purposes, and informs the House that the Senate has agreed to the bill with the amendment in the annexed schedule. The Senate requests the concurrence of the House in the amendment. I give the call to the Minister for Communications.
Thank you, Deputy Speaker. I move that the amendment be considered immediately.
I will put that question. All those of that opinion say aye. To the contrary, no. I think the ayes have it. Minister.
All right. Thank you, Deputy Speaker. At the outset, I would like to thank everyone who has contributed to this debate and consideration of the Telecommunications Legislative Amendment 000 Custodian and Emergency Calling Powers Bill 2025, both here and in the other place. The bill returns to the House with a single amendment, being to insert penalty provisions for failing to comply.
Minister, can I just interrupt? I'll need you to move that the amendment be agreed to at the beginning. So, no. Sorry. We've had the amendment be considered immediately question, and I now, you would rise to move that the amendment be agreed to. I'll put that question and then the debate can ensue. So could you just go to the dispatch box and move that the amendment be agreed to?
Deputy Speaker, I move that the amendment be agreed to.
Thank you. I'm going to put that question. Oh, sorry, my fault now. How about you debate and then we'll do I'll put the question after that.
Thank you, Deputy Speaker. The bill returns to the House with a single amendment, being to insert penalty provisions for failing to comply with an emergency call service direction or the emergency call service determination. I would like to thank Senator Hanson-Young and the Greens for engaging constructively on this amendment. I also thank the Coalition for their proposed amendments and valuable contributions to the debate. Although those amendments were not taken up, we all appreciated the engagement of the Shadow Minister and her office. These reforms will ensure the government has the appropriate powers to maintain effective oversight of the 000 service and will strengthen ACMA's role as an active participant in the 000 ecosystem while enshrining the custodian in law as a coordinating body for the management of the end-to-end 000 ecosystem. This bill acts on the tragic lessons of past outages to the 000 system by establishing into law the powers and functions of the 000 custodian. The custodian will support the effective functioning of the 000 system, ensuring all persons can maintain trust in its operation and that first responder services will be accessible in the event of an emergency without impediment. Deputy Speaker, I commend the bill as amended to the House.
Thank you, and I will put the question that the amendment be agreed to. All those of that opinion say aye. To the contrary, no. I think the ayes have. Oh, my apologies. Seeking the call, Member for Ryan.
Thank you very much, Deputy Speaker. Thank you very much, Deputy Speaker, and thank you, Minister. 000 is one of our most essential services. If it doesn't work, people die, and that's exactly what's happened. The recent outage, the second in just a few years, caused at least 3 deaths. 600 calls went unanswered. 600. Optus pays no corporate tax in Australia, despite their $8 billion in revenue from Australian customers. This is an industry that's been privatised under the watch of Labor and the LNP, including privatisation of 000, an essential service. The regulator, ACMA, has proven itself a toothless tiger. Thanks to our Greens amendments, we have tripled the penalties on telcos who fail to deliver 000 services to $30 million. This is just the first step. We will keep fighting for much more and for holding Optus to account for their serious, deadly failures. Here is a message to all telcos. The Parliament is keeping a close eye on you. You are meant to deliver an absolutely essential service, and it is not good enough for you to put your profits ahead of the safety of your customers. Thank you, Deputy Speaker.
Thank you. So I am going to put the question that the amendment be agreed to. All those of that opinion say aye. To contrary, no. I think the ayes have it. And just a minute. I call member for Fisher.
Thanks, Madam Deputy Speaker. On behalf of the Parliamentary Joint Committee on Intelligence and Security, I present the committee's advisory report on the Criminal Code Amendment State Sponsors of Terrorism Bill 2025, and I ask leave of the House to make a short statement in connection with the report.
Is leave granted? Thank you. Member for Fisher.
Madam Deputy Speaker, I rise today to present a report on behalf of the Parliamentary Joint Committee on Intelligence and Security for its review of the Criminal Code Amendment State Sponsors of Terrorism Bill 2025. The bill would amend the Criminal Code Act of 1995 to create a new legislative framework enabling the Governor-General to make regulations specifying an entity as a state sponsor of terrorism if the minister responsible for the Australian Federal Police is satisfied on reasonable grounds that the entity is a foreign state entity and the entity or a member of the entity has directly or indirectly engaged in, prepared, planned, assisted in or fostered the doing of a terrorist act that was targeted at Australia, or has advocated the doing of a terrorist act that was targeted at Australia. Before any regulations are made listing an entity as a state sponsor of terrorism, the AFP Minister must obtain the Foreign Affairs Minister's agreement in writing to the entity being specified for the purposes of that definition and arrange for the Leader of the Opposition in the House of Representatives to be briefed in relation to the proposed regulation. The bill would introduce new offences to criminalise terrorist activity engaged in by listed state entities, either directly or through a non-state actor, and conduct by persons who would seek to support or assist such activities. In order to address potential consequences of criminalising state entities, the bill includes defences and exemptions intended to protect lawful engagement with listed entities for legitimate purposes, including humanitarian assistance. The committee received 15 submissions to its review of the bill, most of which expressed support for it in whole or part, and held a public hearing on the 16th of October 2025. We're grateful to those who provided evidence to the inquiry in what was a very short time frame. Madam Deputy Speaker, it's no secret that this bill follows ASIO's revelation in August this year that Iran's Islamic Revolutionary Guard Corps, the IRGC, had directed at least 2 attacks in Australia in 2024. These important amendments intend to strengthen Australia's counter-terrorism framework and create an environment in which it is more difficult for malicious foreign actors to cause harm to Australia and Australians. The committee has recommended that the bill be amended to ensure that the Intelligence Services Act 2001 gives the committee the ability to monitor and review AFP counter-terrorism functions in relation to the new Part 5.3a of the Criminal Code, to the same extent that it currently monitors and reviews such functions in relation to non-state terrorist organisations under the existing 5.3. The committee otherwise supported the bill and recommended that it be passed. Madam Deputy Speaker, before concluding, I want to make one final point, and this is probably as my last job as the PJCIS Deputy Chair. It's deeply concerning that once again this government has chosen to ram complex national security legislation through the PJCIS under impossible timeframes. In less than 3 weeks, submissions had to be called for, a public hearing held, evidence reviewed, a report drafted, cleared by security agencies and then tabled in Parliament. That is not proper scrutiny. It is a box-ticking exercise. The PJCIS was once regarded as the most respected and bipartisan committees in the Parliament, the cornerstone of national security oversight. Yet this government continues to undermine that legacy by overloading the committee and forcing it to rush legislation that affects the safety, rights and freedoms of Australians. Madam Deputy Speaker, our national security laws deserve respect, not political expediency. Enough is enough. The government must start giving this committee the time and space to do its job properly, because if we get these laws wrong, the consequences could be devastating. I want to thank anybody and everybody that put in submissions to this report, and I do want to thank the very hard-working Secretariat for putting this report together in such a truncated period of time, and I commend the report to the House.
Thank you. Give the call to Minister.
Thank you, Deputy Speaker. I move that business intervening before order of the day number 8, government business, be postponed until a later hour this day.
I will put the question. All those of that opinion say aye. To contrary, no. I think the ayes have it, and call on the clerk for the next item of business.
Government business, order of the day number 6, Treasury Laws Amendment, Payday Superannuation Bill 2025, resumption of debate on the second reading.
Thank you. I understand that it is the wish of the House to debate this order of the day concurrently with the Superannuation Guarantee Charge Amendment Bill of 2025. There being no objection, the Chair will now allow that course to be followed, and I give the call to the member for Fairfax.
Thank you very much, Deputy Speaker, and I rise today to speak to the Treasury Laws Amendment Payday Superannuation Bill of 2025. The Coalition supports the principle of payday super. We've always believed that superannuation is part of a worker's pay. It is not a bonus nor a gift, but money that belongs to those who earn it. This explains why the Coalition is not opposing this payday super bill. We want to make sure Australians receive their superannuation entitlements when they're paid their wages. And no one wants to see workers ripped off. Sadly, ripping off workers still happens, and it happens too frequently. Around $5 billion in super goes unpaid every year, and that's just not good enough. We want Australians to get every cent they're owed, and we're hopeful that more frequent payments will help close that gap. But while the principle of payday super is sound, Labor's execution is anything but. Once again, we're seeing a rushed, reckless and poorly planned rollout of a policy that risks creating chaos for small businesses right across the country. It's a familiar story to Labor. The headline matters more than the homework. From Treasurer Chalmers' botched super tax on unrealised capital gains to this half-baked implementation plan of payday super, Labor never seems to learn from its mistakes. And now they expect Australia's small businesses to pick up the pieces. The Coalition stands ready to support worthy reform. We always have. But as is standard practice, with a bill with such wide-ranging impacts, we will be seeking to send it to committee. The Coalition will not stand in the way of employees being paid their super when they're paid their wages. But we are asking the government to reconsider its rushed implementation to allow small businesses sufficient time to prepare and adapt. The government's own documents admit its timeline for implementation defies advice from Treasury. On page 102 of the explanatory memorandum, the plan was for an 18-month lead time between passing the laws, originally intended for late 2024, and starting to operate in July 2026. Instead, businesses are being given less than 8 months, not 18 months. And what's more, it's not 8 months from when the laws are passed, but from when the bills were introduced. The government took around 2.5 years from announcing this policy to introducing the bill. And now, all of a sudden, it's a rush job. This is irresponsible. As such, I move the amendment circulated in my name, which calls on the government to 1. Abide by Treasury's advice and provide small businesses and digital service providers with 18 months to implement, and 2, calls on the government to legislate protections for small businesses that have made good faith efforts to comply. Labor's reckless timeline risks the systems not being built on time for implementation. Not only is more time needed for small businesses to prepare for these substantial changes, but so too for the systems providers who are being asked to rush the implementation of new software. The government has committed to shutting down the existing free service that processes super payments on the very date that this new law will be implemented. That is, the free superannuation clearinghouse service will be shut down. This effectively rips the carpet from under around 200,000 small business users, and it will only create further unnecessary uncertainty. It is giving software providers practically no time to build, test and roll out the systems as they are required. We all know what can happen when these types of technology transitions and upgrades are rushed. Why risk it? Small businesses will ultimately be the ones to pay the price where Labor's implementation plan is rushed and is not successful. Every payroll software upgrade, every cash flow adjustment, every compliance change takes time. And if you're in business, you know very well time is money. We support the principle of payday super. But let's be honest, this is no small change. Especially for small businesses, this is a big change. Super payments are shifting from as few as 4 per year to as many as 52 per year. Labor shouldn't paper over this change, particularly for a small operator, such as a tradie with just a few staff members, or a cafe or hairdresser, for example. These small business owners are not payroll experts or accountants, and the owners and managers can't farm out the changes to an HR or payments division to look after. They, of course, just do it themselves. Every second more they are asked by government to work on the business to meet compliance requirements for government is a second they can't spend working in their own business, serving customers and keeping the operation moving. That's not to say that this bill shouldn't proceed. In fact, we absolutely support the principle of payday super. But we need to give small businesses time to adjust so they can get it right. Small businesses account for 97% of all Australian businesses, but less than 40% of employees. They need the appropriate time to implement these changes. The last thing we want to see is if these changes for struggling small businesses, and by extension compromising the workers that they employ, coming to fruition as a risk. There is concern that, for some time, this bill could be the straw that breaks the camel's back. That's why the Coalition is once again backing our hard-working small business community and asking Labor to consider a fairer implementation timeline. And it's not just about the Coalition raising such concerns. MYOB, is a well-known business which offers the market a business management platform. It's used by thousands of small businesses. They have sounded the alarm on the harms that could be caused by any implementation as outlined by the government. Cash flow risks threaten thousands of small businesses. MYOB modelling suggests around a quarter of all small businesses would be at risk of insolvency because of payday super requirements. COSBOA is also calling for more time, fairer penalties and cost support. The Council of Small Business Organisations, COSBOA, has called on Labor to adopt, and I quote, a more realistic approach to implementing payday super. COSBOA is also highly supportive of the principle of payday super, but it warns that the current timeline risks overwhelming small businesses and undermining the intent of the proposed reform. The government is aware of these issues, but it's rushing ahead regardless. In fact, the Treasurer in his speech to the House pointed out that the ATO has said it intends to consult on its approach to compliance for the 12 months after the change. There are businesses across the country today that would have no idea that this change is even coming because of the Treasurer's rush to implementation. The Coalition is merely asking the government to provide small businesses a reasonable timeframe to implement these changes. The Coalition has shown Labor how to do this properly. It was the Coalition that delivered single-touch payroll, the system that makes payday super possible in the first place. Under single-touch payroll, we achieved real-time visibility of wages and super payments, a major reform that we rolled out carefully and successfully. We phased it. It was phased in, sensibly. Large employers first, smaller ones later, and micro-employers were given concessions. That's how you deliver reform that works. Labor, on the other hand, wants your local cafe to have the same deadline to implement as a multinational. That's absurd. That's why we're calling for the government to extend the start date for small businesses, those with under 12 employees, by 18 months. That would cover 97% of businesses, but only around a third of employees, a fair, balanced and achievable approach. Deputy Speaker, the government's plan also risks punishing those trying to do the right thing. We all want to catch the dodgy operators who deliberately withhold super, but not punish honest employers that miss a deadline because of issues beyond their control. If Telstra or Optus goes down, if the bank delays a transfer or if the clearinghouse makes an error, surely we all agree that the employer should be hit with penalties for something beyond his or her own control. Labor is hiding behind the ATO's draft practical compliance guidance to paper over the risk. While the government will suggest that the ATO's draft practical compliance guidance is sufficient in offering relief from penalties, draft guidance isn't law. It can change any time, and it also expires after a year. That's cold comfort for small businesses who are trying to work out how to manage the uncertainty that goes with such a large implementation plan. That's why we're also calling on the government to legislate protections for small businesses who have made good faith efforts to comply. It would be a common sense safeguard for employers doing the right thing, and adopting this approach is therefore a test of whether Labor actually cares about the needs of small business. The Coalition will always back measures that help ensure Australians get every dollar they are owed. But we'll also stand up for small businesses, small and family businesses, who keep Australians in work. So the government can be assured that the Coalition will not be standing in the way. We're not planning to oppose payday super, but we do ask the government for its support to ensure a fair and responsible implementation.
Is the amendment seconded? Member for Hume.
Amendment is seconded.
The original question was that this bill be now read a second time. To this, the honourable member for Fairfax has moved as an amendment that all words after that be omitted with a view to substituting other words. The question now is that the amendment be agreed to. The member for Macquarie.
Thank you, Deputy Speaker. I want to talk about the problem that we're tackling here, and I want to give an example that Debbie in my electorate of Macquarie has shared with me. She wrote to me a few months ago about a situation that faced her husband when they worked out last year that her husband's workplace had not been paying any contribution into his super account for some time. In fact, it came to light because their super fund said, is he still working there? Because nothing's going in, and he was still working at that organisation. Debbie then did some research herself, and she could see that they had underpaid her husband around $8,000 in super at that time. And I want to say that as we've gone through this process, we've worked out it was a much greater underpayment than what she initially thought. So her husband did what most people would do. They gently raised it with their employer, and he was told that they were aware of it, they were behind, and that they really weren't that keen to notify the ATO, as they'd already previously been on a payment plan. And a week later, having thought about it some more, he again raised it and was told that they had gone to the ATO and were on another payment plan. So, you know, at that point, they'd done the right thing. However, and they tracked it and they could see the payments going in. However, about a year on from when all of this happened and was revealed, Debbie's husband decided to put in his notice, and he was told that he could finish up with his last pay the following Tuesday. Now, Debbie, of course, checked to see that everything was in order, and what she found was that now his super was short by about $19,000. And that's pretty much the point that Debbie reached out to me. And this is one of the problems with the current system. It is hard to track the quarterly payments. You've got to crunch the numbers and do the maths. And one of the problems that we're tackling here is that people need to be able to see those regular payments and notice more quickly when they're not in there, because it's easier to see. I'm not going to go into more details about that particular employer, but what I do want to say is that as we have worked through this process, it turns out that it was around about not $19,000 short in super, but more like $23,000 short in super. And that situation is in the process of being rectified, but it's going to take a really long time for that payment plan to return to Debbie's husband the money that he has earned, that he is entitled to. And it is an outrage that a small number of people, employers, are treating their employees in this way. As Debbie and other people say, what about the interest that has been lost? Well, fortunately, the repayment plan that's in place to put in the money that should have been put in the first place is going to include a portion for lost interest. And that was the issue that Belinda raised with me. Belinda is in her 50s, has a very low super balance, and she raised with me that it might be much better if she was receiving, just as she gets paid weekly or fortnightly, that she receives her super in the same way. And that's also the logic that we have applied. And when those opposite talk about that this is all happening too soon, well, there should never be a case where it goes for months and years that people are not paid super. But let's look at just what unpaid super is costing my community of Macquarie. Let's start with the big picture. According to Super Members Council, around 3.3 million Australians were not paid the super that they earned in the 22-23 year, just in 1 year. Unpaid super is costing Australians around $5.7 billion each year, or $110 million a week, according to the council, a loss that is profound for the people affected. So let's bring it from the country down to the state. In New South Wales, unpaid super cost over 1 million workers $1,760 each on average, or a combined $1.8 billion. And that represents 29% of the workforce. So we're not talking about insignificant numbers. Over 6 years, unpaid super has been rising steadily in New South Wales, costing workers a total of $9.9 billion. the average Australian worker could be shortchanged more than $30,000 from their final retirement nest egg if those figures are allowed to continue. So I'm going to take it down even one layer further, and let's just talk about Macquarie. In Macquarie, 18,450 workers have been underpaid, 26% of the workforce, with an average underpayment of $2,130. And over the course of 22-23, that's nearly $40 million. And over the years from financial year 2017-18 to 22-23, that's $183 million. We're talking big amounts of money, and for my neighbour, Lindsay, we're talking 26,500 workers who are underpaid, 29% of the workforce. So that is some indication of the scale of the problem, and people in Lindsay, unfortunately, find themselves in the top 10 electorates in New South Wales with the highest levels of unpaid super. Now, I want to be very clear, as having been an employer myself for nearly 25 years before coming to this place, I recognise that most employers do the right thing, and where they make an error, they work very hard to correct it. And one part of this new legislation will make it much easier for an employer to pick up a mistake and to quickly rectify it. It's much easier to rectify a 2-week or 4-week failure to pay super than it is a 6-month or 12-month failure to pay it. And so I really want to make it clear, we recognise that most employers do the right thing. What we also recognise, though, is when it does happen, this issue disproportionately affects more vulnerable Australians, and that includes women. And that's because those on lower paid, casual and insecure work, who are more likely to be women, are more at risk of missing out on their super. So what we have is a once-in-a-generation opportunity it's a reform to fix unpaid super. That's what payday super is. The reform will ensure and will help workers to know, and employers, that they're receiving the super they're owed when they're owed, and it helps employers know that I've paid the super I owe when it's owed. Let's talk about how this is going to work in practice. From the 1st of July next year, employers will be required to pay superannuation guarantee contributions at the same time of wages instead of quarterly. Employers will have to ensure that contributions are received by the employee's super fund within 7 business days of payday. The change, as I say, makes it so much easier for employees to track their super and for the ATO to detect missed payments earlier before those debts just blow out. The legislation also updates the superannuation guarantee charge, which is the penalty that employers face when they fail to pay super on time. Under the new framework, the super guarantee charge will apply for each payday an employer fails to pay super in full and on time. So if you're doing the right thing, there is no penalty. I know there will be people who really want to know the details, so I am going to give some detail on this, Deputy Speaker. The updated super guarantee charge includes notional earnings, and this compensates employees for the investment returns they missed out on due to late payment. As my constituents say, that is absolutely a key factor in their minds, that if payments are missed, they feel they should be compensated for the lost interest. The updated super guarantee charge also includes an administrative uplift, which is an additional charge to reflect the cost of enforcement and to incentivise voluntary rectification. It can be reduced for employers who voluntarily disclose and have a good compliance history, because we do want to encourage good behaviour. and reward good behaviour. The charge also includes a choice loading, which is an additional penalty if the employer fails to pay into the employee's chosen fund. Employers who continue not to pay, even after the ATO has raised a superannuation guarantee charge, will face higher penalties of up to 50% of the unpaid amount. Now, these changes are designed to prompt employers to fix mistakes quickly and ensure workers are fairly compensated when employers fall short. In terms of enforcing these changes, Deputy Speaker, the ATO will use the single-touch payroll data, which employers already report. That's how they report, and they'll match it with data from super funds to detect missed payments in close to real time. This data matching capability allows the ATO to intervene earlier, reducing the risk of large debts building up and increasing the chance of recovery. And I know, as a former small business operator and spending a lot of time talking to small businesses, knowing soon and realising if there's been an error or an oversight is much better than it blowing out for months and months and months, and you're getting a big shock when you realise the issue that's happened. The next part of this is how we're going to support employers to meet their obligations, because we are going to have the ATO adopt a facilitative compliance approach in the first year. In other words, employers who make a genuine attempt to comply, even if they face technical issues, will not be targeted by ATO compliance. The reform also helps employers by aligning super with payroll, reducing that end-of-quarter admin pressure and the risk of large liabilities. Yes. That is a very real and present thing. I note the opposition, the previous speaker, talking about it's too quick, it's too soon, it needs to be delayed. But this legislation must pass soon as possible, so that employers, payroll providers, super funds and the ATO have time to build the systems needed for implementation by the 1st of July next year. So that's an 8-month period for them to do that work. The longer we wait, the more workers will miss out and the harder it becomes to recover unpaid super. And I want to leave you with an example of the difference this can make for someone. I want to talk about a young worker. For the average 25-year-old worker's retirement balance, this system of paying super when the person gets paid will boost their retirement savings. It's the equivalent of receiving an extra $6,000 in today's dollars. But if the worker is missing out on the super, the impact is even more significant. In a typical unpaid super case for a 35-year-old, recovering their superannuation leaves a much bigger dent in their retirement balance, and we're talking tens of thousands. So, Deputy Speaker, this is the time to do this. We don't need any pushback on it. It would be fantastic if the whole Parliament would recognise that this is fair for workers. It will actually work for employers, most of whom are already doing the right thing, and help them identify mistakes earlier. And ultimately, it will lead to better retirement balances for workers, and that's something we're all trying to achieve so that we take pressure off our other systems down the track. I commend the bill, but not the amendment to the House.
The question now is that the amendment be agreed to. The member for Riverina.
Thank you, Deputy Speaker. And the older you get, the more you get in your Facebook algorithms, how much retirement savings, how much superannuation will you require when you do in fact call it a day from your work? And the probable answer, ignoring what AI might suggest, is not enough. It's never enough. Whatever they suggest is never really enough. And most people don't ever think about or like to talk about superannuation because it is complicated. It absolutely is complicated. And certainly I know on the coalition side we are fortunate. We've got Senator Jane Hume who likes to talk about superannuation. I know she's got a lot of good ideas about superannuation splitting. Senator Matthew Canavan is of a similar view, making sure that partners, usually the males, can actually share their superannuation with females. And they're good ideas and they're worth absolutely investigating, because we also know, as much as we know that certainly we don't like to talk or think about superannuation, that women retiring don't ever have enough. And if we do talk about the pay gap, the superannuation gap is even wider, and because of all sorts of reasons, any number of reasons. But women often find when they do finish work that there just simply isn't enough in the kitty to keep them going, particularly if they're single, particularly if they don't have support. And this is a real concern, and often you find the number of homeless women and the number of women on the poverty line is increased amongst that older age, when those women have indeed finished their working life. This particular Treasury Laws Amendment, Payday Superannuation Bill 2025, and the amendment, it's important to have a discussion in relation to that. We've always, as a coalition, believed that superannuation is part of a worker's pay. It's not a bonus, it's not an extra, it's their money. It's absolutely the workers' money. They've earned it, they're owed it, and as the member for Macquarie quite rightly pointed out, most companies, most small businesses do the right thing by their workers for their employees' entitlements, and they put away the superannuation. And indeed, the Australian Taxation Office, pleased that it many years ago in the 1970s was relocated to Albury, a great show of decentralisation. Those opposite, I'm amazed they're not yelling out to me that happened under their watch. Well, it did, but it goes to show what can be done when an organisation such as the ATO does move into a regional centre. But the ATO will cooperate with businesses that do the right thing, that, as the member for Macquarie rightly pointed out, if they do find that an innocent or unwitting error has been made in payments for superannuation, or non-payments, I should argue, that they will work with them to make sure that the workers are looked after as they should be. Unpaid super, as we know, it is a persistent problem. It's a serious issue. Around $5 billion in unpaid contributions each year, that's the amount. Not all that's willful, but certainly in areas where it is, then those companies should be hit, and hit hard, by the ATO, by ASIC, by any other institution which has carriage of that responsibility. We want, as a coalition government, as indeed a parliament, to ensure that Australians receive every cent that, through the perspiration and efforts and the hours that they've put in, has been earned. It's their superannuation. We're hopeful that more frequent payments will help close that gap, will help bridge that divide. I have to say that, like most things, Deputy Speaker, Labor's bungled the rollout with a rushed and reckless implementation. It's usually the case. It's usually the way. It's poorly planned. It risks difficulties for small businesses right across the country. And like the member for Macquarie in her contribution just now, I've also run a small business, a successful media publishing company. I was in it for 8 years before I entered Parliament. The business continued long after I began my parliamentary career in 2010. And I know how difficult it is to run a small business. It was hard then, let alone now. And the difficulty we face as a nation is that small businesses are going to the wall right across the country. It's very hard in regional Australia for small businesses to find workers, to find hired hands, find help, and you go along any main street in any country centre, large or small, you will often find notes in the window that there is work available within. And these small businesses simply can't find people to fill the vacancies. And for those small businesses that are operating, there is this deluge of compliance, of bureaucratic tape, of difficulty, and not just with the federal government, but also indeed often with local councils and slow development applications. Councils and even state government compliance, it is just onerous on those small businesses. Many times you often talk to a small business operator, they'll tell you that they're taking home less pay than the workers that they are giving an opportunity to. And in this day and age, whilst I appreciate that running a small business is often a ticket to a better life later down the track, it's hard for those small business operators when they're putting in the work, they're taking the risk, they're leasing the building, renting the building, hiring people, sometimes unwittingly not meeting all the requirements that they should, and then they're taking home less pay than the workers. And it's hard because often they don't take holidays, but they have to meet all of this bureaucracy. That's why I'm glad that we have in place the Australian Small Business and Family Enterprise Ombudsman. And I know the work that Kate Carnell, I know the work that Bruce Bilson, a former small business minister, did in relation and regard to helping small businesses. And for any of those small business operators who may well be listening in to this broadcast, go onto the ASBIFIO website and see what is available as assistance in matters such as superannuation, industrial relations, grants and those sorts of things that are available to you as a small business operator, because there is a mine of data that is very helpful and very recommended. Now, we just saw last week with the hapless Treasurer and his hapless unrealised gains completely botched, and this at least this backflip was a bit of a help to small businesses, because, and particularly for farmers who may have had land locked up in their superannuation accounts, because if it went over $3 million, they were then going to face a tax bill on the property value going up. Well, at least the Treasurer has had the foresight and the gumption, but he's been dragged kicking to the table. We know that. He's been dragged there, screaming and kicking. Finally, he's come up with the view that he will shelve that, but for now. But for how long? It was doomed policy at the start. It should never have happened. It was hardly talked about in the lead up to the election, and thankfully it's been put on ice, and hopefully it will never, ever see the light of day, because that unrealised capital gains was an impost on the superannuation abilities by farmers in particular in regional Australia to help their retirement plans, to help their succession planning. And when it comes to superannuation, whilst I said at the start that people don't like to talk about succession planning, a lot of farmers don't like the prospect of succession planning, and it's something that's very important, particularly in this day and age when not necessarily the eldest son's just going to take over the farm. Once upon a time, that was generally the case. The eldest son who worked the farm took over the farm when the farmer retired. That was back in the days when the farmers were generally the men, and these days they're not necessarily always the men. And in those days when the firstborn son was going to take over the farm, and not necessarily, and it's a good thing that doesn't always happen now. And the number of women making mighty contributions to agriculture has to be applauded. And I do applaud what AgriFutures has done in that regard. And anybody who doesn't believe me only needs to go to the AgriFutures Women of the Year each and every year in this place to see the amazing contributions done by women for the future of agriculture. They now realise there's money to be made, there's a future to be had in agriculture, and good luck to them. But again, I say that unrealised capital gains was going to have such a disadvantage for our farmers who had their land locked up in that regard. And thankfully, the Treasurer, the member for Rankin, has seen the error of his ways, albeit he was told to pull his horns in, and he's done so. But Labor has dropped the ball on this policy, on this superannuation issue, and they're now expecting small business to pick it up. And we know that small business is already doing it tough, especially in the areas of construction and transport. And every single day, you pick up the paper, you go online, you listen to the radio, you turn on the television for the news, and you'll see some transport company that's been operating for decades has gone to the wall, or indeed a construction company. Those two sectors particularly are in free fall at the moment, and it's because of the compliance forced upon them, particularly by Canberra, particularly by this Labor government, which I have to say doesn't give a jot, doesn't give two hoots about small business. And that is to the great detriment of this nation, and particularly to the trucking industry, which kept this nation going during COVID. It was agriculture and it was transport which kept this nation going. The transport industry, which carted the food, which carted the vaccines, and of course agriculture, which provided the food. And I have to say the government has been very lax on supporting those industries which supported this nation through COVID-19. Now, in the government's own documents in this particular bill, you see the great revelation. Just turn to page 102 of the explanatory memorandum. Now, the plan was for an 18-month lead time between passing the laws in late 2024 and starting in July next year. But instead, businesses are being given just 8 months, not 8 months from when the laws are passed, but from the day when the bill was introduced. And that, I have to say, is not responsible. It's not realistic. And again, it places pressure on small businesses already doing it tough. I mean, why is it right that a business person has to open the doors very early in the morning, work all day, work their insides out, hope that customers come back, try and attract new ones, try and keep the good customers that they've had for years and years, and then when they turn the lights out and they're the last to leave, go home and have to then go through all this responsibility of looking up what new law there is, meeting all Labor's bureaucratic tape. It is so tough for businesses. It's all right for us. Yeah, we work long hours too, but we don't have the risks of not knowing where your next pay packet is going to come from. We just don't. And yet we make these laws, and the government puts in place this legislation without so much as a thought to what they're doing to small business, to what they're doing to the good, honest, hard-working small businesses which keep this nation running, which keep this nation's lights on, which keep this nation fed, which keep this nation clothed. That's what this government is doing, and it's time to just think about small businesses, listen to small businesses. And when the Labor members are, after the week after next, going back into their electorates, go and listen to small businesses and hear what they are saying. Go into any of your high streets, main streets, and visit your small businesses and just listen to them and take on board their complaints and concerns about the onerous red tape that you're thrusting and foisting upon them. And then, here's a thought, do something about it when you come back here. Absolutely do so. Labor delayed this legislation for a full year, and in doing so, cut the transition time for businesses in half. What was the hold-up? I'll tell you what the hold-up. It's procrastination. It's what Labor is good at. Procrastination, compliance, important legislation, about time you're getting on with it, but have a thought for small business.
The question now is that the amendment be agreed to. The member for Boothby.
Thank you, Deputy Speaker. Speaker, this is yet one more plank in the platform to enable Australians to earn more and keep more of what they earn. Payday superannuation. Being paid your super when you get paid, not months later, seems like such a simple change, and yet it is so powerful. It will mean that more Australians receive their more retirement savings that they are owed sooner and more reliably. Labor is the party of superannuation. We introduced compulsory super to ensure that Australians could enjoy a secure retirement. It was a groundbreaking change that has made Australians the envy of the world, giving Australian retirees better retirement and also taking pressure off taxpayers through reducing the demand on the age pension system. Those opposite, we know, hate superannuation. I've never really understood why. Fundamentally, superannuation is people helping themselves, securing their future. They've tried to wind it back, they tried to undermine it. They've tried to make people raid their superannuation as recently as the last election, when they wanted young people, people who by definition have low superannuation balances by virtue of their short time in the workforce, and the most to lose in terms of the interest they can potentially earn over the next decades. They wanted them to raid their super to get a housing deposit. They want young Australians to trade their future retirement to buy a home, furthering the wealth transfer from young people, not to them. On this side of the House, Labor will always protect superannuation. Not only that, but we will also strive to make it better and fairer. Under this Labor government, we've increased the employer contributions to workers' superannuation to 12%. Under this Labor government, we're establishing superannuation on paid parental leave. This mostly affects women, and Speaker, I've spoken in this place about my experience running a women's homelessness service. No matter why you become homeless, the one thing everyone experiencing homelessness has in common is poverty. And the women who turned up to Catherine House frequently had either no superannuation or very little, at least in part because of the gaps in paying into their superannuation while on parental leave. And this Labor government is also moving to increase the low-income superannuation tax offset, the LISTO, to further address inequities in superannuation benefits, particularly assisting young people and women. And now this change, which really shouldn't be controversial. Whether your money is in your pay packet or in your superannuation contribution, your money still belongs to you, the worker. And so requiring it to be paid into your superannuation account when you get paid is surely not an outrageous proposition. Indeed, when I posted this issue on social media, I had a number of employers, small business owners who are friends, comment that they already pay superannuation on payday. They found it simpler and easier to just get it all done at the same time in one payroll process, rather than creating another process they needed to do on a quarterly basis. But we do realise that for some employers, this adjustment will take time, and so it will be implemented from July 2026, and the ATO will not be targeting genuine errors. Speaker, one of the core pillars of a fair retirement income system is that workers, no matter their job, employer or pay cycle, receive their entitlements in a timely manner. In Australia's superannuation system, the compulsory employer contribution mechanism, the superannuation guarantee, has been central. Under the existing system, employers are required to pay superannuation contributions at the longest period at the end of each quarter rather than at each pay cycle. The result is a timing gap that allows for unpaid, late or missing superannuation contributions. That matters. Every extra day you have superannuation in your account means extra compounding interest. Not only that, but the delays in superannuation payments means it takes longer to realise if your superannuation isn't being paid or isn't being paid correctly. According to the latest estimates, the Australian Taxation Office currently considers that in the most recent financial year data, around $5.2 billion worth of superannuation went unpaid. That's $100 million every week earned by workers but not paid to them. This bill responds directly to that problem. It mandates that from the 1st of July 2026, employers must have superannuation contributions reach employees' super funds within 7 business days of payday, aligning contributions with salary or wage payments. And who will this benefit the most? Young people, women, people working casual or part-time jobs, those in insecure work, people who change jobs frequently. These reforms strike at what many workers may miss out on over their working lives. The government has estimated, for example, that the average 25-year-old, this will mean an additional $6,000 in today's dollars in their retirement income. The average 35-year-old with unclaimed super, this will see the equivalent of $32,000 extra in today's dollars in their retirement balance. That is a significant amount of retirement funding, and not only that, it's just the fair and just thing to do, because it's their money, they earned it. In sum, the bill ensures fairness, strengthens our retirement income system and modernises the contribution regime for the 21st century labour market. Speaker, the government's decision to bring in payday super is deeply rooted in fairness and long-term retirement outcomes. Firstly, it's making the most of compound interest. By paying contributions earlier and more frequently, workers' superannuation balances will begin accruing investment earnings sooner. It addresses inequality and vulnerability because the unpaid super problem falls disproportionately on more vulnerable workers, those in casual or insecure employment, women, younger workers, and those who change jobs frequently. The reform helps level the playing field. Thirdly, it strengthens trust in the superannuation system. Large sums of unpaid or late super contributions undermine confidence that the system is working for all. By tightening the rules and aligning contributions with paydays, the bill reinforces the legitimacy of Australia's retirement income system. And fourthly, it reduces administrative and detection lag. Under the current quarterly system, unpaid contributions may remain undetected for months, if at all. By syncing contributions with paydays and aligning reporting, the ATO can more quickly identify and address shortfalls. Employers will be required to ensure the superannuation contributions have been received into the employee's super fund within 7 days of payday. And while I mentioned previously that a number of employers do actually already pay super on payday, this will start on July 2026, and the ATO will not target genuine errors as businesses transition to the new model. So, Speaker, let me reiterate some of the specific benefits this reform offers. For employees, they get early receipt of contributions, more time in the fund, so more compound interest, meaning better overall retirement incomes. Also, it will be easier for them to check whether their superannuation has been paid on time and correctly, or in fact at all. And of course, a better funded retirement in their future. For superannuation funds and the industry, they get improved cash flow and allocation timing, fewer late clearing issues, clearer reporting, and less backlog of outstanding contributions. The preeminent industry body, the Financial Services Council, has welcomed the bill, noting that the move to 7 business days rather than calendar days was a constructive change in response to stakeholder input. For employers, a simpler system as part of their standard payroll processes rather than having to have an additional process to pay superannuation. For our future Australia, better funded secure retirement income, meaning lower requirement on taxpayer-funded aged pension. For the system overall, higher confidence in the superannuation system, improved compliance environment, reduced pool of unpaid contributions, strengthen retirement incomes across the 50-plus age groups and younger workers. Small business support and compliance burden. Small business owners may require additional support, guidance and perhaps phased implementation assistance. The government and industry groups will work closely to support businesses through the transition, particularly where there are multiple pay cycles, seasonal variations or tight cash flows. Speaker, we live in a rapidly changing world of work, more frequent pay cycles, more casual part-time or gig-type employment and greater job mobility. The quarterly superannuation guarantee payment regime was designed in an era of more stable employment and fixed pay cycles. It does not fully align with the contemporary reality. By bringing super contribution timing into alignment with pay cycles, we are modernising our system. We are addressing the drag on retirement outcomes caused by delayed contributions, especially for younger workers who may lose the greatest portion of lifetime compounding if contributions are late or missing. Moreover, with Australia's population ageing and longer lifespans, ensuring that superannuation is effective, equitable and timely is a matter of economic and social policy. The stronger the retirement savings base of individuals, the less pressure on the public age pension, the less pressure on future taxpayers, the better the economic participation of older Australians, and the more resilient our fiscal future. The Treasury Laws Amendment Payments Superannuation Bill 2025 is a landmark reform for our nation's retirement income system. It combines fairness, efficiency and modernisation. It ensures that workers, especially those who are younger, less secure in employment or changing jobs frequently, get what they are owed: superannuation contributions made promptly and fairly. Implementing contributions at or close to payday transforms the way super works in practice. It reduces the opportunity for unpaid or late contributions, strengthens enforcement, enhances confidence and ultimately ensures Australians retire with more savings. Yes, there are challenges in transition. Yes, the government expects the business community needs time, clarity and support, but the lead time to the 1st of July 2026 gives a clear, date-certain horizon. The risk-based approach by the ATO offers a sensible compliance framework, and the shift to 7 business days shows that we've listened and adjusted in response to stakeholder feedback. In supporting this bill, we reaffirm our commitment to ensuring the retirement income system works for all Australians, that hard work over a lifetime is rewarded with dignity, security and financial independence in retirement. I commend the bill to the House.
The question now is that the amendment be agreed to. The member for Cowper.
Thank you very much, Deputy Speaker, and I'm pleased to rise to speak on the Payday Superannuation Bill. Before I do, the member for Boothby, it was disappointing to hear the member say that those on the other side hate superannuation. So through you, Deputy Chair, I'd like to offer a personal invitation to Friends of Superannuation that I established in only recent weeks with 2 of your senator colleagues. I would love you to come along because we are intent on working together to ensure that Australian people get the superannuation that they deserve in the future. Thank you. Deputy Speaker, since taking the role of Shadow Assistant Treasurer and also Shadow Minister for Financial Services, I have worked side by side with the peak bodies from the superannuation sector to give them the confidence that the opposition is listening to them, and also working side by side with my opposite, the Minister Molino, the Shadow Treasurer and Shadow Minister for Financial Services, because it is so important for the sector to have that confidence and the faith in government, and that is the government and the opposition working together, because when that confidence is there, the sector works well. And if the sector works well, then the system works well. And then you will see superannuation doing what it is supposed to do, and that is to prepare older people for retirement and for them to be comfortable in the future. So I think when we're making or having these debates, or whether we're speaking outside of this chamber, we should be cognizant of that fact, that throwing rocks at each other about superannuation and making statements that one or other of a political party hates superannuation does nothing. And the Friends of Superannuation doesn't just have members from the Coalition, members from Labor, it also has the crossbench. It has members from the Greens. And I think that shows that there is that bipartisan approach that is required to ensure that the future security for Australian people. I just thought I'd make that point, Deputy Speaker. Let me say there is absolutely no disagreement. The Coalition supports payday super because superannuation is part of a worker's pay. It's not a bonus, it's not a gift, it's not a privilege. Superannuation is your money. It's not government money, and the Coalition will always stand up for that principle. We'll stand up for Australians to get every single dollar they've earned, and we believe that to our core. Unpaid superannuation is a real problem. We acknowledge that. About $5 billion a year goes unpaid to workers who get up every morning or do shift work at night time, and it is not only unfair, but it is illegal, and we have to stop that. Deputy Speaker, whether it's the truck driver in Kempsey or the retail worker in Port Macquarie, they trust what is on their payslip, and they should be able to trust what is going into their superannuation account. Many of us have young children going into the workforce, and I've got no doubt that every single one of us want our children to get every single dollar that they deserve, that they've earned, to ensure that at the end of their working life, they have a comfortable retirement because it is their money. Deputy Speaker, in principle, we agree with most of this bill. What we will see is a change in the system where businesses pay superannuation quarterly, and the transition houses are able to hold on to that money for a period of up to 28 days. What this bill seeks to do is change it to a payday system. If you're paid weekly, fortnightly, monthly, then that superannuation, your superannuation, comes out on that day, goes through the transition houses for only a period of 7 days. That means that money hits your account earlier, and it can't be used and abused for lengthy periods of time by other organisations. The intention is right. However, Deputy Speaker, the rollout is wrong. Labor has bungled the rollout, and unfortunately it is a familiar story with rollouts by the other side. They're brilliant at the big announcement, but hopeless on the delivery. And we saw recently the botched super tax on unrealised gains, and I stood at this very dispatch box where the Prime Minister sat opposite me, the Treasurer was sitting on the front bench, and I begged them, I explained to them how the unrealised capital gains would kill farmers. It would kill businesses who put commercial properties into their self-managed super funds because they were A, advised to, and B, allowed to under the current rules. But the goalposts were being changed. So it was very pleasing, very refreshing to see, whether it was the Prime Minister, whether it was the backbenchers whose constituents had come out and spoken to them to say, you can't do this to us, this will hurt us. This will mean I'll have to sell off part of my farm because it's been a tough year because of fires or floods, but my property's still increased in value, and now I have to find 125, 150,000, whatever the 30% component was. It will kill us. So it was very pleasing to see that backflip. Deputy Speaker, one of the major issues, I'd have to say the major issue with this bill is it is being rushed out in a reckless, half-baked manner. And you only need to look at the government's own explanatory memorandum, where in black and white it admits that the plan was for an 18-month rollout, not an 8-month, 18 months. And there were very, very good reasons for this. So Labor knows that payroll software providers need at least 18 months, that accountants need at least 18 months, and that small businesses need at least 18 months. Instead, they're giving businesses barely 8 months, not from when the bill passes, but from the day it was introduced. That is not a fair transition. That is a scramble. It's unfair, it's unrealistic, and it's irresponsible. Deputy Speaker, I don't know how many across the floor have run their own business. I have. I had a business for 18 years. I know what it is like to be sitting there at 3 o'clock in the morning paying the wages, paying the super, and questioning whether you're actually going to be able to pay yourself at the end of the day. I know what it's like to be a small business owner. You are the owner, you're a counsellor to your staff, you're the janitor, you do the compliance, you pay the bills. It's tough. Imagine putting this layer on top of business owners right now, particularly small business owners who don't have their HR department, they don't have managers, they don't have in-house bookkeepers. This is going to be extremely difficult for a small business, whether it's in Cowper or Gippsland or Campbelltown.
Thank you.
Deputy Speaker, I know what it's going to be like, and I know how much of a headache this will happen. They just want a fair go. They want clear rules. They want realistic timeframes. And they want a government that understands the pressure that they face. And I think if members in this place haven't been in business before, go and sit down with half a dozen business owners and talk to them about what this is going to do to them with a rollout of 8 months. Again, it has to happen. It has to happen because employees deserve to have their superannuation. But give the employers time to get to that point. I'll never defend an employer who doesn't pay superannuation. It's happened to me personally when I was younger, and it is unfair. And they use that power over you that I'm your employer, you'll have to go and find another job. Well, sometimes it's too hard to go and find another job. And particularly in today's society, it is hard depending on where you live. Deputy Speaker, it's not going to be the big end of town that pays the price. It's going to be the cafe, the family-run mechanic, the local builder, hairdressers, you name it. They're all struggling with high energy prices, insurance costs are going through the roof, staff shortages, and now they're being told to change their systems within 8 months. Deputy Speaker, bizarrely, at the same time, Labor has decided to shut down the Small Business Superannuation Clearinghouse service. Now, for those who aren't aware what that is, this is a free service that provides around 200,000 of the smallest businesses with super clearing services, the point where the employer pays to the super clearers then transition that money over to the superannuation account. It's being shut down at the same time, the very same date that this is supposed to roll out, at the same time when MYOB, Xero, other clearing houses or platforms are saying we're not going to be ready. We're not going to be ready. It is going to be a mess. Deputy Speaker, this design has not been thought through carefully. There has been plenty of time, in fact years, for Labor to get this right. So I would call on them to consider actually doing the right thing, to consider those small and medium businesses, to consider what it will actually do. it would actually mean that 97% of businesses have time to prepare for the change, but it would only mean 28% of employees are not covered from the 1st of July 2026. That's less than a third. That's fair, it's balanced, and it's achievable. You can actually do that. Because if you don't, there will be job losses, there will be business closures. And for those who say, well, if you're that on that fine a margin, maybe you shouldn't be in business. There are a lot of businesses out there, people who own businesses, people who employ people, that use that simply as a job, that to get a salary, to pay themselves a wage. Not to be extravagant, but there are plenty of businesses who have difficulties with cash flow, but they continue on. And they continue on for years and years. To drop this on them in 8 months will not allow them to address that over the period of time. It will be hard, it will be crushing, and there will be job losses. Deputy Speaker, in closing, I've spoken to many businesses, small businesses, about this bill, and their biggest concern is the period of time. They want to keep the lights on. They deserve a fair go. We deserve to give them, as a government, we deserve to give them, so we're obliged, should I say, to give them a fair go. They are the backbone of the Australian economy. We should be thanking them for what they do to keep us afloat. And in thanking them, we should listen to them. And by listening to them, we should extend the period of time for them to be able to comply with this bill. Thank you, Deputy Speaker.
I thank the member for Cowper. The question is that the amendment be agreed to, and I call the member for Werriwa. Sorry.
Thank you, Deputy Speaker. This side of the chamber has always been the friend and champion of superannuation. We introduced it, grew it, protected it, and now we're going to strengthen it. We are always looking for ways to make improvements. For sure, our super system is not perfect, but it is the envy of the rest of the world. Fathers of our modern-day superannuation system are Bob Hawke and Paul Keating. In 1983, when Bob Hawke came to power, only some workers, mostly professionals, had some form of super. Back then, Australia's economy was very different to what it is today, with high inflation and strict labour market regulation. In order to address a number of outstanding economic and workplace issues of the day, Hawke, the great arbitrator, negotiated with the union movement the Prices and Income Accord. They were breathtaking in their achievements. Among the outcomes of these successive accords was that workers would forgo some of their wage increases, firstly 3%, to go into their superannuation accounts. Move Forward and compulsory super, or the super guarantee as we know it today, was announced in the Hawke's government's final budget in 1991 and subsequently enacted in 1992 by the Paul Keating government. At the time of the announcement of compulsory super in August 1991, the Treasurer and my predecessor in Werriwa, John Kerrin, noted that superannuation is the cornerstone of encouraging greater self-provision that will help improve retirement living standards and reduce the budgetary costs of the pension system as the population aged into the next century. Of course, since those days, there have been any number of adjustments and changes to the super system. I think namely of the emergence of self-managed super funds and so forth. Compulsory super now stands proudly at 12%, ensuring that the aims of the scheme outlined by my predecessor all those years ago in the early 1990s are being fulfilled. There are, sadly Speaker, some anomalies in this system. Notably, women still have, on average, much lower super balances than men. The super guarantee is just that, Deputy Speaker, a guarantee. It's not a privilege, it's not optional, it's not a little extra. It is a workplace right. It's what the workers are owned. Remember its origins back when the workers forewent their pay rise? Given this, it's incredulous that some employers still see super guarantee as something optional. In 2021-22 alone, unpaid superannuation cost workers over $5 billion. In other words, $100 million a week. This is theft, it is wrong, and it has to stop. Few pieces of legislation give me more delight than this one. Rather than quarterly, employers will be required to remit to the employees' fund within 7 days of payday. That is a game changer. Upon receipt, the workers' superannuation guarantee will be put straight to work, earning extra money by the nominated fund. Further, it will allow workers to keep better track of their super and for the ATO to detect any missed payments. In order to enforce compliance, the bill before us also updates the superannuation charge. That is, the penalty that is imposed on employers when they fail to pay super in time and in full. Under the new rules, the superannuation guarantee charge will apply each payday an employer fails to pay super in time, in full and on time. Employers who continue not to pay, even after the ATO has raised a charge, will face even higher penalties, up to 50% of the unpaid amount. Notwithstanding these compliance measures, the ATO will adopt a facilitative compliance approach in the first year. Unpaid super affects thousands of Australian workers. Statistics tell us that young workers are disproportionately affected. And when employers go bust, the impacts can be even more severe, costing workers tens of thousands of dollars. So there's a deal of urgency about this matter, because every week that passes sees more workers duped and robbed of the money that their super accounts are owned. But there's still a logical imperative to passing the bill, because there's a deal of work to be done by employers' funds and the ATO to build the system for its implementation. Deputy Speaker, in 2007, Paul Keating made the following remarks when talking on the story of modern superannuation. As with all things, something on this scale requires imagination. It also requires conscientiousness and for leaders and ministers to take responsibility. We have already left most comparable countries well behind, but to add to mandatory superannuation from here will require an extra dimension. It will require the defeat of the Howard government. Only Labor governments will return to the as-yet unfinished retirements and savings agenda. But the years are ticking by, and with each one we are losing the compounding effect of savings and the wider opportunity to set the nation up for the future. Paul Keating was right. Only Labor governments can deliver on something as visionary as super, because only Labor has the imagination. And Labor has the ministers capable of taking the necessary responsibility. And we have, as Keating has put, left most comparable countries behind. Our superannuation guarantee system is the envy of the world, and it will only be embellished and strengthened by passing this legislation. I commend the Treasurer on the development of the bill. It makes this member for Werriwa stand tall. I commend the bill to the House.
I thank the member for Werriwa and I call the Assistant Minister.
Deputy Speaker, I move that the debate for this bill be adjourned.
The question is the debate be adjourned and the resumption of the debate be made in order of the day for a later hour this day. All those of that opinion say aye. Of the contrary say no. I think the ayes have it. And I call the clerk.
Government business, order of the day number 8, Fair Work Amendment, Baby Prayers Bill 2025, resumption of debate on the second reading.
The question is that this bill be now read a second time, and I call the member for Goldstein.
Thank you, Deputy Speaker. Deputy Speaker, this legislation is an important piece of the patchwork of industrial relations law for the Commonwealth of Australia. It's hard to imagine the scenario that could present itself. A happy family, expectant and excited for the birth of a new child, parents looking to the future, sometimes whether it's the first child or if it's a continuation of their family, only to be struck down by the brutal reality of having a child die shortly after death or a stillborn child. That was the story of Priya's family, who after 42 days lost never to be able to go on and live a full life. And the tragedy of what occurred was that in their suffering and in their grief, while Priya's father was able to secure the leave and continue on paid parental leave to deal with the grief and loss of losing a child, the mother was in a difficult situation where their paid parental leave didn't continue. This is one of the most tragic and heartbreaking stories that you could ever hear as an Australian, because I think we all believe that in these times of deep, dark moments of life, that the only thing we could extend to our fellow citizens is a sense of compassion and empathy for the tragedy that has been lived. And of course, their story is not alone in living with the reality of a stillborn child or having a child that has sadly passed away shortly after death. And that in that situation, every person who has lived with that reality deserves the most incredible warmth, generosity and empathy from those in their care and support network and their employment to make sure that they are able to manage and deal with their grief. So this bill is about respecting the fact that nobody should be forced back to work while they're dealing with the urgency of that grief. This bill is about recognising that as terrible as the situation that befell the family of baby Priya, the legacy of her life and her love will live on by making sure that nobody else need live it again. And so the Fair Work Amendment, Baby Priya's Bill 2025, is a bipartisan effort on this House to make sure that it isn't lived again. It was an issue that arose during the last federal election, and the Coalition gave a bipartisan commitment that we would honour, regardless of who won government, to deliver this change in law. And in doing so and supporting this bill today, we are delivering on that promise. It's important in recognising that the importance of the humanity and the compassion that must ultimately underpin our employment laws, particularly at a time of maximum vulnerability for so many Australians. Because while we might sometimes in this place talk about dollars and cents and wages and industrial frameworks, abstract rules, the place of unions, organisation, superannuation has just happened then. Sitting behind all of those conversations are people, dignity, lives and families. But just as we face the challenges of what happens when we have workplace deaths and the fact that lives will change forever, it is nothing in comparison, of course, to the tragedy of what would happen when a family loses a child in such a way. So this bill seeks to address that and to address in terms of industrial relations instruments to make sure that families have a pathway forward. This bill amends the Fair Work Act to introduce a new principle that unless employers and employees have expressly agreed otherwise, that employer-funded paid parental leave must not be cancelled because a child is stillborn or dies. The bill aligns with the Fair Work Act with the government-paid parental leave scheme. It's about ensuring compassion, it's about ensuring dignity, and more important, it's about honouring and respecting the need to manage grief and to honour the lives that are lost, and for families to be able to support each other through these difficult times.
because when families endure the unimaginable scenario of losing a child, the law should never compound cruelty or to the tragedy or add to the fate. It should not be a debate that leads to a dispute about when leave begins or ends. It should be about respect and treating Australians with respect and kindness in the workplace in these moments of grief. And it's with this reform we're putting a place in a guarantee that in those darkest of times, in those darkest of moments, ones of which we hope none of us will ever have to live through, that the system is going to stand by mothers and fathers and support them to be able to live out and to support each other. But this bill is also about honouring Priya's memory and her legacy of love. That what her family endured is something that no family should ever have to endure again. By ensuring these protections, we're turning this heartbreak into a legacy of love. And it will be a gift to other families who tragically experience the same circumstances and ensure that it is not befallen on other members of the Australian community. By passing this legislation, we're sending very clearly a message to the Australian society that we're not going to look away in moments of grief, that this Parliament is there to back people, to back families, to support them, and we acknowledge and support and stand by them at their most vulnerable moments. In this moment, we also want to extend our incredible gratitude to Priya's family for being prepared to come forward. I can't imagine, Deputy Speaker, the scale of the challenge that was faced by Priya's family, but then the courage to be able to stand up and bring attention to their plight and their situation that has led to this legislative change. I genuinely can't. That out of grief and tragedy they have seen the responsibility that they could give such love and gift to others. And it's at this time that I want to express our gratitude from the Coalition, because in the midst of this unbearable loss, you have found that courage to lead. That bravery has reminded everyone in this Parliament and the country of the importance of decency, of kindness and humanity, and of course of this legislative change, which will be the ongoing legacy. It's easy for politicians to talk about these sorts of important values, but it's much harder for families to live through them in these difficult times. And you've done that, and Australia will be better for it, but you're not alone, because there are other families who have had to endure these challenges as well. And I want to particularly recognise those who have walked beside Priya's family to get to this moment, in particular Bears of Hope, an organisation that helps families who experience the loss of their baby who have been part of advocacy for this bill. Because this bill is not just about the case of Priya's family, though it may have been the catalyst for change. It's about setting a standard for all of us, but also honouring those stories and those families whose stories didn't make it all the way into this chamber and may not have got the attention they so justly deserved. And when we reached out to Bears of Hope and asked them about some of those stories, people were so generous in coming forward because they understood how important this moment was for honouring not just their experience, but of course the legacy of their loved ones. And Deputy Speaker, I've de-identified some details just to ensure to respect the honour of the legacies of those past, but I don't want in any way for those families to be misinterpreted that I'm seeking to dishonour the memory of their lost child. One story. In 2021, I had started a new job in the private sector, and not long after, my wife and I found out we were excitedly expecting our second child. Being a new employee, I had no leave or sick leave accrued. I mention this because in June 2021 we received the news that our baby boy had a terminal diagnosis and he would not survive the pregnancy. Initially, the workplace was supportive, whilst I used that minimal leave I had to attend appointments with specialists. Place also like funeral parlour to discuss cremation versus burial and then return straight back to work. When discussing the inevitable with my manager and letting her know that it was my intention to use the 2 weeks half-pay parental leave, yes, 2 weeks half-pay, that's all dads get, this was her reply. 2 weeks half-pay. Why are you going to take 2 weeks? Do you even need 2 weeks? I mean, it's not like you're going to have a baby at home to look after. Luke was born sleeping on the 19th of July 2021, and I was requested back to work on the 30th of July 2021. Second story. I'm unfortunately a bereaved parent who also experienced the unconscionable lack of empathy and support from my employer at the time, who I provided my dedicated service for many years. My twin pregnancy was extremely high risk with complications which my employer was aware of. I ended up giving birth at 23 weeks and 5 days pregnant. I notified my employer, and then my twins tragically died in the NICU at 4 days old on 16 April 2021. Mere weeks after my twin daughters' funerals, I was contacted by my employer at the time asking about my return to work. This was of course met with confusion and shock for me, given I had pre-approved paid maternity leave, which was to commence upon the birth of my daughters. They referred to their employee handbook stating that the paid maternity leave is only for parents who are the primary caregiver of a child, and given my regrettable circumstances, I was no longer eligible for the company-funded parental leave. I was in complete shock that in such a dark, tragic time of my life, I was then treated with such a lack of empathy and disregard for my circumstances. I couldn't believe that I remained eligible for parental leave payments from Centrelink, who was acknowledging that I'm still a parent who gave birth and still required time off work to recover and heal regardless of whether my children were alive or not. Yet my employer, whom I'd been loyal to for many years, could make such a heartless decision, making an extremely dark time for myself and my family even worse. I was then faced with negotiating a return to work plan with my employer instead of having those sacred days and weeks to heal and grieve my children and face my new reality. I had no choice but to take unpaid maternity leave from my employer, who wasn't very willing to accept it. It was so unfair and made an already tragic and heartbreaking time in my life even worse. I'm writing this to help in any way that I can, as I don't want any bereaved parents to face the same heartless circumstances so many of us already have due to an inhumane lack of empathy from employers. Another story. This past August, I gave birth to a stillborn baby at 39 weeks and 4 days. Before our baby's arrival, my husband and I had arranged our parental leave with our respective workplaces. I was set to take a combination of unpaid maternity leave and government parental leave for 12 months. My husband had arranged 2 weeks of paid paternity leave from work and 2 weeks of paid parental leave through the government. I want to share what happened after our baby's passing. I gave birth on a Sunday. The following day, my husband called his workplace to inform them of our loss. He was told he would be only entitled to 2 days of bereavement leave. This was devastating for me to hear at the time. I felt that I would be left to grieve alone without my husband by my side. My husband, on the other hand, was also in shock and trying to process the sudden loss of our child, and he was not in a fit state to return to work. After a period of uncertainty, we were told that his manager had to escalate the situation to HR to seek approval for him to retain his paid paternity leave. While the leave was eventually approved, his workplace also questioned whether he still needed 4 weeks off. At the time, this felt deeply invalidating. It made me feel like our baby's death didn't matter or was an inconvenience for the company. The stress and uncertainty during this time were immense. Being given space to grieve is not a luxury, it's essential. Parents need time to support each other through the trauma of losing a child. It is heartbreaking to know that others in our situation are expected to return to work so soon before they have had a chance to begin healing. The 4 weeks we had planned to spend bonding with our baby were instead spent navigating grief, engaging with support services, seeking counselling, waiting for our baby to be returned from autopsy so we could spend a few final hours together arranging a funeral and trying to find a way forward. Parents should be given adequate time to come to terms with their loss. Honouring paid parental leave entitlements is the least that can be done. Offering just 2 or 3 days of bereavement leave is simply not enough. We spent 2 to 3 days in hospital holding and cherishing the very short time we had with our precious baby. This time was priceless for us. I fully support Baby Priya's bill and know it will make a difference to parents who leave the hospital with empty arms and broken hearts. I work as a registered nurse, and I had my stillborn daughter at 33 weeks and was supposed to go on maternity leave at 36 weeks. My CEO cancelled my maternity leave and allowed me to have 2 weeks of compassionate leave from my own sick leave, might I add. I understand that in our employee agreement that there was a clause in there that I had a fetus born at 12-week gestation and for it to live they would have allowed maternity leave. This is absolutely ridiculous. I was now in the pits of my grief and severe stress, as I have a mortgage to pay and need to pay for this. I felt that I was in a corner with nowhere else to go, but to go back to work life, nothing has happened. While still bleeding and recovering from birthing my dead child. Being a nurse and in the health industry, I felt that I should have been more supported, but unfortunately was not. Even more kick in the teeth was that I found out a few years before my time that a higher-up manager also had a stillborn and they paid her maternity leave. No parent should go through losing a child. I would not wish this on my worst enemy. Workplaces should honour their maternity leave regardless of the circumstances of their loss. Deputy Speaker, reading these stories is heartbreaking. Reading these stories into the nation's record is actually one of the hardest things I have done in this role, but is nothing in comparison to what those who have lived them. We can't take back the past, the decisions that people have made, the absence of empathy that people have lived. But we do have choices. We have choices about the type of country we want to be, the type of laws we want to live out, and the changes that we can make so that people don't have to live these situations again. There are, of course, lots of conflicting issues that can arise. But when it comes down to it, no matter who the employer is, I have no doubt in the overwhelming majority of businesses, employers, across this nation in the situation where people have a stillborn child or a child who dies shortly after death during a period of paid parental leave, that their first course of action is the most incredible wave of empathy and support for the parents who have lived the most incredible tragedy. Sadly, unfortunately, there will always be a few outliers. But I have absolutely no doubt in my mind that the overwhelming majority of Australians do the right thing to support those families, to work with them, and to give the assistance that's required. And there will be some people, stoically, who will want to find a pathway back to employment as part of their managing their own grief. How they do that, I don't quite understand, but that's not a matter for me. That's something for them and their employer, and the bill provides a pathway for people to do that based on their own unique circumstances. But it is so important that we set a standard about the tragedy that occurs and the pathway for the law to recognise the tragedy that exists, the grief that is lived, and how the law must change to respect and reflect that, to support those in that incredible stage of time. And so that is what we're seeking to achieve in this amendment. It ensures that when Australians face grief, their workplaces and their laws reflect the best of our national character as Australians: fairness, respect, compassion. It also reminds us as legislators that the true meaning of society is how we treat people in their moments of vulnerability, including honouring loss. Because that is not just what this bill does, but of course it empowers those who have gone through the most unimaginable tragedy. And by passing this bill, we're sending a clear message in Australia that no family grieves alone, and no parent should face the indignity of loss, and certainly not alone, as Priya's family faced. I'm respectfully incredibly proud to support this bill with the support of the Coalition. It honours Priya's memory and her family's courage, and to all families who have experienced such devastation. And I hope this reform stands as a reminder to all of us in this place that beyond the politics that sometimes leaves this place feisty, our duty is to bring decency, kindness and humanity into the laws of our nation. And that this is a legacy of reform, and this is a legacy to baby Priya and to the love to her from her family that will bring this Parliament together. And I call on all others in this Parliament to support this bill, to be part of making sure that no other family ever has to endure what Priya's family and the other families that I have read out and those who have not been recorded into the Hansard have lived, or accept that we are choosing to knowingly allow the status quo to continue for those families in loss and grief. Thank you, Deputy Speaker.
Thank the member for Goldstein. The question is that this bill be now read a second time, and I call the member for Melbourne.
Thank you, Speaker. I rise today to contribute to the Fair Work Amendment Baby Priya Bill 2025. This bill delivers on a clear and compassionate Labor election commitment. At least you didn't get to know your baby. It's better this happened now than later. You can always try again. These are things that were said to me when I experienced the devastating loss of my stillborn, nameless baby. Words meant to comfort, instead they cut deeply into my grief. At the time, I felt angry and pain at how misunderstood I was. If the people that were closest to me were unable to understand the extent of my loss, how can we expect our employers to know what we are going through? We can't. Losing a child at any stage is profoundly painful, yet stillborn and infant deaths are often met with silence, discomfort or avoidance. Despite how common they are, society rarely creates space for open, honest conversations about them. By enshrining this in law, we acknowledge their existence, honour their parents' grief, and affirm that their brief lives matter. By giving families the recognition and support they deserve, we help break the silence that so often surrounds stillbirth and infants' deaths and create a culture of compassion, understanding and remembrance. Many people who experience pregnancy loss feel isolated in their grief, partly because it's not widely acknowledged or understood. There's a tendency to minimise the loss, especially when the baby wasn't born alive, which only deepens the pain for grieving parents. The lack of public dialogue also makes it harder for people to seek support, share their stories or honour the memories of their babies without fear of being dismissed or misunderstood. Breaking this silence is essential, not only to validate the experiences of those who have lost a child, but to foster a more compassionate and informed culture around grief and pregnancy loss. This bill allows space for families to honour their loss and grieve, something I wish I had time to do. The Labor Party has committed to introducing legislation that ensures working parents who experience the unimaginable heartbreak of stillbirth or the early death of a child are still able to access their employer-paid parental leave. This vital change recognises that grief does not ease the need for time to heal, to mourn and to begin processes such as a devastating loss. Where parental leave entitlements exist in a worker's employment conditions, this promise would protect a grieving parent's right to take the time they need without being forced to return to work in the midst of their sorrows. This commitment was made in direct response to the advocacy of baby Priya's parents. This bill bears Priya's name. Priya died when she was just 6 weeks old. Her parents' story is one of extraordinary courage and perseverance in the face of unimaginable grief. They choose to use their voice not only to honour their daughter's memory, but to fight for change so that no parent would have to experience what they went through. I am so grateful for the strength of Priya's parents, because when I and many people like me grieve, we can't always find the strength to speak out. Grief can be so heavy it stops us in our tracks. That's why I'm so deeply grateful to those who can, to those who have the courage. The courage moves where others cannot. Their voices carry us all. This bill is their legacy, and on behalf of parents who have experienced this loss, I thank them. It is a testament to the difference that determination, compassion and advocacy can make. The loss of a child is every parent's worst nightmare. It is devastating, it is life-altering, and is something that changes families forever. In those moments, parents shouldn't have to worry about workplace politics, legal ambiguities or administrative hurdles. They should have certainty. They should be given the time and space to grieve, to heal and to support each other. This bill provides that certainty. It says clearly, if you have an entitlement to employer-funded paid parental leave, the fact that your baby has died or was stillborn will not strip that entitlement away. It is a simple principle, but is profoundly important, and I know exactly how devastating a loss it can be. Speaker, under the current system, there is a troubling gap. Employers are not legally required to provide paid parental leave. That remains a matter for workplace arrangements and contracts. But many employers do provide generous schemes, reflecting the reality that supporting parents benefits everyone. It builds loyalty, improves retention and continues to a fairer society. However, many of these schemes are silent on what happens if a child is stillborn or dies early in life. There is no clear entitlement, there is no clear legal position. That uncertainty is unfair on parents, but also on employers who want to do the right thing but are navigating untested legal ground.
Some employers continue to provide paid leave, others feel they cannot. And some have unfortunately refused leave, relying on silence in the agreement. Parents in those circumstances are left not only to grieve their child, but also fighting for the leave they expected to rely on. This is a cruelty no one should have to endure. This bill closes that gap. It establishes a clear prohibition on employers must not, because of the stillbirth or death of a child, refuse to allow an employee to take employer-paid parental leave to which they would otherwise have been entitled, or cancel any part of that leave. There are, of course, sensible exceptions. This rule does not apply where the employer's terms and conditions expressly allow cancellation or refusal in these circumstances. Those terms make clear that no leave is provided, or where other forms of paid or unpaid leave are provided that specifically addresses these circumstances. Employees also retain the right to refuse that their leave be cancelled, recognising that grief is personal and parents may choose different paths. Importantly, the bill stops any employer from moving the goalposts after the law takes effect. The bill is not about interfering with good faith bargaining. The ability of employers and employees to negotiate enterprise agreements that go above and beyond the national employment standards remains a pillar of Australia's workplace relations system. Bargaining leads to better outcomes for employees through fair conditions and for employers through certainty and engagement. This bill respects that. It sets a minimum floor of protection while maintaining the flexibility of workplaces to negotiate arrangements that suit their circumstances. Employers can continue to innovate and lead on parental leave. This bill simply ensures parents are not left in limbo if tragedy strikes. The bill will apply broadly from the date it commences. It covers national systems employees, that is virtually all private sector employees in every state except Western Australia. It will not apply retrospectively, but from commencement, employees who are entitled to employer-funded paid parental leave will be covered by these protections. This approach ensures that families receive certainty as soon as possible. This bill aligns employer-funded parental leave with the treatment of stillbirth and infant death under the National Employment Standards and Government Parental Leave Pay. Unpaid parental leave and government parental leave pay already provides clear rules in these situations. By bringing employer-funded schemes into line, this bill reduces confusion and simplifies compliance for employers. Penalties align with existing Fair Work Act provisions. The definitions mirror existing legislation, including the definition of a stillborn child and the definition of child from the Family Law Act. The bill applies equally in cases of adoption and surrogacy, ensuring all families are treated consistently. This bill provides clarity that benefits employers just as much as it benefits employees. This bill does not mandate new leave schemes. It does not force employers to offer paid parental leave. What it does is provide a clear legal framework for those who already do, ensuring everyone knows where they stand in the most difficult of circumstances. This bill is about fairness. It's about compassion and it's about delivering on Labor values. Labor has always believed in supporting working families, from paid parental leave itself to reforms like this. We recognise that good workplace conditions do not just happen. They are built through careful policy, strong advocacy and governments that care. Supporting parents through the worst moments of their life is not a nice to have. It is something any decent society should do. I again want to pay tribute to Priya's parents. Through their grief, they found the strength to advocate for change. Their efforts have been instrumental in bringing us to this moment. And I acknowledge the many other parents, advocates and organisations who have fought for these changes over many years. Their voices have been heard. They are no longer lost in the silence. In moments of grief, families should not face legal uncertainty. They should not have to plead with their employers. They should not have to fight for the entitlements they expect. This bill ends that uncertainty. It provides clarity for employers. It provides compassion for parents. It honours the memory of a little girl whose short life has inspired lasting change. This is what good lawmaking looks like: practical, humane and deeply grounded in real experiences of Australians. I commend this bill to the House.
Hear, hear.
I thank the member for Melbourne. The question is the bill be now read a second time, and I call the member for Riverina.
Thank you, Deputy Speaker. I admire the member for Melbourne. It's not often that in the House of Representatives chamber, when there aren't a lot of us in the chamber, but somebody gives a speech and it's listened to attentively by the Minister at the table, in this case the Assistant Minister, Member for Fremantle, by the Shadow Minister, in this case the Member for Wannon, and by all sitting in the chamber. Quite often we're getting on with paperwork and scrolling on our phones and doing the House duty that we normally do, but everybody stopped and listened. And this is for the second night in a row that the Member for Melbourne has given a speech, heartfelt and personal, about her experience in this tragic circumstance of losing a bub. So thank you, Member for Melbourne. Thank you for bringing your story to not just the House of Representatives, but through it and your beautiful words to the nation. And that would have been really hard, and I know that. And my heart goes out to you. As I said last night in the Federation Chamber, my late mother Eileen had a stillborn baby which she carried full term. And Deputy Speaker Freelander, I know you've delivered a lot of babies. This poor little bub, beautiful little blonde-headed boy, died the night before he was due to come into the world. And on the 15th of July 1972, and Mum carried those mental anguish and scars for the rest of her life. And it wasn't much talked about in the early 70s. Thankfully, we are much more open as a society now, and it is much more talked about. And on this legislation in particular, the Fair Work Amendment, Baby Prayers Bill 2025, I also do want to thank Michaelia Cash, the Coalition Senator, for the work that she has done in this space when it was first raised, and I appreciate that it is a government bill, and good on the government for bringing this important bill to the Parliament. We will never know the identity of baby Priya, and nor should we. But that little girl who passed away just 42 days old, her legacy will be something that is powerful for particularly mums, but parents right across Australia, fathers too, who lose a loved one, either in a stillborn situation or very much in infancy. It will make an amazing and remarkable and much needed and timely change to their lives. It aims to change the Fair Work Act so that employers cannot cancel employer-funded paid parental leave if a child is stillborn or dies. And I just want to dwell on the experience of two ladies from the Riverina who've started an organisation which is bringing hope to heartbreak. And they have formed the Villamar Community. It was an organisation founded by Megan Gaffney and Beck Baker after both women lost their daughters, Ruby and Mia. Now, a couple who I know very, very well, Sam Armstrong and his wife Maddie. I've known Sam since he was a little boy playing alongside my youngest son Nicholas in Aussie Rules competition, junior Aussie Rules competition in Wagga Wagga. And he was always a lovely kid. He's grown up to be a wonderful, wonderful man. And he and his wife found out that their little girl, Joy, her heart had stopped beating at 8 months pregnancy. How heartbreaking would that have been? And Villamar, through Megan and Beck, came to Sam and Maddie's assistance and Beck was able to explain what was going to happen. Megan visited after Joy was born and helped the Armstrongs with keeping keepsakes of Joy, as well as a promise of ongoing support. And that's heartfelt, that's genuine. But it was a quote in the Daily Advertiser, just yesterday, timely as that was, that Mrs. Gaffney said that her experience was that the doctors and nurses were absolutely beautiful, but something was missing in the stillborn tragedy. She said there was no heartfelt photography, but it was this sentence that stuck in my mind. Nothing like that. We received a folder that had Centrelink forms in it, and off you go. And that's really bringing home the harsh reality that you're trying to cope with the traumatic loss of a loved one, of a family member who you have to bury in a tiny coffin. My late father Lance went through that on his own, and this situation, at least they won't have the awful reality of having their rightful due being cancelled by an employer at a time of grieving. And it is a huge time of grieving. And no more will they just have to get on with life. They at least will have that time to grieve, and at least the financial security of knowing that they have this legislation in place to provide them that comfort and support. As I say, Priya's parents deserve great recommendation and commendation. Her mum has chosen not to be identified, and that is fair enough, absolutely understandable. But after she lost Priya, she soon found herself in negotiations over returning to work. How hard must that have been? And her husband said, I thought at the time that it was terribly unfair. I got leave and she didn't. Around 1% of babies born in Australia each year are stillbirths or result in neonatal deaths. And 6 babies are stillborn every single day. Now that is according to the Australian Institute of Health and Welfare. That's 6 families grieving every single day. And it's hard enough to explain to family and friends, let alone just acquaintances, why you're not pushing a stroller down the street, why you're not going to the local coffee shop with the new bub in your arms, let alone having the necessity to return to work straight away because there aren't the security measures in place to help you. The baby Priya bill has been introduced, and I say to the government, thank you. Well done. The Coalition supports it. Senator Cash, before the election, gave an assurance that the Coalition would support it, and this is perfectly understandable and appropriate, because this is a difficult subject area, and no one understands this more than mums who've lost bubs. So to the member for Melbourne, to Maddie Armstrong, to those who have founded the Villamar community in the Murrumbidgee local health district, our hearts are with you, our condolences are there, and now we have the proper security in place that for other mums who will be in your shoes in future years will at least have the comfort of knowing that they are supported in this time of grief. And I also want to acknowledge a journalist at the Daily Advertiser who wrote this story, Jack Marshall, who wrote, "The professional distance of a journalist is impossible for me here, as I carry the memory of my own daughter, Hope, who died shortly after she was born in 2007. Infant loss carried such a stigma when we had Hope, and to a point it still does, but two women who have also suffered loss have created the Villamar community, helping families navigate their infant loss story. And the journalist went on to talk about Megan Gaffney and Beck Baker and the role that it is playing in my local Riverina area. And I do thank them. And I also do thank baby Priya's parents, her brave parents, because whilst we don't know baby Priya's identity, the name will forever be attached to this very appropriate and emotional legislation. And the parents of Priya, they got 30,000 signatures in their advocacy. And you can imagine being in their position. And many mums are, many parents are. But it's especially hard on mums. But they made their campaign count. They brought it to Canberra. They knew it was right, and they had listening ears in government. And to those people in government who've made this legislation possible, again, I say well done. Bipartisan. I think this Parliament is best when we come together on legislation such as this, which is righting a wrong. And it wasn't a wrong that was, although it was called by Priya's dad terribly unfair, and it was, but it was one of those things which was probably just unnecessarily and unwittingly overlooked. But we've fixed that. We will fix that with this legislation, which will no doubt pass the House of Representatives with the support from both sides of politics. And this is when politics is at its best, when we can come together on common agreement for particularly a social cause such as this, and particularly to support those mums who don't deserve to have this impact on a time of their lives which is so otherwise devastating. Thank you.
I thank the member for Riverina. The question is that this bill be now read a second time, and I call the member for Boothby. Hear, hear.
Thank you, Deputy Speaker. This is a bill that I think tugs on the heartstrings of all in this chamber, and I thank the member for Riverina for his heartfelt offering. I unfortunately missed half of the member for Melbourne's offerings, but it is pleasing that it is a bipartisan approach. As a mother of three who went through a high-risk pregnancy and had 3 babies in NICU, the neonatal intensive care nursery, this bill really tugs at my heartstrings. Can there be anything worse than the death of your child? My heart rebels at even the thought of it. And to have a child die while your body is still recovering from it and from carrying and bearing it, picking out a tiny coffin and farewelling your beloved, much longed-for child while the paint on the nursery is still fresh. It really doesn't bear thinking of it. Australia is one of the safest places in the world to have a baby, but tragically we know stillbirths and infant deaths do happen. And so I'm speaking here today on a matter of profound human and ethical significance, on the Fair Work Amendment, Baby Priya's Bill 2025, a bill born from heartbreak and now transformation, a bill named after one brief but powerful life, the life of baby Priya. And today we're asked to do more than amend legislation. We're asked to affirm that when grief visits our citizens, the law will not abandon them.
Hear, hear.
This bill is born of a terrible grief, a grief we would not wish on anyone, and of compassion for that grief. This bill is for baby Priya and her parents.
Hear, hear.
In June 2024, a little girl named Priya was born prematurely at 24 weeks and 6 days. She battled for life for 42 days and then tragically the fight ended. Her mother, an employee of a large workplace, notified her employer of the death of her daughter. Just 5 days later, she was told via text message that her approved employer-funded paid parental leave had been cancelled, replaced instead with just 1 month of personal leave. Priya's father was able to retain his full paternity leave in the New South Wales industrial system, and he commented on how deeply unfair this was. Priya's mother, grieving the loss of her child, faced not only the deepest sorrow, but also the corrosive uncertainty about returning to work, about her leave, about how she would carry on. We should not and cannot allow that to stand. The experience of baby Priya and her parents is rare but not unknown. In 2022, more than 3,000 Australian families lost a child to stillbirth or in infancy. Those parents, these families, deserve our compassion. They deserve certainty. They deserve the knowledge that when they have been preparing for paid parental leave, the death of their baby will not in itself strip away that entitlement. And that's what this bill seeks to achieve, to embed in the Fair Work Act 2009 a new principle that unless otherwise expressly agreed, employer-funded paid parental leave cannot be cancelled in the event of a stillbirth or infant death. It aligns the private sector entitlement with the Commonwealth Government Parental Leave Scheme, which already does not cancel payments in those circumstances. It is to fix a gap of humanity, a gap of fairness, a gap in compassion, and a gap in our National Workplace Relations Code. Speaker, it also helps employers and managers who no longer have to make the call on whether parental leave still applies or not. It provides clarity and it strengthens workplaces. A workforce that feels supported in personal crisis is more likely to be sustained, more likely to be loyal, more likely to engage. Employers benefit from clarity in policy and from the moral economy of their workforce. As the Minister noted, putting this right is not only good for parents, but gives absolute clarity to employers. So how does it work? The bill amends the Fair Work Act 2009 by inserting a new principle to the effect that an employer-funded paid parental leave entitlement of an employee cannot be cancelled or ceased solely because the child is stillborn or dies, unless the employer or employee have expressly agreed otherwise. The bill preserves the ability of employers and employees to negotiate alternative arrangements, recognising that enterprise bargaining flexibility remains central to our workplace relations framework. The bill clarifies an area of ambiguity in existing law. Currently, the ability of an employer to cancel paid parental leave is determined by whatever policy or contract applies, and there's no clarity in the national system. It sends a message that when Australians experience the worst imaginable loss, they should not then face a sudden withdrawal of the very support they were counting on. And by enshrining this principle, we give grieving parents time and space, not simply to grieve, but to recover, to navigate the next steps and to live again. Speaker, at the heart of this bill is a principle of decency and respect. It says that your place of work will not punish you further in your darkest hours. It says we will respect and honour the depth of what you are going through and the impact the short life of your child has had and will continue to have on your life going forward. As one grieving mother said, it made a big difference to me just to have the space to deal with those emotions. It's just an unfair situation. In short, this bill is a moral, practical and economic imperative. Speaker, this will not impose undue burdens on employers. The bill does not enforce employers to provide additional leave above what is already agreed under enterprise agreements and policies. Rather, it ensures that an existing employer-funded paid parental leave entitlement cannot simply be taken away because the child did not survive. Many employers already treat these tragic cases with humanity, and what we are doing is removing uncertainty and codifying a standard of decency. It Employers retain the ability to negotiate and agree policies for stillbirth and infant death situations, and that flexibility remains intact because we are aligning with what many employers already do. The additional cost burden is modest and in many cases non-existent for those workplaces which already honour full leave. And these situations, a stillbirth or a death of an infant, are thankfully rare, around 1% of pregnancies. Many employers will never have to deal with such a situation, others rarely. It's a matter of fairness, not a radical change. The entitlement only applies when an employer-funded paid parental leave entitlement already exists. The bill does not create a new entitlement where none existed. It preserves one where it has been approved and aligns its application with the event of a stillbirth or infant death. The risk of misuse in these tragic circumstances is negligible because the loss of a child is documented, verifiable and devastating. The bill explicitly allows negotiation and agreement between an employer and employee. It simply ensures that the cancellation of a pre-approved paid parental entitlement cannot be done unilaterally by the employer on the basis of stillbirth or infant death, and the core structure of enterprise bargaining remains untouched. As Minister Rishworth said, promoting enterprise bargaining and good faith workplace discussions is central to the government's approach. This bill is about dignity, belonging and fairness. For working Australians, especially parents, the transition to and from work should recognise that life does not pause for employment. The bill signals that our workplace relations system will not abandon someone in their grief. It complements other reforms that are about supporting families, extending paid parental leave entitlements to 24 weeks, adding superannuation to paid parental leave, focusing on flexible work and ensuring our workplaces reflect the modern family and modern expectations. In doing so, this bill also reflects the values Australia has long held, that we support families in their time of need, that we recognise the burden of loss, and that our laws act as a shield, not a burden, in the face of tragedy. Speaker, naming this bill after baby Priya is more than symbolic. It honours the lived experience of her family, and it ensures that the change we make is rooted in real people and, sadly, real pain. It reminds us of the cost of doing nothing. As Priya's mother said, my hope is that this law will grant parents the time, support and financial assistance that are rightfully yours so that you can take care of yourselves. In putting Priya's name on the law, we commit ourselves not to treat such events as just another HR matter, but as human moments deserving of empathy and protection. And the government thanks baby Priya's parents for their courageous advocacy in their time of grief, for bringing attention to this important issue and for making things better for those parents who sadly will follow behind them in experiencing the same tragic circumstances. This bill honours baby Priya, it honours her parents' advocacy and it honours what our society should be, compassionate, fair and humane. I commend the bill to the House.
Member for Boothby, and I call the member for Lyme.
Thank you, Deputy Speaker. It is a privilege to speak on this bill, one that is a reminder to all of us of the good work that this Parliament can do. This bill is a reminder that in the cut and thrust of what the public sees, this work goes on to address those issues that make us the very best of legislators and politicians. I come to this bill without the personal experience to fathom the loss, the pain, the grief, the day-to-day struggle to lose a child that a woman has carried, loved, cared for, talked and sung to, a child that will never get the chance to take a breath or never get to grow beyond those first few weeks. Humanity can be cruel, but worse is when policy and laws double down. I'd struggle to understand why there would be anyone in this place who would not support this bill. It is what I believe is an ethically, morally and technically correct thing to do. I want to take a moment to extend my deepest condolences to the thousands of parents dealing with the loss of an infant, a loss of a baby, a loss of a loved child. Words are few, but actions can mean a lot, and I hope that the passage of this bill with bipartisan support has the meaning beyond words. The Fair Work Amendment Bill 2025 will amend the Fair Work Act so employers shall not cancel employer-funded paid parental leave if an employee's new child does not survive. During the 2025 federal election, the Coalition offered bipartisan support to this bill, and today we give effect to that support. The bill is named after baby Priya, who passed away when she was just 42 days old. After informing her employer that her child had passed away, Priya's mother was faced with negotiating with her employer about a return to work she had not planned for at the same time as grieving the loss of her child. Priya's parents sought advice from the Fair Work Commission, who advised there was no further avenue to pursue. Priya's father was able to utilise 3 months of paid paternity leave through the New South Wales system, while Priya's mother faced returning to work. On the 17th of April 2025, the then Minister for Employment and Workplace Relations, Senator Dion Murray-Watt, committed to amending the Fair Work Act. On the 24th of April 2025, the then Shadow Minister for Employment and Workplace Relations, Senator Dion Michaelia-Cash, confirmed the Coalition's support for the bill to ensure individuals who suffer the tragedy of losing a child whilst on parental leave will not have that leave cancelled by their employer. Employee groups have been consulted and have raised no amendments to the bill and are supportive. A petition established by Priya's father for this bill has received over 32,000 signatures. And can I say, I simply cannot imagine the depth of character of Priya's father in that period of intense grief, to have the presence of mind to put in place a petition and fight for his child. That is an incredible, extraordinary human being. The bill has had the support of a unison of voices, from employers to organisations such as Bears of Hope, an organisation that helps families who experience the loss of their child. The bill amends the Fair Work Act 2009 to make entitlements to parental leave in cases of stillbirth or the death of a child more consistent, whether the leave is unpaid or paid parental leave. The bill only deals with the operation of entitlements to paid parental leave. It does not alter the existing provisions dealing with employees' entitlements to unpaid parental leave in the case of a stillbirth or death of a child. The bill will prevent employers from unilaterally cancelling periods of paid parental leave in cases of stillbirth. However, the bill will not prevent employers and employees from agreeing to cancel such periods of leave. Deputy Speaker, my speech today is a modest one because time is of the essence. To give parents the dignity and the time to grieve, the time to begin to heal in the face of unimaginable loss. This is good family policy. This is good work of this parliament, and I commend the bill to this House.
And I call the member for Bonner.
Thank you, Deputy Speaker. I rise to speak in support of the Fair Work Amendment, Baby Priya's Bill 2025, known as Priya's Law. This bill is a crucial step forward in protecting parental rights and ensuring compassionate bereavement care in the workplace. After 42 days, Priya's parents experienced the unthinkable. Their little girl had passed away. Only 5 days into processing this grief, Priya's mother notified her employer of more than 10 years of service. Although she received condolences and support from co-workers, her employer cancelled her 3 months of pre-approved paid parental leave. This left Priya's family uncertain, navigating HR policies whilst enduring the worst pain imaginable for a parent. Priya's parents have advocated tirelessly to ensure no other parent would face what they did. The Albanese Labor government committed to legislating a guarantee that working parents dealing with stillbirth or early infant death can continue to access employer-paid parental leave. This bill delivers on that commitment. I'm so pleased to see today that this bill will receive bipartisan support, and it has been a real privilege to listen to the contributions of all members today, but particularly the member for Melbourne, for sharing her deeply personal story. It is incredibly difficult to relive those experiences, and for her to share her lived experience with us today was an absolute privilege. Deputy Speaker, this bill is about dignity, compassion, and giving families the space and financial security they deserve when they need it most. It provides clarity for both parents and employers. It removes the distress of negotiating a return to work while dealing with grief and trauma. And it ensures employers do not have to make discretionary calls on whether a specific leave provision applies in the most difficult of circumstances. We know that Australia is one of the safest places in the world to have a baby, but tragically stillbirths and infant deaths do happen, with profound impact on parents, families, and of course the community. On an average day in Australia, more than 6 babies are stillborn and more than 2 die within the first year of their birth. In 2022, this resulted in over 3,000 families losing a child. Deputy Speaker, Priya's law amends the Fair Work Act 2009 to stop employers from cancelling employer-funded paid parental leave if an employer's child is stillborn or dies. This bill brings the framework around employer-funded parental leave in line with government-paid parental leave and existing unpaid parental leave entitlements. It applies to existing and future employment contracts and workplace instruments where the stillbirth or death of a child occurs after commencement. Importantly, this bill does not interfere with existing bargained entitlements. Many employers already offer express stillbirth leave entitlements, which will remain unaffected. It does not prevent employers and employees from bargaining and agreeing conditions in good faith. It also does not create a requirement for employers to provide employer-funded paid parental leave if it is not already offered. This bill also prevents employers from undercutting this reform by unilaterally changing existing terms and conditions of employment after commencement. Deputy Speaker, this bill also upholds human rights. It aligns with 7 core United Nations human rights treaties, including the right to enjoyment of just and favourable conditions of work, the right to an effective remedy and fair hearing, the right to protection and assistance for families, the right of women not to face discrimination on the basis of gender, and the right to protection of health and safety in working conditions, including reproductive function. This bill also addresses gender inequality. Women are more likely to take employer-funded paid parental leave following childbirth by protecting their leave in the event of stillbirth or early infant death. This bill fosters women's participation in the workforce, economic security, and autonomy to return to work when they are ready. Deputy Speaker, as I said earlier, more than 3,000 parents in Australia lose a child to stillbirth or within the first 28 days of life. Each loss is devastating. These rates have not changed for over 20 years. Stillbirth and neonatal deaths are higher in Aboriginal and Torres Strait Islander communities, culturally diverse communities, disadvantaged and regional communities. For example, in the Northern Territory, the stillbirth rate is 20 per 1,000 births, more than twice the national average. Addressing these inequalities requires improving healthcare access, education and reducing poverty, priorities that the Albanese Labor government is committed to and delivering on right across our country. October is also International Pregnancy and Infant Loss Awareness Month, reminding us of the importance of awareness, education and support for grieving families.
International Pregnancy and Infant Loss Remembrance Day is on the 15th of October every year, and we saw families around the world light candles in honour of lost children. This shows the profound need to break the silence and stigma around miscarriage, stillbirth and infant death. I acknowledge the organisations advocating for stillbirth and early infant death prevention, including the Red Nose Foundation, the Centre of Research Excellence for Stillbirth, the Stillbirth Foundation of Australia. They do tireless work together with many community organisations across all of our communities in supporting research and education. I also want to acknowledge the Services Union, of which Priya's mother was a member, for their support and collective action, including a petition signed by more than 30,000 Australians. I am proudly a member of the Services Union and thank them for their advocacy and support, not just for Priya's Law, but across many other issues just like this affecting families and women right across our country.
Yeah.
Following the introduction of this bill, many MPs shared the introduction of the legislation on social media. And I just wanted to share a couple of comments which reflect, I believe, the community's sentiment around this bill. Jean said, "How amazing is Priya's mum for her relentless campaigning through grief to make sure no other family goes through the same. You have created an incredible legacy for Priya and she would be so proud of you."
Yeah.
Elizabeth said, "I was shocked after giving birth at 24 weeks that I didn't qualify for parental leave while grieving back in 2011. Thank you for changing this. It will make a huge difference for those parents suffering." And Farik said, "Policy making is never ordinary. It's a profound responsibility. It demands groundwork, legitimacy, and a deep sense of ownership. When these elements align, policies become not just functional, but transformative. Bravo to the Prime Minister for championing the Priya's Bill, a compassionate response that has touched the hearts of countless grieving families. In moments of irreparable loss, this legislation offers dignity, recognition, and hope. Keep going."
Yeah.
Finally, I pay tribute to baby Priya and her family, whose advocacy has created a lasting legacy, ensuring no other parent will face the distress of having paid parental leave cancelled while grieving. Although baby Priya was only 42 days old, her legacy will be everlasting. This law is in her name. It is a promise. No parent will face this pain alone, and no grieving parent will be forced back to work while enduring the deepest loss imaginable. I want to share some words from baby Priya's mother, who said, "My hope is that this law will grant the time, support and financial assistance that are rightfully yours, so that you can have time to take care of yourselves." Deputy Speaker, I commend this bill to the House.
Yeah.
I call the member for Barton.
Thank you, Deputy Speaker. I rise to speak on the Fair Work Amendment, Baby Priya's Bill 2025. This is a bill about compassion, fairness and dignity. It's about how our laws treat people not only in their moments of strength, but in their most fragile and heartbreaking times. And at its heart, it's about a little girl named Baby Priya, a name that will now forever remind us that behind every policy, every clause and every line in legislation, there are real human stories. One of the reasons I chose to study law was because I wanted to work as a union lawyer. Why? Because when most people introduce themselves, they tell you what they do for work. Work is not just about earning a living. It's about identity, it's about purpose and dignity. And for so many Australians, the ability to go to work safely, to be treated fairly, and to be supported when life takes a difficult turn, that's what makes a society truly humane. For over a decade, I had the privilege of representing workers, nurses, construction workers, cleaners, people who simply wanted a fair go. I saw firsthand how moments of vulnerability at work can either bring out the best in our system or expose its cracks. The union movement and Labor governments have worked hand in hand to build a workplace relations framework that enshrines fairness and dignity, a system that many around the world look to with respect and admiration. And that legacy continues today with this bill, because of defending dignity at work is never an outdated cause. In today's world, where productivity and profit often dominate headlines, I can sometimes feel like compassion is losing its place in the workplace. But not here, not in Australia, and certainly not under an Albanese Labor government. This government understands that a fair and prosperous nation depends on how we treat people when they are at their most vulnerable. This bill fulfills an election commitment to stop employers from cancelling employer-funded paid parental leave when an employee's child is stillborn or dies shortly after birth. It is a small but profound reform, one that provides clarity to employees and employers, and one that reflects the best of who we are as a society. Baby Priya was just 42 days old when she passed away. Her mother, in the midst of unimaginable grief, found herself having to negotiate with her employer about a return to work she had never planned for. At the very same time, she was trying to process the loss of her baby. That should never happen to any parent. This bill removes that cruel uncertainty. It removes the distress of having to negotiate work arrangements during grief and trauma. It also gives employers clear guidance, sparing them from having to make discretionary calls in heartbreaking circumstances. It brings humanity into the legal framework of work. And I want to pay tribute to Baby Priya's parents for their courage in sharing their story and for transforming unimaginable pain into positive change for others. Their advocacy will ensure that no other parent in Australia has to face what they did. Deputy Speaker, as someone who has spent years both in the law and in community service, I've learnt that policy must always be shaped by empathy. In my work at St Vincent's de Paul Society, I've seen the faces of parents and families who carry grief quietly, people who come seeking help, not because they've failed, but because life has thrown them something no one should have to face alone. I've seen how compassion from others, with a listening ear, a bit of time, a small act of understanding, can mean everything in those moments. And it's those experiences that remind us that laws are not just instruments of governance, they are reflections of our shared humanity. As a lawyer, I also came to appreciate the importance of trauma-informed policy, because behind every case file or piece of legislation, there are people processing pain in their own way. A trauma-informed approach recognises that grief and trauma do not follow neat timelines. It acknowledges that the workplace, for all its structures and systems, is still made up of human beings. When we legislate with that understanding, we move beyond technical fairness to real fairness, fairness that sees people as whole, complex, emotional beings. And as someone who values family deeply, who believes in the bonds that tie us together through joy and through loss, I cannot think of a more important principle to uphold in our workplace laws than compassion. So what does this bill actually do? This bill applies to national system employees who are entitled to employer-funded paid parental leave. It ensures that if a baby is stillborn or dies shortly after birth, that parent is still entitled to the paid parental leave they had planned for. In essence, it brings employer-funded parental leave into line with government-funded paid parental leave and unpaid parental leave entitlements. It will apply to both existing and future employment contracts and workplace instruments, but only where the stillbirth or death occurs after the bill commences. It's also important to be clear about what this bill does not do. It does not interfere with existing enterprise agreements or entitlements. Many employers already have compassionate stillbirth leave in their agreements, and those will remain untouched. It does not prevent employers and workers from bargaining and agreeing to even better conditions in good faith. And it does not require employers to provide paid parental leave if they don't already do so. It just simply protects those who do. Finally, it prevents employers from undermining the intent of this reform by unilaterally changing terms and conditions after commencement. I think it is important to highlight two specific things in these reforms. Firstly, that they extend to death following birth. For many parents, the days and weeks after welcoming a new baby are meant to be filled with love, exhaustion, I'm sure the member for Banks has recently experienced, but also joy, but not loss. Sudden infant death syndrome is when a baby suddenly and unexpectedly dies and a cause cannot be identified. It's absolutely heartbreaking. Even with all the care and medical understanding we now have, these tragedies still happen, and the heartbreak ripples through entire families and communities. So whilst the rates of SIDS has thankfully significantly decreased, it still causes around 3 deaths per 1,000 babies each year. In those moments, time seems to stop, and what matters most is having the space and the compassion to heal. This reform ensures that they are able to grieve without the pressure of having to return to work or organise additional leave. Secondly, this reform extends to fathers as well as mothers, because we know that parenthood is shared, and this is loss that affects every person involved in childbirth. Equality means providing this leave for everyone, including same-sex couples, surrogates, as well as partners caring for their loved ones and grieving the loss of their own child. It is about recognising every parent in every kind of family and ensuring compassion is extended to all. This is sensible, balanced and compassionate lawmaking. Australia is one of the safest places in the world to have a baby, but tragically, stillbirths and infant deaths still occur, and their impact is profound, not only on parents but on families, workplaces and communities. For too long, our legal frameworks have been silent on what happens when tragedy collides with employment. When a parent's life changes overnight, our system must be flexible enough to protect them, not punish them. This bill closes that gap. It's part of a broader suite of reforms that recognise the evolving needs of the Australian families. The Albanese Labor government has strengthened government-funded paid parental leave, extending it to 24 weeks, and importantly ensuring superannuation contributions are paid during that period. Because paid parental leave is not just a family policy, it's an economic one too. It improves workforce participation, staff retention and gender equality. As an employment lawyer, I've seen how vital paid parental leave is in giving parents, especially mothers, the confidence to return to work, to progress in their careers and to continue contributing to the workforce without being penalised for having a family. And as someone who's worked closely with community organisations like the wonderful Binnies, I've seen how economic stress, unfortunately, can quickly spiral into a broader hardship. Policies like these help prevent that. They give people the time, space and stability they need to recover, heal and rebuild. Deputy Speaker, when we talk about dignity at work, we often think of fair pay, safe conditions and job security. But dignity is also about how we treat people in their darkest moments. This bill recognises that grief does not fit neatly into the workplace policy manuals or HR systems. It doesn't run to a timetable. It doesn't end after a set number of days. And for parents who experience stillbirth or infant loss, the trauma is not just emotional. It can be physical, financial and deeply isolating. Allowing them to access the leave they had planned is a gesture of humanity. It says you're seen, you're supported, and you are absolutely not forgotten. This is what dignity at work looks like. Now, this bill is not only good for workers, it also gives clarity certainly for our employers. As someone who has advised both sides, for the workers and also for the employers, I know that uncertainty in law often leads to confusion, conflict and stress for everyone involved. This reform provides a clear national standard. Employers won't have to make case-by-case judgments or interpret ambiguous contract terms in moments of crisis. It creates consistency, reduces disputes and promotes trust in the employment relationship. It's the kind of practical reform that demonstrates Labor's ability to balance empathy with clarity, to protect workers while ensuring workplaces function smoothly and fairly. Deputy Speaker, throughout my career, I've seen how moments of grief or crisis can reveal the true character of an organisation. When a worker loses a loved one, faces illness or endures tragedy, how an employer responds can make all the difference, Deputy Speaker, not just legally but humanly. In my time as an employment lawyer, I met many workers who were not looking for a fight. They just want to be treated with decency and compassion. And I've met good employers, and I must say there are a lot of good employers who wanted to do the right thing but lacked clear guidance from the law. This bill provides that guidance. It ensures that compassion isn't left to discretion. It's built into the framework of our workplace laws because fairness should never depend on luck or on who your employer happens to be. Deputy Speaker, the Fair Work Amendment Baby Prius Bill 2025 reminds us that lawmaking is not just about numbers, clauses or statistics. It's absolutely about people. It's about empathy. It's about ensuring that even in loss, Australians are treated with the respect they deserve. It tells every parent in this wonderful country that their pain will not be compounded by bureaucracy. Thank you.
The question is that the bill be now read a second time, and I give the call to the member for Werriwa.
Thank you, Deputy Speaker. This bill seeks to clarify the issue for families when a baby is stillborn or dies shortly after birth. Every day in this country, 6 babies die or are stillborn. 6 families are devastated and they need to plan how to live this new reality. In their grief, they should not also have to deal with changes to a work agreement, particularly at a time when they are least likely to cope. 32 years ago, I received flowers from my employer for the funeral of my daughter, Megan, who passed away at 5 days old. The next day, I received a letter from that same employer advising I was no longer on maternity leave, and if I wanted to continue my employment, I needed a doctor's certificate to say I was unfit for work. In our devastation, I had a week to provide that doctor's certificate. I was barely able to make a decision about whether I wanted a cup of tea or not, let alone go to the doctor and explain why I was there. This workplace was a major bank. There was no empathy at all. Without the certificate, I felt I might lose my job, having nothing then to use to contribute to my family. I felt trapped with mounting debts because of the funeral we had to plan that we didn't expect. And I ended up going back to work early. My maternity leave at the time was not even paid, so I was not even a burden to that employer, and they were a major bank. The bill before us then is something that we need. We need to be able to give families the choice to make the decisions that they need to make, and the bill will take away this further distress. Of course, Speaker, not all employers behaved like mine did, and certainly none do now. But the issue sadly remains that in some workplaces that this is still an issue. And that's why I am pleased and relieved to see that this item has been brought forward for consideration. The bill honours the name of baby Priya, who was just 6 weeks old when she died. But this bill honours far many more children than just baby Priya, and I take this opportunity to thank her parents for their constant advocacy, because they've used their loss and devastation to make this bill better and make our workplaces better. This bill, Deputy Speaker, provides much needed clarity for both employers and grieving parents about their entitlements should their child be stillborn or pass away. Specifically, employers do not have to provide paid parental leave. However, the legal position is unclear in workplaces where there is paid parental leave, but there are no explicit entitlements addressing what will happen if a child is stillborn or dies. This is not right or fair. The bill before us means that an employer must not refuse to allow an employee to take the employer-paid parental leave in the event of the death of a child, to which they would have formerly been entitled. Further, the bill means that an employer cannot cancel any part of that leave. The bill also prevents an employer from amending a workplace policy by unilaterally verifying an employee's terms and conditions after the bill's commencement. Importantly, the bill will not stop employers and employees bargaining in good faith. That is, this bill does not interfere with specific entitlements that employers have negotiated above and beyond the national employment standards, which deal with stillbirth or the death of a child. This bill and its provisions will aptly apply broadly and specifically to the national system. Employees entitled to employer-funded parental leave, although there are some exemptions. Vitally, to ensure people are covered as soon as possible, employers entitled to an employer-funded parental leave will be covered from the commencement of this bill, but the bill will not apply retrospectively. Other matters contained in the bill relate to ensuring the compliance and penalties. Further, to reduce confusion and increase consistency, the bill uses existing Fair Work Act definitions where possible. Deputy Speaker, it is said that grief is not a sign of weakness nor a lack of faith, it is the price of love. In my experience and that of baby peers and every parent across our nation who has endured the loss of a baby, that is true. Some things in this place rise above politics, and this is one of them. We have come some way since my experiences those many years ago, but grief remains, as do the unanswered questions, and so do the unresolved matters such as this before it. As a nation and a parliament and a community, we can do better, and that's what this bill seeks to do. The bill will ensure that one of life's most vulnerable moments, matters relating to leave, will be addressed, and that will at least ease one burden for broken-hearted parents. For that, I thank the Minister, baby Pira's family for bringing this bill for consideration today.
Thank you. And I call the member for Aston.
Thank you, Deputy Speaker. I rise to speak on the Fair Work Amendment, Baby Priya's Bill 2025. The Albanese Labor Government is committed to ensuring that working parents who experience the unimaginable tragedy of stillbirth or early infant death can continue to access the employer-paid parental leave to which they are entitled. This bill makes that possible, where it is consistent with an employee's terms and conditions of employment and ensures that compassion and fairness guide our laws in the most heartbreaking of circumstances. Deputy Speaker, this bill is named in honour of baby Priya, a precious baby girl who passed away when she was barely 6 weeks old. Her life was so short, but her impact has been profound. The loss of a child is one of the deepest sorrows any family can face. It happened to my own mother and father, who lost their fourth-born son, their baby boy, Edmund, to sudden infant death syndrome. That was back in 1957. My dad could never speak of his overwhelming grief, having found baby Edmund in his cot. And my mum, when she did tell me stories of the brother I never knew, tears always welled in her eyes. He'd just learned to crawl. And this kind of loss changes families forever. It changes everything. And in those moments of unspeakable grief, no parent should have to confront the additional burden of uncertainty about their employment, their entitlements, or their financial stability. It recognises, excuse me, this bill is a testament not just to the strength of Priya's parents, but to their courage in channeling their unbelievable pain into purpose. And I pay tribute to Priya's parents for their tireless advocacy and for turning their personal tragedy into a call for justice and compassion. They have given voice to the voiceless, and in doing so, they have helped shape a reform that will offer dignity and security to countless families in the years to come. And no parent should have to go through this, but sadly, they do, and in future will as well, I'm sad to say. Deputy Speaker, this bill provides clarity for both employers and grieving parents about what happens to paid parental leave entitlements following a stillbirth or the death of a child. Under current laws where an employer provides paid parental leave, there is ambiguity about whether those entitlements can continue if tragedy strikes. That uncertainty is neither fair to employers nor to employees. It leaves families in distress at a time when they most need reassurance. This bill removes that uncertainty and restores fairness. Under the new provisions, an employer must not, because of the stillbirth or death of a child, refuse to allow an employee to take the paid parental leave they are entitled to or cancel that leave unless an explicit term of employment provides otherwise. It also ensures that employers cannot avoid these protections by later changing workplace policies or contracts. In simple terms, if an employee has earned and been granted paid parental leave, the loss of a child will not strip them of that right. This reform provides certainty and compassion in equal measure. It recognises that paid parental leave is not only about caring for a newborn, but also about supporting the profound transition to parenthood and the emotional and physical recovery that follows childbirth. Those needs do not vanish when a child tragically passes away. If anything, the need for support becomes even more urgent. Importantly, this bill does not interfere with the ability of employers and employees to bargain in good faith. Bargaining over entitlements beyond the national employment standards, such as employer-funded parental leave, remains a cornerstone of Australia's workplace relations system. The bill preserves that flexibility while making sure that compassion is built into its application. This reform strikes a practical and principled balance. It ensures grieving parents are treated with dignity and respect, while also maintaining clarity and workability for employers. For business owners, it provides clear guidance and legal certainty. For employees, it provides a certain level of comfort and security at a time of intense emotions and vulnerability. From commencement, these provisions will apply broadly to national system employees, covering nearly all private sector workers across Australia. It will not apply retrospectively, which ensures fairness and avoids legal uncertainty for existing arrangements. The bill also aligns employer-funded parental leave with the government's paid parental leave scheme and the unpaid parental leave provisions already in the Fair Work Act. This alignment helps reduce confusion for employers, employees and human resources professionals alike. It means the system will be simpler, clearer and more consistent across all forms of parental leave. Penalties for breaches will be consistent with those already contained in the Fair Work Act 2009, ensuring that the same standards apply across the board. The bill also maintains consistency by using existing definitions from the Fair Work Act and the Paid Parental Leave Act, providing continuity and avoiding unnecessary duplication or confusion. Crucially, these protections will extend beyond biological parents. They will apply in adoption and surrogacy arrangements, reflecting the many pathways to parenthood in modern Australia. Every family deserves to be treated with compassion and dignity, no matter how it is formed. This inclusive approach ensures that the law recognises and respects the diversity of Australian families. Deputy Speaker, this bill is about empathy, certainty and fairness. It ensures that in the face of unimaginable loss, parents are not left to navigate a maze of red tape or uncertainty about their rights. Instead, they will have the time, space and security they need to grieve, to begin the slow and painful process of healing without fear of losing their entitlements or their jobs. It is a small change in legislative terms, but for families enduring the worst heartbreak imaginable, it will make a profound difference. It says to those parents, your grief is seen and your loss is acknowledged, and your rights are protected. This bill embodies the very best of what this Parliament can do. It takes compassion and turns it into law. It ensures that our workplace relations system reflects not only economic fairness, but also human decency. Deputy Speaker, the Albanese Labor government believes in a fair go for every worker and in a compassionate society that looks after its people, especially as they navigate grief and their darkest days. And this is what this bill delivers. I commend this bill to the House.
Call the member for Brisbane.
Thank you, Madam Deputy Speaker. I too rise in support of this bill. And as we've heard tonight, this bill is named after baby Priya, who tragically died when she was just 6 weeks old. But this bill is about care, compassion, empathy and human decency. Baby Priya's bill will give financial certainty to parents after the loss of a child. Priya's mother received condolences and gifts from colleagues while grappling with the grief of losing her daughter. I can't imagine how you could even have the brain space to be able to do that. And Priya's mother notified her employer of 11 years. We're not talking somebody who just walked in the door yesterday, albeit that should make absolutely no difference, but her employer of 11 years who then cancelled her pre-approved 3 months of leave. At a time of heartbreak and grief, parents shouldn't be unexpectedly told it's time to go back to work or to be put in a position to make some form of employment decision. And I really do think Priya's mother and father should be proud of their important advocacy that has led to this important bill. And I think all Australians and those in my electorate can agree that this reform is just simply the right thing to do. Priya's parents advocated for these laws and met with the Prime Minister and Minister Rishworth after the introduction of the bill. And as Priya's mother told the Prime Minister, the law is in her name and now Priya will live on forever. In 2022, more than 3,000 families lost a child to stillbirth or within the first 28 days after birth. And after Priya's death, her parents have advocated to ensure that no other parent would ever have to face what they did. This bill honours Priya and her family. Priya and her parents have made a meaningful difference to the future of working parents in Australia, creating a legacy that will last forever and honour their little girl. Madam Deputy Speaker, over the decades, Australia's parental leave policies have seen significant developments, and all for the better. And these advancements reflect changes in societal norms and family structures. The campaign for a parental leave in Australia initially focused on maternity leave during the 1970s, a time when women's participation in the workforce was growing, but support for working mums was minimal. And the unions played a crucial role in advocating for paid maternity leave, arguing that women should not have to choose between motherhood and their careers. And my sons are now in their mid-20s, and I do still recall those dinner conversations of whether or not it made economic sense for me to go back to work or not, or for my husband to stay home and look after our kids. These decisions are still being made today, but we have had early wins in relation to leave, and they were modest, but they were often negotiated workplace by workplace and setting precedents for future policies. As societal expectations evolved, so did the demands from mothers and parents. And by the 1990s, there was a growing recognition of the need for policies that also supported fathers and non-birthing parents. And this led to the introduction of more inclusive family leave policies, recognising the diverse needs of modern Australian families. Unions across the country led the push for more inclusivity and won the right to parental leave for both parents, acknowledging their shared responsibility in child rearing and promoting gender equality in the home and in the workplace. The significant breakthrough in paid parental leave came with the introduction of the Paid Parental Leave Act in 2010. And this legislation provided for up to 18 weeks of government-funded parental paid leave at the national minimum wage, a substantial support for working families. And this policy really was a game changer, ensuring, or at least giving all eligible parents who could afford to take the time off work to care for their newborns without being unduly compromising their financial stability. It gave them the ability to make those decisions. In more recent years, we've seen further enhancements. These include the introduction of flexible leave options, allowing parents to split their leave into blocks and to return to work on a part-time basis. The extension of leave benefits to include adoptive parents and same-sex couples, and the recognition of important superannuation payments during leave periods. And Priya's bill will build on this. Madam Deputy Speaker, this bill is especially close to my heart. We've heard tonight of personal stories of fellow parliamentarians and how difficult their time in the workforce was. A very good friend of mine tragically lost their daughter within days after giving birth. And in my early years, quite some time ago, I was a radiographer and I had to work with many families who were coming to terms with the fact that their baby wasn't going to survive. These are really, really distressing times, and there are so many thoughts, so many emotions going on in our own minds. It's just impossible to make really, really important decisions. So Australia is one of the safest places in the world for a baby to be born, but we do know still that stillbirths and child loss does happen, and no parent should ever have to go through what Priya's mum and dad experienced, and that's what this bill will change. Madam Deputy Speaker, this bill
Member for Brisbane, I'm going to have to interrupt you. It being 7:30, I'm sorry. I propose the question that the House do now adjourn. And I call the member for... I call the member for Indi.
Thank you, Madam Deputy Speaker. Madam Deputy Speaker, Indi is home to a spectacular variety of precious flora and fauna that many locals volunteer to protect. Just last weekend, citizen scientists in the beautiful town of Rutherglen were out to spot the elusive platypus, and in July, determined locals participated in the annual Kinglake National Park Lyrebird Survey. The people of Indi often tell me how much they love and value the natural environment. Many who have recently moved to the region say a key factor in that decision to relocate was the natural beauty of Indi. We have a great responsibility to care for these precious places. I recently met with members of the Gecko Clan Community Landcare Network in Benalla who embody this responsibility. Gecko Clan supports 14 landcare groups from Yarrawonga through to Seymour, implementing network-scale projects to strengthen sustainable agriculture and biodiversity. With Gecko Clan, I visited Andrew and Jane's carbon-neutral beef farm, where I heard and saw firsthand from them and their son Mark their sustainable farming practices. Andrew and Jane's farm is one of many across Indi, revegetating parts of their land with native species, improving soil health and securing positive outcomes for nature and the future of agriculture. Because farmers know how to care for the environment and they want to take climate action. Andrew and Jane exemplify this, but many of them also tell me they need practical support on how to action this intent. That's why I fought and secured, that's why I fought for, actually, and secured $76.4 million in the 23-24 federal budget to establish a network of sustainable agriculture facilitators, SAFs, to deliver tangible support for farmers to adopt climate-smart agricultural practices. Because as the climate changes, we must equip rural industries with the knowledge and the resources to adapt and to protect nature at the same time. Energy security and the transition to clean energy are priorities for the people of Indi. Most rural Australians support renewables, and Indi leads Victoria in the uptake of household solar panels and in the installation, I'm proud to say, of home batteries under the Cheaper Home Batteries Scheme, a policy that originated right back home in Indi. And what has let communities down so far, though, Deputy Speaker, has been the lack of meaningful consultation in the broader energy transition. People need to know what's going on and why. We need to ensure that communities have a say in where projects are located, that they're in the right places and that they deliver substantial long-term economic benefits for those communities. We need clear best practice and minimum standards for community engagement and benefit sharing. Communities should be valued stakeholders and receive timely and transparent information with genuine avenues for addressing key community concerns. They also very much deserve long-term big benefits that meet community need and are commensurate with the vital role that regional communities host to in these large-scale renewable energy infrastructure projects. Now, these could be investments in telecommunications, childcare centres, reliable and cheaper power close to home, investments that make regional communities attractive places to live and to run a business. And, Deputy Speaker, I will continue in this place to advocate for strong community engagement and benefit sharing requirements from our renewable energy projects and our bigger energy transformation. We also need strong community engagement in our nature reforms. We are all about to see, for the first time, the full proposed changes to the Environment Protection and Biodiversity Conservation Act. The EPBC Act, as it currently stands, is indeed defective. Graham Samuel, who undertook an independent review of this Act, said that these laws are not working and called for fundamental reform. We know one element of this will include regional planning to identify no-go zones where it would be unacceptable to develop renewable energy. Regional mapping was my #1 recommendation to the Community Engagement Review, the Dyer Review. It gives certainty to business and regional communities, and we need similar attention in the reforms to the EPBC. We need to know how regional planning will intersect with state government renewable energy zones, and we need to ensure that our regional communities have a say, are engaged and truly have benefit.
The question is the House to now adjourn to get the call to the member for Richmond.
Thank you, Mr Speaker. Well, Mr Speaker, at the election in May, Australians endorsed the Albanese Labor government's plan to keep building Australia's future, including our ambitious plans to protect the environment and act on climate change. And indeed, my electorate of Richmond and the far north coast is known around the country and, in fact, around the world for our stunning natural environment, and protecting it is so vitally important. And of course, our region is also unfortunately known for devastating floods and really feeling the direct impact of climate change. So acting on climate change and striving to protect our environment are issues of great importance to my community. And indeed, Speaker, our government is acting on climate change whilst also harnessing the economic opportunities that the global shift to clean energy presents for our nation. We've accepted the Climate Change Authority's advice to set a 2035 target, cutting emissions by 62 to 70% compared to 2005 levels. This is ambitious but achievable. It sends the right message, the right investment signal, responds to science and is delivered with a practical plan. And we're committed to net zero by 2050, in contrast to those opposite who continue to debate the reality of climate change, endlessly debating that. The fact is, Australians voted for real action on climate change and our government is delivering it. And Speaker, since we were elected 3 years ago, Australia now has enough renewables to power 6 million homes, and we've helped industry cut emissions through the Safeguard mechanism, and we've delivered new vehicle emission standards, giving Australians more choice of cheaper to run cars. Our plan is working and emissions are coming down. And of course also the work to reform Australia's environmental laws isn't complete, and we've committed to reforming these laws to make them fit for purpose whilst taking real action on climate change and protecting the environment. And as part of this reform, we'll be introducing legislation to modernise our environmental laws and establish Australia's first ever independent federal environmental protection agency, or EPA. A federal EPA will be a tough cop on the beat with real teeth. Of course, last time we tried to create the federal EPA, The Greens, the Liberals and the Nationals all shamefully teamed up to block it in the Senate. Well, I call on this time to actually support it and to reflect upon the results of the election in terms of what people do want to see. They don't want protests, they want real action, and they endorse our real action when it comes to creating the EPA. And of course, Speaker, Australians are embracing clean energy, and the best example of this is our government's Cheaper Home Batteries program, which means cheaper, cleaner and more reliable energy. And to date, more than 100,000 batteries have been installed across the nation. And in my electorate, there's more than 1,000 homes, businesses and community groups who are now powered with cheaper batteries. For locals with existing solar, a typical battery could see savings of up to $1,100 a year on their energy bill. This program is working in our communities and right across the country. And indeed, Labor has a very strong track record of delivering for our environment, and we're working to stop species extinction by supporting the recovery of threatened species and ecological communities. This will help us to rebuild the populations of some of our most vulnerable species, to prevent further extinction and preserve biodiversity. And in my community on the North Coast, Labor is always taking strong action to better protect and recover our native wildlife. In fact, one of my commitments at the last election was that a re-elected Albanese Labor government would deliver $2 million to the expansion of the operations of the Byron Bay Wildlife Hospital. And it's a fantastic hospital that provides such important work, and it's treated approximately 7,000 native animals. And I was very pleased to announce and very pleased soon to be delivering on that commitment. I'd also like to commend the New South Wales Minns Labor government, who recently announced the proposed boundary for the Great Koala National Park, alongside a comprehensive plan to support workers, industry and local communities. And this plan will deliver the protection of our most precious koalas and more than 100 threatened species. The Great Koala National Park will create a vast network of protected areas, encompassing over 475,000 hectares from Kempsey to Grafton and inland to Ebor. Speaker, Labor is the party that delivers action on climate change, and in fact it's Labor who's delivered every single major environmental reform in our nation's history, and we proudly do that. Whether it's land care or saving the Franklin or protecting the Daintree in Kakadu, building the largest network of marine parks in the world, and of course meaningfully addressing the threat of climate change. Australians voted for us to take action when it comes to climate change, and we are doing that and building on that. They also voted for us to protect our natural environment, and we continue to do that every day.
The question is the House to now adjourn. I give the call to the honourable member for Flynn.
Thank you, Mr Speaker, and I rise to speak on an issue that is affecting every community in the electorate of Flynn, and that is the lack of housing. Vacancy rate in central Queensland is sitting at just 0.5%. Parts of the north and south Burnett are 0.1%. And this is having an effect on attracting skilled workers to the region. Rents are rising for families, pensioners and the disabled, and the opportunity for purchasing new homes for young Australians is getting much more difficult. But don't just take my word for it. A report released by the Master Builders Association of Australia in November 24 found the following results from a nationwide survey. 1 in 4 say housing is the most important issue for them, up from 8% in November 23. 90% say it's difficult to afford to buy or rent a property in Australia. 2 out of every 3 say the federal government is the most responsible for addressing the housing crisis. 70% are of a view that the federal government has not done enough to address the housing issue. 85% agree there is a shortage of housing in Australia. 7 in 10 say the housing crisis is damaging the quality of their life in their communities. 7 in 10 say the housing crisis has gotten worse over the last 12 months. 86% of renters who want to buy a home fear they won't achieve it within the next 5 years. 39% have struggled to pay their rent or mortgage in the last 12 months. Now, while there is no silver bullet to alleviate the housing crisis, the simple fact is that supply is not keeping up with demand. While the Labor government has set an ambitious goal of 1.2 million homes in 5 years, recent data has shown that not one state achieved the first-year target for housing completions, with my home state of Queensland falling 6% short of the 20% target.
The building trends in general across the country also seem to be going backwards. The latest release of building activity in Australia, according to the Australian Bureau of Statistics, has provided the following key statistics for the last quarter. The total number of dwelling units commenced fell 4.4% to 45,165 dwellings. New private sector house commencements fell 6.6% to 26,074 dwellings. The value of total building work done fell 0.3% to 38.9 billion. For the 3 years and for the 3.5 years, Labor has been building bureaucracies and not homes. Labor's housing ideas are costing taxpayers $60 billion, yet they are building fewer homes than the former government. Mr Speaker, there is not one single factor that is contributing to the housing crisis. Reasons include labour and material shortages, red tape and restrictive planning, zoning laws and, of course, the government's policies. However, one issue that the Labor government refuses to acknowledge that is contributing to the housing crisis is the level of immigration into this country. Australia welcomed 380,000 net permanent and long-term arrivals over the first 8 months of 2025, the highest volume for this period of a year ever recorded. That is just the first 8 months of this year. Meanwhile, according to the Australian Bureau of Statistics, just over 150,000 new homes were built in this country during the 2023-2024 financial year. Figures from the ABS also reveal over 2.5 million immigrants came to Australia over the last 5 years. 667,000 immigrants came to Australia in 2023-2024 alone. While it is fundamental that we attract skilled immigration to this country, unsustainable immigration levels are not being addressed or even reviewed by this government. Since the year 2000, it is estimated that Australia's immigrant population has more than doubled, 103%, while the number of housing units has increased only 54%. Mr Speaker, there is no doubt that all levels of government must come together to alleviate the housing crisis. Local and state governments can do their bit by unlocking more land and cutting regulation and encouraging investment. And the federal government must do its bit by immediately reducing immigration levels that are sustainable for our future.
The question is the House to now adjourn and give the call to the member for Banks.
Thank you, Mr Speaker. I rise to speak about the Labor government's ambitious reforms to superannuation and to deliver fairer outcomes for all Australians. The Treasury Laws Amendment Payday Superannuation Bill will deliver a once-in-a-generation reform to tackle the issue of unpaid superannuation, which cost workers in the financial year 2021 to 2022 more than $5 billion alone, according to the Australian Tax Office estimates. In a typical ATO investigation of cases of unpaid super, a worker has missed out on nearly 2 years' worth of contributions. These statistics demonstrate that while super going unpaid is not necessarily malicious on the part of the employer, they are resultant from systematic issues with payroll and related systems. While these incidents impact all employees, for young workers, the impact on their retirement savings is incredible. When a young worker loses superannuation contributions early in their career, they aren't just losing money, they are also losing the benefits of years of compounding interest. For the average 35-year-old, failing to recover the contributions they are rightfully owed reduces their overall savings in retirement by $32,000 in today's money. In addition, when an employer goes out of business, the impact is even more severe. The same 35-year-old worker's retirement balance would be a whopping $90,000 worse off in today's money. The Payday Superannuation Bill will require superannuation contributions to be paid at the same time as wages, instead of a quarterly one from the 1st of July 2026. This will make it easier for employees to track their super balances, remove the uncertainty of whether sufficient super has been paid, and make it easier for the ATO to track missed payments before debts become unrecoverable. Further, the legislation updates the superannuation guarantee charge to bring the penalties employers face for failing to pay on time, ensuring that if for some reason the employers needed any incentive to do the right thing, they certainly have one now. The ATO will use single-touch payroll data, which is already reported, and match it to detect payments in near real time. Mr. Speaker, these changes are so important for protecting the integrity of our superannuation system. We know employers need time to make sure they are ready to get things up and running for the 1st of July and to get it implemented, and we are working with them across the country to do so. Mr. Speaker, the reforms set out in the payday superannuation bill are coupled with changes announced to the low-income superannuation tax offset to deliver more help to workers who need it the most in our communities. The government will be introducing legislation to increase the offset by $310 to $810 and raise the eligibility cutoff from $37,000 to $45,000 from the 1st of July 2027. This boost to the listo will help top up the super of low-income workers and ensure their contributions are taxed at a lower rate than the rest of their income, aligning it with the timing of the government's 3rd round of tax cuts, taking effect at the start of the 2027-2028 financial year. This change will benefit all workers with incomes between $28,000 and $45,000. This will make 770,000 more workers eligible for the offset, and another 500,000 people will see their payments increase. The ultimate function of the listo changes is to enable low-income workers to enjoy a more secure and dignified retirement, and this will make it a reality for 1.3 million Australians, including many thousands of working people in my electorate of banks who will see the benefits of this legislation. Mr. Speaker, not everyone in this place sees superannuation the same way. Those opposite treat superannuation as a solution to the problems created by their mismanagement of the economy. Most recently, of course, instead of forming a decent housing policy agenda, the coalition settled on telling young people to rob their futures by raiding their superannuation funds. This government, however, knows that building compulsory superannuation, as we did in the past, is so important to working people to ensure that they're enjoying dignity in their retirement. And we are getting on with building an economy and ensuring that jobs are stronger, fairer, and that we have a sustainable superannuation system. Thank you.
The question is the House to now adjourn. Give the call to the member for Wright.
Thank you, Mr. Speaker, and nothing will light my phone up in the electorate more so when the largest contributor to GDP is agriculture, and my farmers and my growers rely heavily on making decisions on a daily basis than when the Bureau of Meteorology fails them. And I feel it incumbent on me, Mr. Speaker, to come into the House tonight and share with the Parliament a number of concerns that have lit up my text box. And I will be most respectful of the House to remove the expletives from their contributions when they share with me about the failings of the Bureau of Meteorology's technical upgrade. Now, I don't suggest for a moment that the Bureau of Meteorology have done anything with a level of intent to upset my people, but tonight you need to know they are upset. They are disappointed. They make their business decisions based on the 24-hour information that's available to them, whether or not it's to shift cattle from one paddock to another, their growing seasons, whether or not because they'll buy seedlings in the planting season. They will want to make sure that they don't put seedlings out just before a major rain event where they get flooded out. It is a valuable tool. And to be absolutely transparent, Mr. Speaker, the Bureau of Meteorology has been a constant friend and ally of my agricultural sector. It has been something that they have relied on, and the disappointment in the lack of consultation, the changes without notice has been disrupted to the point that has got me to my feet to raise this as a concern. In front of me, Mr Speaker, I have an image of the old radar and an image of the new radar. And I've provided the House and the Speaker with an image of it, but I need to explain this just for the benefit of Hansard. The radar image is consistent of a number of coloured images, and the coloured images reflect the rainfall potential. And underneath that coloured image there is a series of towns where the water levels are expected to land. The new images, 2/3 of the towns are missing. It's only the major portions. So when someone is looking to irrigate a paddock or make a decision on a 100-acre paddock, and the nearest reference point that they would have usually used is a town reference point, and that is no longer on the map, and the closest reference point, if they are in the Lockyer Valley, is Ipswich, that, Mr Speaker, is problematic. I am not seeking to come here to grandstand. I am seeking here tonight to encourage the Bureau of Meteorology to reconsider some of the changes that have been made and to start some sense of consultation with the people who are going to be affected. I'm going to share two texts, the ones that I can read into Hansard, from different growers. One, and I hope this gives some context. The first one was, the problem is, because I said, yeah, they blew up, and they said, what's wrong? The Bureau's mucking us around. And I said, send me a text, tell me what's wrong. The problem is that it's not user-friendly. If a storm was coming when the old system was in place, you could go to BOM, Queensland, Marburg, and you'd have the image. Then you'd go out 256 kilometres to see what rain was behind it. The radar images now are not clear. They're more difficult to zero in on. The biggest issue I see is that the new system seems to want to highlight warnings and climate change issues at the expense of excellent management tools that it has been. So we've got growers that are actually commenting in their scathing report of the Bureau of Meteorology and asking them to reconsider. The second one was that the BOM site is, and there's the expletive, but for the benefit of Hansard, and for the forecasting and the radaring, it's not as comprehensive as the old site, especially with the districts. So again, more compliments of the old BOM. Very difficult to navigate, and I really don't have 4 hours of my life to waste time on how to navigate it. And God help the older generation. It's actually a safety concern for the people, especially in the storm season, which is when we experienced what we experienced in the last couple of days. Seems like the computer nerds left in charge out practically to put in a new system. I actually have gone to Willie's weather system.
The member's time has expired. The question is the House to now adjourn. I give the call to the member for Barton.
Yeah. Thank you, Speaker. Tonight I rise to deliver Poppy's speech, and I want to read it in full first before I make some remarks of my own. At my school, a chaplain implied my relationship with a girl was sinful. If anyone dares to put a rainbow flag on their locker, it's torn down. At my friend's Catholic school, students were told that gender-diverse people are mentally ill. And that's just the start of it. Private and independent schools in New South Wales are all but exempt from the LGBTQ+ anti-discrimination laws. They argue that it's because of religious freedom. But when 39% of the LGBTQ+ youth considered suicide last year, and over half self-harm, it's become more than a matter of faith. It's become an issue of survival. So what steps should the government take today to build a better tomorrow for young, particularly LGBTQ+ Australians? The first step they need to take is fixing anti-discrimination legislation. while the New South Wales Anti-Discrimination Act is being reviewed. Change isn't happening fast enough. Queer students need help now. No school should be allowed to discriminate, whether that be what I've experienced or so much worse. The government has a responsibility to ensure that stories of homophobia like these are just stories, not realities, so that thousands of queer students don't become just another statistics. Now, Poppy sent this speech in as part of the Raise Your Voice initiative. I was struck by it when I read it, and I empathised with it. Now, quite a few people know about this personally, but I've always held the Holy Mother of God, Mother Mary, close to my heart and my Catholic faith. I wore a medallion of her around my neck to keep her near and keep me safe when I was in high school. I remember being ordered to take it off when I was at school because it didn't align to the school policy. My principles and beliefs felt outcast and rejected. And in the similar vein, Poppy has felt outcast and rejected because of who she loves. That just doesn't make sense to me. Of course, schools should be able to teach their faith and their values, but in turn, students should be able to express themselves and live their values too. Yeah. For me, it comes down to one Jesus commandment that I think about quite a lot. Love one another as I have loved you. We are all deserving of love, we're all deserving of respect, and we're all deserving of dignity. This is a principle that underlies all religion, and I like to think our democracy as well. And it should also extend to schools. Now, I want to thank Poppy for sharing your experience with me and also this House and this Parliament. To us, you will never be another statistic. You and all members of the LGBTQ+ community are absolutely loved and you're always welcome here. Thank you, Speaker.
It being 8 p.m, the House stands adjourned until 9 a.m. tomorrow.
Thank you, everyone.